Good morning. Welcome to the board meeting of the Osteopathic Medical Board of California. This meeting is being held on May 11th, 2023, and the time is 10:05 in the morning. This meeting is occurring at the Department of Consumer Affairs hearing room located at 1625 North Market Boulevard, Sacramento, California, 95834. Today's meeting will be conducted using the following guidelines. All participants will mute their microphone or phone during each presentation of the agenda topic. Board members who wish to provide additional comments should select the raise hand feature next to their name, as if you're on a webcast. This will alert the host and chair you have additional comments. At the conclusion of discussion from board members, I will ask for public comment. At the conclusion of the discussion period, I will call for a vote if necessary or move on to the next agenda item. At the conclusion, all in attendance should keep their comments specific to the agenda item being discussed. An opportunity for public comment for items not on the agenda will be provided. Please be advised that during this comment period, the board cannot engage in discussions or take action on any matter that is raised, except to decide whether to place the matter on the agenda of a future meeting. Okay, we'll move on to agenda item number 2 and establish a quorum, the roll call. Machiko, will you call the roll, please?
Good morning. Gore Damian.
Here.
Cyrus Buhari.
Here.
Michael Kim. Andrew Marino.
Good morning. Here.
Elizabeth Jensen. Hamesh Patel.
Here.
Claudia Mercado. Denise Pines.
Present.
You have a quorum.
Thank you. We'll now, Dr. Jensen did not answer, right? Okay. Do you want to skip the 3?
You can have someone else read it.
Okay. Okay, so agenda item number 3, we move on, is reading of the board's mission statement. Dr. Jensen was originally set to do it. I don't know who you want to have do it, Erica.
I can go ahead.
Sure.
Good morning. The mission of the Osteopathic Medical Board of California is to protect consumers and promote the highest professional standards in the practice of osteopathic medicine. The Osteopathic Medical Board of California licenses osteopathic physicians and surgeons. The board investigates consumer complaints and uses its enforcement power to ensure practitioners abide by the provisions of the State Business and Professions Code Medical Board Practice Act. To maintain their license, practitioners must successfully complete rigorous, periodic, continuing education requirements that meet the standards of the American Osteopathic Association.
All right, thank you, Ms. Calderon. Item number 4, meeting and public comment procedures. Agenda item number 4. So public comment on items not on the agenda. During the meeting today, public comment is welcome on any agenda item as the item is taken up by the board. Under the Open Meetings Act, the board may not take action on issues raised by public comment that are not on the agenda, other than to decide whether to schedule that issue for a future meeting. In order to allow the board sufficient time to conduct its scheduled business, the board will limit the time given to each person to 3 minutes. It is not necessary to repeat statements or views of a previous speaker. It is sufficient to state that you agree. As a reminder, please do not disclose details of any active enforcement case or licensing matter. as this may compromise the board's ability to hear the case at a later date. The board appreciates your cooperation and assistance in meeting its legal mandate. At this time, are there any public comments on items not on the agenda? Moderator, is there anyone requesting to public comment?
Thank you, Mr. Board President. Usually the order is any public comment in person, and then we
Okay.
go to the WebEx people.
Okay. Any members of the public wish to comment who are present? I see none, so we'll move to the WebEx.
Thank you, Mr.
Moderator,
Board.
is there anyone?
Thank you. I've opened up the question and answer panel, and if any member of the public would like to comment, they may type comment using the field in the lower right-hand corner of the screen and submit it to all panelists, or simply raise their hand. We're displaying instructions, and we'll give them a moment. All right, I see no request for public comment. Shall I close the question and answer panel?
Yes, please.
Okay.
Thank you. We will move on to agenda item number 5, which is review and possible approval of the last meeting's minutes. This was a January 2023 conference and teleconference. Did everybody have a chance to review the minutes? And if so, any discussion by the board members? And if they've been reviewed, if we could have a motion to approve in a second.
I can make a motion to approve the minutes.
Second.
It has been moved and seconded. Moderator, is there anyone, is there anyone in the present, a public member who wishes to comment? I see none. Moderator, can we ask members on WebEx?
Thank you. I've opened up the question and answer panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of the screen, or simply raise your hand for displaying instructions, and we'll give you a moment. All right, I see no request for comment. Shall I close the Q&A panel?
Yes, please. Thank you.
Okay, you're welcome.
Okay. Machiko, we'll have you do a roll call vote.
Gore Damian.
Aye.
Dr. Buhari.
Aye.
Andrew Marino. Dr. Patel.
Aye.
Denise Pines. Aye.
Thank you. We will move on to the President's report. I don't have very much to discuss. We just got back from the Federation of State Medical Boards annual meeting, and you'll hear from Dr. Chowdhury, who is going to make a presentation on something that was discussed there. Erica and Machiko and I had attended the OPSC meeting in San Diego earlier this year, their CME event, which was very, very nice, and they did a lot of advertising and a lot of work for the board, and I thought that was commendable. Other than that, we have one item which we have to wait for one member to show up before we go through that, and we'll come back to that at some point. Any members of the public wish to comment on my very brief President's report? I see none present. Moderator?
Thank you, Mr. Board President. I am opening up the Q&A panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of the screen, or simply raise your hand. We'll give you a moment. All right, I see no request for comment. Shall I close the Q&A panel?
Yes, please. Thank you.
Oh, you're welcome.
All right, we're moving along. So we'll move on to item number 7 on the agenda, which is the presentation by Dr. Humayun or Hank Chowdhury on the Interstate Licensing Compact. Dr. Chowdhury is the president and CEO of the Federation of State Medical Boards and has captained that ship for many years, and it's our honor to have him at our meeting today to make this presentation.
Thank you very much, Dr. Bahari. May I ask if I'm to share the slides or if staff will be sharing the slides and advancing for me?
I can advance the slides for you, Dr. Chowdhury.
Great, thank you so much. Before I begin, let me, if I may, make 3 quick acknowledgements. One, I'd like to recognize and thank Dr. Bahari for his excellent leadership of this Osteopathic Medical Board of California. We greatly appreciate his attendance and engagement with the FSMB at the national level. I think California has a lot to share with the rest of the country, and we value all of your input and your staff throughout the meeting. Second, I'd like to recognize and acknowledge Denise Pines, who Ms. Pines, as you may know, serves on our FSMB Board of Directors, and she has been very insightful and helpful to us in getting a broader view of the issues that are impacting the residents of California, and of course the rest of the country in terms of offering input and guidance for recommendations that we make from time to time for state medical boards to consider. And third, I'd like to bring greetings from our new chair, Dr. Jeffrey Carter, who is a anesthesiologist from Missouri who just became chair just a few days ago at our meeting in Minneapolis. So with that as an introduction, let me jump right in. I hope to one day visit your board, as I've done before some years ago, but I was asked to specifically come and talk about the Interstate Medical Licensure Compact. There's also a PA Licensure Compact that is newer that I will talk about, and I'm happy to take any questions at the end. Next slide, please. Next slide, please. Thank you. So just a quick background about the FSMB. The FSMB was founded in 1912 by the nation state licensing board. So we do represent all of the state and territorial medical and osteopathic licensing boards in the United States. We have our primary headquarters are in Euless, Texas, just outside of Dallas. We also have a Washington, D.C. advocacy office. We have about 170 full-time employees who provide a variety of services to our nation state licensing boards. Next slide, please. Just briefly, since you just went over your mission, I'll share that our mission as an organization nationally is to support all of you, not only the boards, but those who serve on the boards and those who support the boards on staff as you protect the public and promote quality healthcare. Our mission is to help through education, assessment, data, research, advocacy, and various services that we provide. The Interstate Medical Licensure Compact is something that we helped facilitate the state boards to create, but it is not something we created. It is not the FSMB's service, if you will, though we are happy to support it. I think it's clear to point out that the way that state medical or state licensing compacts work is that the states have to run them, they have to create them. But I'll give you more detail in a moment. Next slide, please. So this is a quick overview of the Interstate Medical Licensure Compact, and then I'll go over a little more detail. A lot has happened in the last 10 years since we first convened a meeting of licensing boards who were interested in advancing licensure portability and enabling greater access to care for our nation's residents in a way that did not disenfranchise any of the state licensing boards or their ability to license and discipline doctors. Through those conversations in early January 2013, one of the ideas that gained some traction was the notion of an interstate compact. Those of you who may be attorneys in the audience may have a better familiarity with interstate compacts. They've been around since the nation was founded, but they were relatively new to the medical profession. There was a nursing compact that had been around for any number of years, but every compact is different. But we knew that it's not an entirely new instrument, and when we talked to various state governors and state legislatures, they seem very familiar with the notion and the concept of it. And so in April of 2013, Wyoming, the medical board in Wyoming was the first state to offer a resolution to our House of Delegates to enable a conversation that could lead to an interstate compact. Well, by a few months later, we created a drafting team, completed a final draft of what that service should look like. And the reason that process was so important was the way the interstate compacts work is once you delineate the specific requirements that you want and the processes, it pretty much cannot be changed. And it has to then go to each of the state governments around the country or the territorial governments to sign off on. States can't modify the legislation once it's drafted. And so we were very careful about dotting our I's, crossing the T's, making sure the semicolons are in the right place, and of course that the words are in the right place. But it was launched in 2014, and we didn't really know if it would gain traction. But by May of 2015, we had 7 states. We had decided, the states had decided early on that if you can get 7 states to be interested, then we should formally activate it. That seemed sensible. We worked with a number of organizations that have some experience with interstate compacts. The Council of State Governments, CSG, was very helpful. And by October of 2015, because we had 7+ states by then, the Interstate Medical Licensure Compact Commission was formulated and inaugurated. And the commission is made up of representatives of the participating states. And then in 2017, only 6 years ago, the Interstate Compact Commission began processing applications. And that's really what the role of the Interstate Compact is. It's an expedited pathway to enable individuals, physicians who are qualified, to become licensed to practice medicine, but that license is issued by the states. And the state medical boards. So it doesn't create a compact license. So I think early on we had to do a lot of explaining to explain what it is and what it isn't. But fast forward to March of 2023, we've now processed 39,000 applications by physicians, and the state boards who are participants have issued more than 60,000 licenses to enable the practice of medicine lawfully in their jurisdictions. Next slide, please. So this is what the map looked like. In the end of 2015, there were 10 states, so many more than 7 by the end of 2015. And I'll fast forward to what the map looks like today. Next slide, please. So all the states in dark blue have formally studied the compact, discussed it at their legislatures, gone through their committees and their various assemblies and senates, and ultimately had this licensure compact signed into law by their governor. So all the states in dark blue, there are 37 of them, have now done that. The states in light blue are the states where compact legislation has been introduced, but has not been formally adopted yet. I can tell you that the most likely next 2 states will be Missouri and Hawaii. I know this because it has made it out of the committees, it has made it out of the legislature, and is essentially just waiting for the governor's signature. So maybe perhaps by next week, we may have 39 states that have formally adopted the compact and others who are thinking about it, considering it, and so forth. Next slide, please. So as an overview, I should mention, the map is the same. I should mention that this is a voluntary expedited pathway. In other words, if you're a physician and you are deemed to be eligible for this expedited pathway, you can theoretically get licensed in all the jurisdictions in the participating states instantly, because that's the way the language of the compact is structured. But it's voluntary. You don't have to do it. I often get asked by physicians, well, I already have a license in my state. Do I need to go through the licensure compact to get another one? No, you don't. This is an option. It's another pathway. It's kind of like a TSA pre-check, because the criteria are a little bit more stringent than what is traditionally in place for most state boards. But if you meet those criteria, which the states discussed and agreed upon, the notion is that you can practice in all of these states if you wanted to, whether in person or by telemedicine. At one point in our process, we wondered if the Interstate Compact should only be used for telemedicine purposes. This is way before the pandemic, but the state board executive directors and chairs around the table said, well, you know what, if we're going to be issuing a license to practice medicine thoughtfully to qualified physicians, then why limit it to telemedicine? Why not allow them to practice in person if they want to, if they're able to? Because many physicians practice in border states where, or they're very close to a state border, and they like to be able to practice in multiple states, for example. And if you look at a state like Kentucky, it has several states around it. So you can see the value in states that have adjoining states where sometimes patients are moving back and forth between those states. Next slide, please. So what are the criteria? I'll tell you in confidence, well, not confidence, but I'll share with you, this is an open meeting, that when we first started this conversation about what should be the criteria by which physicians could be eligible for multiple licenses pretty much instantly, there was a lot of thought went into what those requirements should be. Typically a licensure application in any state or territory has sometimes more than 100 questions. And so obviously we didn't, it didn't make sense to have all of those questions. So we narrowed it down as best we could and ultimately settled on 9 criteria. And I'm not going to read each of the criteria in the interest of time, but they're pretty straightforward. Graduation from an accredited medical school, passing of the licensure exams, whether it's the USMLE or the COMLEX or any of its predecessor exams, within 3 attempts for each of the steps. Completion of GME. Now that's new. Right now, as you know, there's not a single licensing board that requires completion of an ACGME or AOA residency to get licensed, but this pathway does, because it wanted to give this ability to get multiple licenses to people who are not just qualified in any state, but qualified enough to be safe to practice medicine and safe for the patients across any state. And so the state board said, well, if we're going to do this, if we're going to make licensure easy to get, we want to make sure that those who are getting these additional licenses are at the peak of their abilities. And so completion of residency was added to the criteria, but so was holding specialty certification or a time unlimited specialty certificate, otherwise known as a grandfather certificate, that is recognized by either the American Board of Medical Specialties or the American Osteopathic Association's Bureau of Osteopathic Specialists. I should mention this is at the time of application. So if you're a physician, your state has the interstate compact, and you want to apply to, I don't know, 5, 10, maybe 39 states, you can do that, but you have to demonstrate that you either are grandfathered for specialty certification, or at the time that you are pursuing these multiple licenses, that you are specially certified. Once you get those licenses, however, none of the states will require you to maintain that specialty certification. As a reminder, specialty certification is not traditionally a requirement for licensure, but for the compact, it is for the initial application. And that's a key point, because sometimes physicians have misconstrued this and said, oh, well, I'm not eligible because I'm not board certified. Well, if you're grandfathered, you actually might be. But once you get this, you don't have to maintain your certification either. So I think that's a key distinction that sometimes gets lost in the discussions. Possessing a full and unrestricted license to practice in a member state. So you do have to have one legitimate license from a legitimate entity obtained the ordinary way. But once you have that, you're eligible for this. Obviously, no criminal history, and there is an FBI background check that's required. No disciplinary action by a licensing agency, and have never had a controlled substance license or permit suspended or revoked by the DEA. And finally, that you pledge that you are not under active investigation by any licensing agency or law enforcement authority in the United States or elsewhere. Obviously, this is a summary. There are a lot more details to each of these eligibility requirements. Next slide. And actually, could you go back one slide? There's a key point I wanted to make. If you look at the very top line, now you might wonder, how many physicians would actually be able to meet these 9 criteria? Well, the FSMB, as Dr. Bohari and Ms. Pines know, has a comprehensive data set on every single licensed physician in America. And we know where they went to medical school, when they graduated, whether or not they finished their residency, and if so, in which specialty. We know if they're specialty certified, we know where they live, et cetera. An estimated 83% of licensed physicians, according to the FSME, would be eligible to get multiple licenses through this pathway if the state of California were to adopt it, for example. And the number may be slightly different. It might be 82 or 84. I'd have to look at the numbers specifically for California physicians, but nationally, 83% of physicians are actually eligible. Now, what about the 17% who are not? Is this disenfranchising them? Well, the state boards would argue that the 17% who don't meet any of these 9 criteria for whatever reason, maybe they took 4 attempts to pass a licensing exam, maybe they maybe they finished their residency but did not become specially certified, for example, or maybe they've had a minor disciplinary action at some point. There could be any number of reasons. This doesn't completely disenfranchise them because those individuals are more than welcome to apply to as many licenses as they want through the normal means, which is essentially one state at a time, and you have to go through each process. But if you happen to meet these 9 criteria and you want more than one license, this pathway could be an option for you to consider because it's pretty fast, pretty expedited. Next slide, please. We didn't know how the House of Medicine, the leaders in medicine, would respond necessarily to the compact because it's really for individual physicians and the licensing entities. But one of the organizations, the Coalition for Physician Accountability, which has been around for about 10 years, this is our last meeting back in November, is made up of the CEOs and chairs of all of the national medical organizations that are involved in the licensing, certification, education, assessment, and accreditation of physicians. It includes the American Medical Association, it includes the American Osteopathic Association, it includes the Council of Medical Specialty Societies. I need more time to go over each of the 14 or so organizations that are represented in this photograph, but by and large, the coalition is supportive because it's a way to protect the public, enable physicians to practice in multiple jurisdictions thoughtfully and lawfully, protect the public because the state boards that issue these licenses can still have the right to take away those licenses through their disciplinary actions, and is a way to stave off, for example, national licensure. The Federation has long argued, as our members have, that the state boards may be not as nimble as everyone likes in terms of getting things done in terms of licensure, but that doesn't mean you should throw away the state licensing boards and have a national licensure. So it's nice to have the support of most leaders of the House of Medicine. Next slide. And just to bring home that point, the Federation, just like state boards, we don't always agree with everything that our organizations that are involved in representing physicians and looking out for their rights. We don't always see eye to eye on every issue, but we do have a cordial relation. So this is me and our chair from this past year, Dr. Trikanda, meeting with Jack Resnick, the AMA president. Next slide. We also have a good working relationship with the American Osteopathic Association. This is Dr. Trikanda and myself meeting with Dr. Ernie Gelb, who many of you know is the current president of the AOA. Next slide. Now, what about the cost? Is there a cost? Well, when you talk about something that's expedited, chances are there is a fee involved, and there is. The Interstate Medical Licensure Compacts Commission, that's not the FSMB, that's the states that actually run the compact. They decided early on that there should be a fee charge for the work involved. So, for example, there is a $700 fee at the time of the application. This is what the states that are participants in the Interstate Compact have agreed to. $300 of that fee is paid to the state of principal licensure. The state of principal licensure is the state where the doctor who is entering this pathway, this expedited pathway, that's the state where the physician is principally licensed. Now the physician may have multiple licenses, but this is where you're principally licensed, where you spend most of your time. And if that's not clear because you're working in multiple jurisdictions, it's where you file your taxes for your state income taxes. So $300 would go to the state of principal licensure because that $300 fee involves checking your credentials against those 9 criteria that I outlined, which makes sense. If you're going to be eligible for a pathway, someone has to figure out whether you meet those criteria, and that's what that $300 fee is. So in addition, there's a $400 fee to the Interstate Medical Licensure Compact Commission, which is charged with processing all of these sort of credentials and making sure that everything is in place. Now, in addition to the $700 fee at the time of application, there's also the fee for each state license. So we caution doctors, before you jump and apply for 37 licenses, recognize that there is a fee attached to each license. The fee is not to enrich the coffers of the states. The fee is designed, as you all well know, to support the mission of the state boards to protect the public. The fee allows some of the processing that's required for the Interstate Medical Licensure Compact if it's implemented. The fee enables, of course, as you know, support for having staff, having investigators, making sure there's due process, making sure complaints by consumers are followed up. So we sometimes have to do a little education about why the states are charging a fee for their license. But don't forget, in this compact, the states are issuing the license. So those fees go through the state, and the state can set whatever fee they would like. Now, over time, as more physicians take advantage of getting multiple licenses, if they want, through this compact, the states may, through economies of scale, determine that maybe they don't need to charge as much as they do, and they may modify those fees a bit. That's entirely up to the states. It is not up to the FSMB. It is not up to physicians. It's not up to the AMA or the AOA. But there is a genuine hope of the Interstate Medical Licensure Compact Commission that at some point, as the processes become more smoother over time, that the fees could moderate to lower levels than they are right now. Right now, in most states, they're about the same fee as you would charge for a traditional license. But again, remember, physicians aren't, from what we've done in the surveys of physicians who go through this, they're not doing this, just to simply get a license. They're doing it because they want to practice medicine. They're less worried about the cost and they're very pleased with how quickly this occurs. Because literally, once you meet the 9 criteria, the state of principal licensure issues a certificate that is good for a year that allows you to apply to as many licenses as you want through that pathway. And if you literally ticked off that you wanted 37 additional licenses, the way the law is set up in this compact, each of those states is obligated to issue that license instantly. Now, that's pretty radical if you think about it, but it's good for doctors, it's good for patients, and it's good for the state licensing boards who retain the ability to monitor and control and oversee the licensure and discipline process. And of course, they're members of the Interstate Compact Commission as well. Next slide, please. So speaking of the commission, the Interstate Medical Licensure Compact Commission is the governing body that oversees this particular Interstate Medical Licensure Compact. There are many interstate compacts around the country. There is usually a commission that runs it. It's usually not a private entity. In fact, the law says it cannot be a private entity. It has to be the states that are legally involved in this. So each compact member state, once they become a member, is allowed to have 2 commissioners. They also have elected officers, they have appointed committees, they've hired an executive director through some of their fees to sort of manage some of their meetings. The first meeting began in October 2015. The Compact Commission is permitted by law to accept federal or private grants to fund and support its operations. So the good news there is there have been some federal grants from the Department of Health and Human Services and HRSA specifically. Typically, what the FSMB has offered is, since we have a history in applying for grants, the FSMB, at the request of the Interstate Compact Commission, has applied for these grants and gotten those monies and essentially given them to the Compact Commission to ease some of their workload, to enable them to hire staffing, to enable them, for example, to have these meetings. So again, the very first license was issued in April of 2017 through this expedited pathway. And this slide is already a little bit old. It says as of April 1st, 60,707 licenses have been issued. I have more recent data. As of May the 1st of this year, I can tell you that number is now 63,000 licenses have now been issued. So every month, there are about 2,500 licenses being issued by the state licensing boards through this expedited pathway. Next slide. And I think I'm finishing up my presentation, Dr. Buhari, and then I'd be happy to take any questions from you, the board, or the members of the public, or anyone else as appropriate. There was a significant meeting that occurred late last year, November 7th through the 8th, of the Interstate Medical Licensure Compact Commission. It was their annual meeting, and this was a meeting that included a rulemaking hearing to change one of its statutes, one of its processes. Now, remember I said that once the compact was adopted, you really can't change anything. If you change something substantive, that requires essentially going back to all the states and having them look at it, which is not easy to do when you have 37 states. But if it's a relatively minor adjustment, and the relatively minor is open to interpretation, but if the commission members are supportive, you can make minor modifications. So on this date last year, there was a significant modification made that I need to share with you, because when the compact was created, because the states were a little bit nervous or anxious about giving the ability to practice medicine to potentially thousands of physicians who are qualified, they were a little worried about what would happen if one of those physicians became disciplined. Because as you currently know, when a complaint is filed against a physician with a state licensing board, there is a process. The process takes time. The physician may be licensed in other jurisdictions. Usually, the fact that there's a complaint against a physician usually is not shared in most other jurisdictions where the physician is licensed, unless there's an action taken. There was some real concern in the state licensing boards that if a complaint is filed and the process just takes too long, and someone is licensed in 37 jurisdictions and has their license revoked, that it might take quite a lot of time for the system to do its job of protecting the public. And so a provision was added that when a complaint is filed against a physician who has multiple licenses through this compact commission, that complaint information, number one, would be shared. Number two, that if the state of principal licensure makes a disciplinary action decision, all the other states would automatically take that same action. So in other words, let's say California adopts this law, this legislation for the Interstate Compact Commission, and a physician gets disciplined, goes through the process, gets a complaint, and you decide at the end of the day to revoke that license permanently. That information would require, under the original statutes of the Compact Commission, for all other licenses obtained through the compact by that physician to also be instantly revoked. The reason this particular meeting late last year was so important was following the Dobbs decision at the Supreme Court, we are beginning to see some interesting situations beginning to emerge. And if they haven't fully emerged, they may emerge. And so the states brought this issue to the commission and said, we need to revisit that requirement that we have. And so through a vote, the Interstate Medical Compact Commission made an important vote, and this passed. The amended Rule 6.5 says that regarding disciplinary action says that this will be changed to that any disciplinary action by a disciplinary board shall be considered unprofessional conduct and may be a basis for discipline by other member boards, rather than the original language that said that is subject to discipline by other member boards. That addition of the word may enabled some flexibility so that if a state board decided to revoke a license for whatever reason it deems necessary, another state in the compact is not automatically obligated to do that. It may do that after reviewing the situation, or it may not. So that kind of flexibility was built in, to be honest, after the Dobbs decision. And then Rule 6.6, state authority regarding disciplinary actions, to go along with that, says that a member board authorized or required to impose an automatic licensing action against a compact physician under the Interstate Compact statute may immediately terminate, reverse, or rescind such automatic action pursuant to the Medical Practice Act of that state. In other words, making sure that the state's Medical Practice Act also is acknowledged and recognized within the rulemaking and rules and procedures of the Interstate Medical Licensure Compact Commission. Next slide. Briefly, there is a PA licensure compact for physician assistants. You can see that the organizations that are involved in helping interested state medical boards become part of it. It is a project funded through a grant under the Licensure Portability Grant from HRSA, again, the Health and Human Services. I'm sometimes asked, Hank, are you disappointed that all 50 states aren't part of the Interstate Compact? And my answer is, no, it doesn't work that way. If the states want to adopt the Interstate Compact, that's wonderful, and we're happy to help them implement that. But if they don't, that's up to them. We don't tell the states what to do at the Federation. We support them. We want to make sure you make informed decisions about various issues. And a lot of these, sometimes it's not up to the state boards, it's up to the state legislatures and ultimately the governor. We're happy to support those state boards that are involved in these kinds of ventures. Next slide. So the PA Compact is relatively new. There's only one state that has adopted it thus far, because again, it's new. And that state was Utah. There are at least, it says 3 states, but there are actually 4 states, maybe maybe 5 or 6 that where legislation is beginning to be pending to discuss it. And again, I'm not here to talk about the PA licensure compact. It is different than the medical licensure compact. But if you wanted more information about that, I'm happy to arrange another time for my colleagues in the PA community who can certainly talk about that. Each of the compacts, as they say, is quite different. In the nursing compact, by the way, which you may be familiar with, if you are deemed eligible as a nurse, you can practice in any of their states that are participants. That's different than the medical licensure compact, because early on in the medical licensure compact, the state medical board said, if we're going to be issuing a license or the ability to practice medicine, one, we want to be able to issue that because that's what we do. And two, we want to know where they're practicing. We wouldn't feel comfortable knowing that a doctor who's gone through this pathway may or may not be practicing in our jurisdiction. We'd like to know. We want them to get our license. They should pay the fee for our license. And then we can then oversee whether they're delivering the care that they should, so that if there's a problem among the public, there is recourse. So I share that because, again, if you may hear about a lot of interstate compacts, they're literally all very different. And so I want to make sure that that distinction is known. And I think I have 2 more slides. Next slide. I mentioned that what we do at the Federation, there's an international version of this called the International Association of Medical Regulatory Authorities. We have 10 state licensing boards that are members of IAMRA. The FSMB plays a role as a secretariat. I mention this because I'm aware, since we'll be going there in November, this particular meeting is being hosted by the Indonesian Medical Council. We hold these meetings every 2 years in person. There are a lot of webinars in between. If the Osteopathic Medical Board of California is interested in becoming a part of IAMRA, I think it's important for the world to be aware of osteopathic physicians who are educated and trained in the United States, especially those who go overseas. I think there's some confusion internationally between osteopaths and osteopathic physicians. But the reason I'm sharing this slide as part of this presentation is I'm aware of at least 1 or 2 states, one or 2 countries that have a federated model where they have provinces or other sort of states within their country that would like to learn more about the Interstate Medical Licensure Compact because they're intrigued by the concept. It sounds sensible and seems to be, again, a concept that seems to be working. Next slide. I think that's my last slide. Happy to take any questions. That's my Twitter handle, but I'm also available through email and the Osteopathic Medical Board. Thank you, Dr. Buhari.
Thank you, Dr. Chowdhury. That was a very informative presentation. We've sort of dabbled in this throughout the years, on and off, having it mentioned on the agenda, but never really had a real proper understanding of what it is. Are there any questions from board members for Dr. Chowdhury? Ms. Mercado?
Okay, hello. Thank you for that great presentation. I might have missed it, sorry, I walked in a little bit late, but wanted to ask you if you can talk to us a little bit further about how physicians are going to be able to prescribe through the compact. I know there's still some issues with the opiate epidemic recourse in terms of the damage it did nationwide and some doctors being affected, and how is that going to affect the public potentially if we can't keep track of what they're doing throughout the states?
Sure. So again, it's a great question. I want to make sure we're all on the same page. If a physician is eligible for a license through the Interstate Medical Licensure Compact, they can get it. And the criteria are strict because the states want to make sure that the public is protected. Once they get that license, it doesn't mean they can do whatever they want. And so part of our education has been, and the Compact Commission has done the same, to educate physicians that, let's say you want to practice telemedicine in multiple states. Well, yeah, in theory, you can do this through the Interstate Compact, but you still have to follow local laws. You have to follow federal laws. So it doesn't mean you can do whatever you want. And that's partly why in the Interstate Medical Licensure Compact, the states insisted that it's the states who issue the licenses because they want to know who's going to be wanting to practice medicine in their state, and they want to make sure that they can hold that licensee to all the rules and regulations a state may have. And so to answer your question in a slightly different way, this doesn't enable a physician to do anything differently than they would if they were licensed through the ordinary pathway. It just enables multiple licenses to be issued by those state licensing boards, but with tighter eligibility requirements and with what I would argue would be adequate safeguards so that if there is a problem or a situation, that complaint information is still required to be shared with all the licensing boards for physicians who are going through the compact, and the state may still take whatever decision it wants in terms of discipline.
So just, I guess, so who's going to be recording what they're prescribing? So a physician is coming to California and prescribing opiates. Where are they going to register those prescriptions? Is it going to be through the Cure system?
So you'll have to forgive me. I'm not familiar. I'm licensed in the state of New York. I'm not licensed in California. So let me put it this way. If a physician forget about the compact, if a physician applies for a license in the state of California, whether an MD or DO, through your board or the Medical Board of California, you issue them a license to practice medicine. The state may have additional requirements as it relates to prescribing or PDMPs or whatnot. If a physician gets a license through the Interstate Medical Licensure Compact by the state of California, by your board or the Medical Board of California, they're still held to that same requirement. So the answer to your question is a physician getting a license, if California were to adopt this compact, would still be held to the exact same requirements as any other physician in the state of California.
But in terms of how can they prescribe medicine throughout the different states? I guess I'm a little confused on that aspect.
So when you're licensed to practice medicine, when you're, let's say I'm licensed in the state of New York. If I was also licensed in the state of Florida, let's say through the compact, so now I'm licensed in 2 jurisdictions. What that means is, and the state boards have long held, that the practice of medicine is where the patient is located. So if my patient is located in the state of Florida, I can prescribe medications to them because I have a license in the state of Florida. And if something goes wrong, there's recourse and the state of Florida can come after me. But I can't do that for a patient living anywhere else. In New York State, they don't keep track of every prescription I write, and neither does the state of Florida. But there is a complaint-based system in place. So that's how that works. Did I answer your question, or am I still being vague?
Yeah, I'm just trying to understand the infrastructure that's being set on the back end, because you also mentioned that if something goes wrong, that all the boards or all the states get informed. Are you guys building like an internal IT tech system where everybody plugs and plays and you're sharing data, or is this still going to be manual as you build a compact?
So the Interstate Medical Licensure Compact Commission, as I said, it's now grown to a process where it's helped state boards issue 63,000 licenses. It is maturing. It is using IT much more than it has. It's asked the FSMB for some assistance in helping verify credentials, because, as I said, we have a lot of those credentials. So I would say the Interstate Compact Commission is maturing in tightening up its ability to keep track of things. For example, one example of this is while the Interstate Compact exists principally to issue those licenses, the idea initially was when you renew those licenses, you do that on your own with your states. Well, at some point it occurred to the Compact Commission that if you have, let's say, 10 licenses, each of those 10 states may have varying requirements for renewal in terms of CME, for example, continuing medical education. How is a physician supposed to keep track of that? Well, that's up to them. But the Interstate Compact Commission said, maybe we can help them. Maybe we can come up with a means to remind them that X license is about to be due for renewal in 90 days. Please check the state's requirements. You may be required to do CME. The Compact Commission is even exploring ways in which they can aggregate some of that CME, because maybe some of the CME that you do in one state counts for another state. So the Interstate Compact Commission is using technology more and more, but the Interstate Compact Commission, I should point out, does not directly deal with those complaints. It is not it does not license doctors, it does not discipline doctors, it does not solicit complaints. That is an internal process. There is a technology piece to it, but I'm not the expert to talk about that, but I can have someone come and respond to you afterward. So I'll try to make it simple. Let's say California adopts this compact. and a physician is licensed in California and New York. New York receives a complaint about this physician. It could run the gamut. It could be fraud and abuse. It could be competency related. If both of those licenses were issued through the compact, New York State would be required to share that complaint data with the state of California. The state of California can do what it wants with that complaint data. It can launch its own investigation, or it can see what New York does. At some point, New York may or may not take an action. You know how these work. Not every complaint leads to a disciplinary action, but if New York takes a disciplinary action, then California has a choice to make. Does it want to take the same action? Does it want to take a different action? So it's no different than what occurs now. The difference is the requirement to share complaint information about physicians who get those licenses, only for those licenses obtained through the compact. Because currently, as you know, outside of the compact, complaint information is not shared between the states.
Yeah, so the IMLCC right now, so far, it's issued over 60,000 licenses. So they've brought in over $24 million. So this is going to be a body that's simply just doing paperwork and making sure these licenses get approved with all that money?
So okay, two things. One, the money, most of it has gone to the state licensing boards. So each state charges a licensing fee. Those fees are not retained by the commission. They go directly to the state licensing boards. Number two, the Interstate Compact Commission does not issue these licenses. The states do. The Compact Commission is just a conduit or a means of sort of making sure that processes are being followed and that the processes make sense. From time to time, the commission may even change some of those processes to enable efficiencies. And in terms of safeguards, I should mention, once a state decides to implement this, it doesn't happen overnight. It takes roughly 8 to 10 to 12 months to make sure the IT infrastructure is in place to enable this sort of additional pathway. The FSMB's foundation has provided grants to help state boards do that. There are other means in which other entities, private entities, are authorized and able to provide that kind of money to set it up. But ultimately, the majority of the monies go to the state boards. The commission, as I said, has one employee, actually. I should make that clear. The commission is not this huge conglomerate. The single employee is the executive director. There may be another part-time person, but it's not it doesn't have an office of its own. It doesn't have a building of its own. It meets once or twice a year. So it's not this huge entity that you might think.
Okay, thank you so much. I'll take a look at the slides. I think we have a copy of those, right? One final comment. Is it possible for you to provide us with, you mentioned that you guys keep really good data on the demographics of all your physicians, where they're licensed, I believe age. Is that something that is public record that we can obtain for the Osteopathic Medical Board? I'm interested in seeing how the nation is looking in terms of available physicians and demographics in terms of ethnicity and gender.
Great question and good timing, because every 2 years, the FSMB issues a census, a national census of the nation's physicians. We've been doing that since 2010. So we're literally weeks away from formally issuing a comprehensive manuscript that'll go into those details. But I will also, since you made the request, I will ask my staff to put together a sort of a data set that is specific to osteopathic physicians in California, even before that full manuscript is issued, because we have the data. And now, of course, that data comes from the state boards. What we do is simply aggregate the data. So if your state doesn't ask the question that you're looking for, we may not have the data. So I want to make that clear. It is not an independent data set. It is a public data set that each state board typically issues about its physicians. What we do is we make sure that it's linked in with their medical school data, their residency data, et cetera.
Oh, great. So you do have that data at a federal level that you can provide us for all the states?
Sure. Yeah.
Okay,
As I say, the larger data set
it.
will be available publicly soon, but I will have, as soon as I get off this call, I'll have my staff put together a shorter data set that is specific to California and osteopathic physicians, if that's what's being asked.
Yeah, thank you so much. That's my questions.
All right, thank you. Any other board members with comments, questions?
I had a question. Himesh Patel here. Thank you, Dr. Chowdhury, for coming and speaking about this important topic. I do realize that this compact can have great benefit to people or to doctors that are, physicians that are trying to get licensed in multiple states. It helps provide greater reach to those patients that are vulnerable and have low access to medical care. As someone that works in telehealth, I can attest to the fact that being licensed in multiple states helps quite a bit for traveling patients, patients that work in a different state, different times of the year, but still want me to be their medical provider. If this body, in the end, does support the compact, what would be the best next steps to kind of get the process going?
So, so the usual step is for a legislator at the state level to introduce the legislation, and then to have the legislature. Most states have bicameral legislation, as you know. So both houses of the legislature at the state level would probably send this to a health committee and have discussions, and then ultimately it would get out of legislature. Most, by the way, the 37 or 30, we're approaching 39 states that have signed this into law, it was overwhelming support. So it wasn't like a narrow margin. It was like overwhelming support, because once I think folks sit down and look at how this is structured, it's actually pretty good, pretty safe, and pretty functional and makes sense. If you think about the alternatives being things like national licensure, this certainly offers an approach that seems to be working. But typically it needs to be signed into law. And so, of course, that needs the governor's signature. So that process, from the introduction of that legislation to having the governor sign it, can take anywhere from months to a couple of years sometimes. Depends on the state and the inclination. But this is, much to our pleasant surprise at the FSMB, has really grown by leaps and bounds, and it's coming to a state near you, but ultimately it's up to each of the states to decide what they want to do.
Thank you. Are there any other questions from board members for Dr. Chowdhury regarding this presentation?
Dr. Bahari, if I can step in here. Erica Calderon, Executive Director. Just to help aid the question that Ms. Mercado had earlier about what's required for California in terms of the DEA registration, we would require that for every premise location where the doctor will prescribe, furnish, or dispense medication. So it would be tracked by the Cures database system. So just to kind of clarify that and point that out, that would be still a requirement for the state to impose. And secondly, I do have a question for Dr. Chowdhury. In terms of board certifications, if you can elaborate on that a little bit more, whether they're still required to maintain that active at all times. Thank you.
Sure, and I'm glad you made that first point. You were much more articulate than I was about the requirements. And as you know, the DEA recently, under the legislation from late December, now to be DEA licensed or registered in any jurisdiction, you also have to do 8 hours of required education in addiction medicine and substance use disorder and the opioid use disorder. To your question about the specialty certification, just as a reminder, and if you go to the website of the Interstate Medical Licensure Compact Commission, you will see somewhere on the website is a letter on their letterhead where they have signed information about this, because this issue comes up often. So let's say California adopts this into law, and a physician who is licensed in the state of California wishes to apply for additional licenses. At the time that that physician is seeking those additional licenses, the compact requires that physician, as one of their 9 criteria, to be specialty certified. It only lists 2 types of certification: the American Board of Medical Specialties or the American Osteopathic Association. However, once you get your license through this pathway, and you sort of have a 12-month limit, a timeline for eligibility, once you signal your interest in getting multiple licenses, and they do the background checks to make sure you meet the 9 criteria. Once you get the license through this pathway, you are not, I repeat, you are not required to retain, maintain, or continue with that specialty certification. You can if you want to, of course, but it would not be a requirement for renewal of medical licensure in any of the jurisdictions that are part of the compact, nor is it a compact commission requirement to retain or maintain specialty certification. That's an important point. Not every physician retains specialty certification, as you know, and that point is an important one to make.
Thank you.
You're welcome.
Okay, now seeing no more comments from members of the board, any public comment from members who are present or questions? Seeing none, I'll ask the moderator on the WebEx.
Thank you, Mr. President. I've opened up the Q&A panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of your screen, or simply raise your hand. We are displaying instructions and we'll give you a moment.
And Dr. Bahari, while we're waiting for questions, may I make one other comment?
Of course.
Thank you. In some states that have considered the compact, I'll share an anecdote. One state said, well, we don't think we need the compact because thank you very much. We do our process quite well. We're pretty nimble. We can do things, we can turn things around very fast. And so we don't think we need the compact. I think it's important to keep in mind that the compact is not meant to be a criticism of the hard work that the state boards and the staff do in licensing individuals. It is simply another pathway. And it works both ways. If California were to pass this into law and the governor signed it, it wouldn't simply mean that physicians outside the state of California could become licensed in the state of California, whether they want to do that for in-person care or for telemedicine, faster than they could now. It also means that California physicians, among the finest in the nation, would be able to deliver care, whether in person or through telemedicine, through other jurisdictions if they wanted to, through this expedited pathway. So it works both ways, and it's not simply about speeding up your process. It's also about enabling physicians to be able to cross state lines, deliver care, which, as you know, this country still needs in underserved areas around the country, to all sorts of populations that don't have that kind of access. And that's why we think, and this is maybe a good place to close, it's good for patients, we think it's good for doctors, and we think it's good for state licensing boards that can retain their oversight and control of what they do best, and they've been doing for decades, which is protecting the public.
Thank you. We'll go back to the moderator for anybody with the on the WebEx, members of the public.
Thank you, Mr. President. No one has indicated that they would like to make a comment, so shall I close the Q&A panel?
Yes, please. Thank you.
You're welcome.
And once again, thank you, Dr. Chowdhury, for taking the time and making that presentation. It was very informative.
Happy to do so, Dr. Bahari, and hope to see you all in person one day. Thank you.
Thank you. All right, we'll move on. But before we get to agenda item number 8, which is the Executive Director's Report, we have one small item to discuss, and that is board member Claudia Mercado will be terming out on the board, and she's served on for many years now and been a very, very strong advocate for public safety as far as this board goes. And she played a very large role in multiple committee assignments, and it's sad to see her term out. But as a certificate of appreciation we have for you for the 10+ years of service to the Osteopathic Medical Board and commitment for consumer protection, I'd like to present you with this certificate.
Thank you so much to the public for being here. This is why we do what we do, so we can protect you. My first meeting was in 2012. I was also late, so apologies. But my first meeting when I showed up, they weren't sure if I was a board member. It was mostly, just to be completely transparent, mostly Caucasian men in their 60s, and I was one of 2 females, the only Latina on the board. So they thought I was the clerk. and here I am 10 years later still being of service. So it's been a joy to work with you guys. I'm so glad to see the board be so diverse. We represent really what truly California stands for, and I look forward to other members to taking this to the next level. So thank you so much. Appreciate you.
We'll open it up to comments or any statements from board members.
Sure. Thank you, Claudia, for all your service. It's the first time we're meeting in person because of COVID and everything, but thank you so much.
Claudia, I'd like to also thank you for serving, definitely for the length of time and always being very engaged in all the meetings that I have participated with you on. You really do see this as public service, and I want to thank you for that.
Appreciate you. Thank you for those words.
Any members of the public who are present who wish to comment?
Claudia, if you can hear me, this is Andrew. I wanted to also say thank you. I've enjoyed working with you, and I'm sad that you're leaving, but I know that you'll go on to other things. You care a lot for the board, and I hope that we can continue your legacy. You always speak up for the items that sometimes get overlooked, and I'm very conscious and aware of that. And again, I just want to thank you for your service. I've really enjoyed working with you.
Claudia, this is Gore. Thank you for your service as well. It's been very nice working with you. I wish you all the best in whatever you're planning to do.
Thank you so much. I appreciate your comments.
Moderator, any public members on the WebEx wish to comment?
Thank you very much, Mr. President. I've opened up the Q&A panel, and if any member of the public would wish to comment, they may raise their hand or type comment using the field in the lower right-hand corner of the screen. We'll give them a moment. All right, I'm seeing no requests for comment. Shall I close the Q&A panel?
Yes, thank you.
You're welcome.
All right, we'll move on to item number 8 on the agenda, the Executive Director's Report. Ms. Erica Calderon.
Good morning, Dr. Bahari, members of the board. First of all, I'd like to go ahead and point out that our entire staff is here present today with our exception of our reception, who is holding up the ship. But I'd like to go ahead and just point out that we have both our application services unit here, our administrative services unit, and the enforcement unit present here. We wanted to wish farewells to Ms. Mercado for all of her services, but I'd like to just go ahead and point out that we do have everyone here today. Erica Calderon, your Executive Director for the Osteopathic Medical Board of California, here today to provide you with my Executive Director's Report. First, I'd like to say that it was a true pleasure, again, to see you all here in person. And Dr. Bahari, a pleasure of spending time with you at the annual OPSC conference and most recently at our FSMB conference last week. It was also a pleasure to interact with Ms. Pines there. To Ms. Mercado, once again, thank you for the many years of serving the OMBC and for your commitment in improving consumer protection. This report today will provide you with information on the following topics. We have our administrative services, including personnel, and an update on our technology, an update on our Federation of State Medical Boards, FSMB, and just a friendly reminder on the change in our cures fees. And later on today, I will be presenting an update on the enforcement program. In terms of our administrative services, I would like to start off with an update of our physical office space and an update on the California Board of Naturopathic Medicine. On April 1st, the California Board of Naturopathic Medicine vacated our shared office space and moved to 1747 North Market Boulevard in Sacramento, California. The Naturopathic Medicine Committee was formed on October 23rd, 2009 under the Osteopathic Medical Board of California. However, both of the programs remain autonomous from one another. On January 1st, 2023, the committee became the Board of Naturopathic Medicine and was removed from the OMBC and placed as the newest board under the umbrella of the Department of Consumer Affairs. Due to recent growth in both programs, a mutual decision was made between both executives to look at bigger office space. Both boards explore the idea of moving out together to another office or one of us vacating the shared office space. After exploring all options between the boards, our budgets department, and our facilities department, ultimately a collaborative decision was made that the naturopathic find another location to move into and that OMBC stay at our National Drive location. The board wishes the executive director of the California Board of Naturopathic Medicine, Ms. Rebecca Mitchell, and her staff the utmost success in their board's future endeavors in their beautiful new office location. In terms of personnel, we do have quite a bit to cover today. The board has undergone an office organizational restructure this quarter with the help of our Department of Consumer Affairs Human Resources Office. We now have 3 units established. In addition to our licensing service unit and our enforcement unit, we now have an administrative services unit. The board is thrilled to announce 1 internal promotion and 3 hires this quarter. The board still has 13.9 authorized positions. However, with the reclassifying of 1 single position, which was our part-time medical consultant, we were able to get the 3 units established. The board has backfilled behind Corey Sparks, who previously held the lead role over the enforcement unit. In addition, the board filled its previously allocated half-time staff services analyst position to bring on a full-time management services technician and hire 2 individuals on a limited term basis. A staff services manager 1, who will act as the board's licensing program manager, and a retired annuitant who will be assisting the board with revising its disciplinary guidelines. If you can please refer to attachment 8A, which is our OMBC's past and current organizational charts, you will be able to see a visual of all of these changes. We will start with the Staff Services Manager 1 over the Administrative Services Program. Ms. Terry Thorfinson has been redirected to this position. Ms. Thorfinson, as you know, has been instrumental in the past in managing the entire office. She will now manage the admin unit and primarily focus on tracking legislation and drafting board regulatory packets for us. Please join me in welcoming Ms. Thorfinson into her new role. I will now address another member of our management team, our Staff Services Manager 1 over our licensing program. The board is happy to announce the internal promotion of our very own Ms. Machiko Chong as our new limited term licensing program manager. Ms. Chong joined the OMBC family back in July of 2010 as a staff services analyst, as the board's only licensing program coordinator, and in 2012, she was promoted to the board's executive analyst role. She has served the board for nearly 13 years and has proven herself to be a huge asset and just a wealth of knowledge with the application services process. Even though I was thrilled to know that I had a personal assistant when I joined the board in November, Ms. Chong's skills are much more needed and beneficial to the board as our licensing program manager. Please join me in welcoming Ms. Chong into her new role. Ms. Chong's prior executive analyst position will remain vacant and will be filled at a later time. The operations of the enforcement program will be currently managed by myself with the assistance of the board's lead analyst, which takes me to introduce you to our associate governmental program analyst, our lead over the enforcement unit, who will serve the board as our probation monitor as well. The board is happy to announce the recruitment of Ms. Andrea Jeremia, who joined the board on March 20th, 2023. Ms. Jeremia previously held a position with the Medical Board of California for nearly 3 years in their discipline coordination unit, processing all the board's accusations and disciplinary orders, as well as serving MBC as a lead panel analyst. Please join me in welcoming Ms. Jeremia to the OMBC family. Next, we have our Management Services Technician. As previously mentioned, the board officially merged its half-time medical consultant position with the board's other half-time staff services analyst position to hire this position. This position was advertised in mid-February. Interviews were conducted, and the board has officially filled this position as well. You can tell we're very busy in this aspect. The board is happy to announce the recruitment of Ms. Mia Quinn, who is in our audience today. Ms. Quinn joined the board on April 26, 2023. She also comes from the Medical Board of California's Discipline Coordination Unit, where she provided support services to 9 analysts, initiating all of the board's out-of-state cases, scanning and uploading all of the disciplinary orders for public disclosure, and maintaining the entire file room. And if you can imagine, that file room is huge. Ms. Quinn will be providing support services to both the licensing and enforcement units, so please join me in welcoming Ms. Quinn to the OMBC family. Finally, in terms of office staff, we do have one other hire, our Staff Services Manager 1 Specialist. She's not present here today, but we like to go ahead and acknowledge her. She is our retired annuitant. The board is happy to announce the recruitment of Ms. Rebecca, she goes by Becky, Marco. Ms. Marco began her employment with the Physical Therapy Board of California in 1981 as an office technician and retired from the PTBC as their executive officer on December 23rd, 2012. She served the board in every capacity in between with an emphasis on the rulemaking process. She has a wealth of knowledge, skills, the experience, and all the abilities needed to assist this board with revising our disciplinary guidelines, which have not been updated since 1996, so I'm super excited to kick this project underway. Please join me in welcoming Ms. Marco to the OMBC family. Lastly, but not least, in terms of staffing, I do have an update in terms of our legal counsel. At our January 2023 meeting, we did announce that the board was being reassigned its legal counsel, and Mr. Michael Knotes would start transitioning out. The board was introduced to Mr. Michael Kin at that time. However, shortly after that board meeting, we were informed that we were getting reassigned again. So I am very thrilled to introduce you all to Ms. Kayla Watson. It's right in front of us here, our newest legal counsel. She will be shadowing Michael for a while, so we do have some time left with Michael, so thank you again for that. Moving along to an update as far as our technology and outreach goes. The board has been very active this quarter in terms of working with our BREEZE team, as well as our Office of Human Resources, as you can tell. We are looking at improvements for both our licensing and our enforcement programs. At the last board meeting, I did mention that Terry was meeting with BREEZE on a daily basis, but now we actually have staff from both programs that are assisting in these improvements. You will hear all the details of what we have accomplished later today in our program updates, but which I don't want to steal Machiko's thunder because she's made a lot of progress when it comes to applications. However, I do want to announce that one of the requests that I personally received from our board president, Dr. Bahari, is now in production, and that is the automation of our wall certificate to include the digital signatures of both our board president and our board secretary. So Dr. Bahari and Mr. Moreno, you will no longer have to sign each certificate manually, and our licensees will be receiving their certificates a lot sooner. In terms of our social media accounts, at the last board meeting, the board announced the creation of its Facebook and Twitter account. The board did request that our cover page get updated after receiving feedback, and that now represents a picture, an image of our state capitol building. The board has been very active in posting informational material for both our consumers and our licensees through these accounts, and so far we have received great feedback. We will continue to utilize these platforms for outreach and obviously to keep our stakeholders informed of any process changes with the OMBC and DCA in general. In terms of our redesigning of our website, DCA is aware that this is a priority project for OMBC, and so far this project continues to be on its course. It has been projected that it would take approximately 146 staff hours to fully execute, and we are hoping to start this process July 1st, which is the beginning of this fiscal year coming up. Internally, board staff has been preparing for this transition. We have completed what we consider phase 1 internally, which was to identify all old content that we do not want to transfer over to our new page. This page will now serve multiple purposes, obviously to make it more user-friendly for our licensees and our consumers as well. We'd like to go ahead and streamline those processes, make sure that our licensees are able to get the forms that they need for their applications, and obviously make it easy for our consumers to be able to file a complaint with us. I will say that we have since updated our Contact Us page. It is a wonderful tool now. We gave our consumers the option of sending direct email messages to certain staff in certain units. So once they complete their inquiry, it comes to the specified unit to be addressed immediately, instead of redirecting staff, our consumers to call, certain phone numbers and expect a voicemail. There is one last technology update that I'm very thrilled to announce, and that is that our board is transitioning to Microsoft Teams communication at the end of this month, which means that staff will now be able to provide better customer service, as they will now have the ability to call or take incoming calls directly from their computers. This is great for those of us that are still teleworking in the office, and instead of waiting to come back to the office to return their calls, they're going to have that instant communication with our population. Now for an update on the Federation of State Medical Boards. The board attended the Administrators in Medicine and Federation of State Medical Boards 111th annual meeting from May 3rd through the 6th, which was hosted in Minneapolis, Minnesota. We just came back from that last week. The FSMB is a national nonprofit organization that represents the 70 states, medical, and osteopathic boards of the United States and its territories. Their mission is to serve as the voice for state medical boards, supporting them through education, assessment, research, and advocacy, while providing services and initiatives that promote patient safety, quality health care, and regulatory best practice, as we heard from Dr. Chaudhry. The FSMB is a recognized authority throughout the United States and internationally on issues related to medical licensure and discipline. The board did have the pleasure of attending the keynote presentation provided by Professor Malcolm Sparrow from the Harvard University. Dr. Sparrow examined the puzzles of performance measurement for organizations that provide public protection and hold disciplinary powers, such as state medical boards. He described 4 distinct types of work that all coexist within such organizations, and how each type of work produces its own distinct set of matrix. I also had the pleasure of attending the Executive Directors Forum, where I was able to engage with several of my colleagues in similar positions from across the country and discuss topics and issues related to each relevant state. Lastly, the board attended the American Association of Osteopathic Examiners, the AAOE, annual business meeting, and we did have the pleasure of meeting Dr. Chaudhry at that meeting. We also spoke to Ms. Rain Richards, the president of the AAOE. To finish off my executive report, again, just to remind everyone, we are looking at a fee increase. The Controlled Substance and Utilization and Review System fee decreased from $11 to $9 annually for licenses expiring on or after July 1st of 2023. The fee is assessed at the time of the license renewal on licenses that prescribe order, administer, or furnish any scheduled drugs. The fee covers the reasonable regulatory cost of the Department of Justice for operating and maintaining the Cures database, which is a critical element in the state's efforts to address the growing danger of the opioid addiction stemming from prescription drug abuse. At this time, this does conclude my executive director's report. As I mentioned earlier, I will be addressing the enforcement unit later. If you have any questions, I'd be happy to answer them.
Hi, this is Claudia. Congrats to everybody that's part of the one. Oop, there goes my award. Put that in the same place. I was just saying thank you for everybody for being here. In terms of taking care of the team, when we budget for, let's say, raises or promotions, do we have to go to the DCA committee for that and make sure that we're up to par, or how does that work? Just want to know how we're handling that on a regular basis for employees of the staff.
Absolutely, Ms. Mercado. Every change that I make, I do have to address it with the budgets office just to make sure that we still have the allocated funds. We do have certain fund conditions for certain line items, and staffing is always one thing that we constantly keep an eye on. So whenever I do make any kind of staffing change, whether it be filling a position, we do take that in consideration and we get it approved through our budgets department.
Okay, and just for raises for employees internally, that's something that's done by you as executive director? But for the board, for us to ask for a raise for you, we have to go to the DCA, correct?
Correct. And well, in terms of certain staffing raises, that does go through their supervisor, their direct supervisor, and they do have to, attest to whether they are fit to receive that.
Yes, want to make sure we're taking care of the team.
Absolutely.
Any other questions from board members for the executive director's report?
I guess maybe just one more question. The last 6 months, what has been like something that has really thrilled you that you guys have accomplished as a team? Just more on a personal note, I guess, off script.
I think coming in and actually analyzing the changes that were needed, and structurally, I think that we needed to make this happen to actually introduce the 3 separate units. I think that now having leadership within those units is going to make a lot of things happen. Like I mentioned earlier, Terry was overseeing the entire office. And so getting projects going, it required a lot of, it requires a lot of support from the staff. And so now that we're all grouped in these units, we can collaborate in efforts for outreach, making changes to forms, publications. We do meet, now that I have my leadership team, we're meeting on a monthly basis to discuss these changes that we're all working on. And we're just collaborating more than it used to be before, I believe. Staff seems to be happy. They're here present today, and I think morale-wise, we're doing great. And we're just getting things done. Everybody's excited, so collaborating with my team on a daily basis, checking in with them, seeing what works and what's not working, has been our approach for our success for the last 6 months and making changes. And I do want to say thank you, that I appreciate them, because we are making such tremendous changes in such a little amount of time. But even our office having more space has really assisted us in getting organized, making things, essentially running smoother for all of us.
I think the DCA, it looks like they are really stepping in to help. So just keep asking for help. I know they have the resources for us, so I would encourage you guys to hold them accountable to help us shine. Thank you.
And I want to say a personal thank you for dealing with the signatures and the certificate issue. I walk over to the mailbox once every couple of months and pull out a gigantic stack of these. The last one was horrendous, but and my writer's cramp is going to get better, so that's good. Well, appreciate that. Thank you. And it really is an efficiency, because people will get their certificates much faster now. One less hurdle for it to go through. Any members of the public wish to comment on the executive director's report? Seeing none, moderator for the WebEx, are there any members of the public?
Thank you, Mr. President. I've opened up the Q&A panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of your screen, or simply raise your hand. We are displaying instructions and we'll give you a moment. All right, this is the moderator. I see no requests for comment. Shall I close the Q&A panel?
Yes, thank you.
You're welcome.
All right, we'll move on to item number 9, and I think after we get through agenda item number 9, we'll take lunch. Sounds right? Okay. This is update from the Osteopathic Physicians and Surgeons of California Association. We have Holly.
Good morning. I'm Holly McChris. I'm the Executive Director for the Osteopathic Physicians and Surgeons of California. First, thank you, Dr. Pahari, Erica, and Machiko for coming to the annual convention in San Diego in February. The members that were there and the attendees that were there, they really appreciated having that one-on-one time with you. So I hope that we can make this a constant thing to get you at our meetings, because it was really perfect. I'm just going to touch on one thing that we're dealing with, and Terry has been huge at helping with this as well. The bill AB 765 is a very important bill to us all of a sudden. It was important to begin with, but now that they have removed the word osteopath from the bill, it has allowed 30 internationally trained osteopaths who are not licensed or overseen in the state of California or federally to continue to practice manipulative medicine, again, without a license and without anything else. So we know this is a historic term for the osteopathic physicians in California and in the nation. So we were really wanting to work together to see how we can make that come back either into the bill or see what we can do next year. So we appreciate OMBC being part of this process, because it really is an important thing. And then I'm going to let Terry just talk about the rest of it, because she's got more of it than I do. One other thing, the OPSC board meeting is meeting next Wednesday, where we will be addressing a lot of what you're addressing with the bills that are coming up as well. So we will work together. I'll let Erica and Terry know what is happening at OPSC's level, and then I know they will be informing me as well as to what you all are going to do, so we can be in the same place potentially. And that's it. To reiterate, Erica coming in, I haven't even been here a year yet, and in that first 6 months, I didn't have a lot of relationship with the OMBC. Terry and Machiko were my people. But when Erica came in, she really created an environment for us to have this great working relationship, which I truly appreciate, because I know that's not the case with many other boards and their state associations. So thank you for Erica, and she's doing a great job. You all are doing a great job, so thank you.
Thank you. Any comments from members of the board?
I have one. What's your thought about the compact?
The presentation we just had? Great question. I appreciate Erica asking the question, because I'm a little concerned about the board certification part. I don't quite understand how that evaporates once they have this license over a year. You all probably understand it better than I do. And I actually reached out to the AOA while we were sitting here with this presentation to get more information from the AOA and how they're supporting it, because board certifications are very important at the American Osteopathic Association. I'm not quite sure. Like our past president, Dr. Lynch, he's licensed in 4 states. You're licensed in how many states, Dr. Patel?
The goal is 25.
There you go.
Currently maybe 7 or 8, but it's a very long and cumbersome process.
Okay.
For maybe 2 years, also very expensive.
That's what it sounds like. So I'm not really sure where to go with it yet, but this is my first understanding of this presentation. I would like to work with the AOA to get more information from them, seeing how they're very supportive of it. I just don't quite understand some of the actions. And I actually texted with Dr. Lynch to see if he knew about it, and he was unaware of it. So I will actually go to him, seeing how he is one of those that carries multiple licenses, to see what he thinks about this.
I mean, as far as the board certification goes, you're not required to have a license. in California to practice medicine.
Correct.
But most insurance plans, most hospitals will require this of their subspecialties.
Correct. But that's what I'm saying. I don't understand once you get this multiple license or whatever it is, how does after a year or 18 months, whatever it was, how does that just kind of cease to exist? And do you have to maintain it?
You still have to maintain it through the state licensing board. So if the state licensing board has a CME requirement, is that what then that still has to be maintained.
Okay. Yeah.
This is, I think it boils down to a faster, easier way to obtain a license in multiple states. If you got, let's say we were part of the compact and we got a request to give a license to a person who was vetted by the medical compact and given a license by them, then we would be under the understanding that they meet the criteria.
Dr. Bahari, Michael Knot's legal counsel. I do think we're a bit off this agenda item, so I think we should contain the discussion at this point. I think a little bit was okay in terms of their thoughts, but.
Hi, I have
Thank you.
I think, do you guys do any work in terms of promoting the profession? I know that, countrywide there is a deficit in physicians, so I think, instead of trying to find new ways for one doctor to be licensed in 20, 35 states, what are we doing to bring new talent and to really promote the profession and really fill the gap of what the future needs in terms of physicians?
I think OPSC does a really good job of that. They also work very hand in hand with the AOA, who is at the national level that helps facilitate that information in a way. I think, again, a year, not even yet a year, but I do believe in what we've done in the last 9 months, 10 months. We've really been pushing out there the information about needing to be coming to California, really. I mean, most want to come to California, so we've got a pretty good thing there. We work really closely with the colleges, too, to ensure that they're looking at the recruiting processes. We're trying to maybe participate a little bit more with them in that area. We are looking at doing some things across California with taking our CME meetings on the road to go to schools that have the pre-med so that they can engage with osteopathic physicians and learn about our pathway into being that physician area. Bringing talent to California, though, I'm not quite sure. I mean, I work with the other state associations. We have our own association, and we work very closely together on what each state is doing as well. So there's a lot of cross-pollination that's happening. I'm not sure if there's a specific thing you're looking for.
No, it sounds like you answered the question, just in terms of your work, even working with us and getting us that information. Just if people come to our website and they're considering doing MD or DO, what's going to make them go into this profession, or what's going to make somebody young even know that this profession exists. So I was wondering if you're doing that kind of outreach, because I know we have also, we've talked about that, of how we do that ourselves as well.
And we've also talked about doing some partnering together to do some of these conversations together.
Thank you.
I know that as soon as we get into the schools in California, we participate in their orientations. Erica's going to start coming to those orientations so that she can educate the student doctors who are coming out what it means to be part of this board, what it means to be part of California and licensed physicians in the state. And then, again, through the AOA, we are working. They've created a new membership task force that will focus on kind of some of these ideas on how to get more into the pipeline, I guess. But it is one of the largest growing professions, I do believe. You all have a lot of DOs coming into, or a lot of people interested in becoming an osteopathic physician, I should say.
Okay. And you guys are working, do you guys work with the governor's office, or what legislative bodies are you guys working to address the need for more DOs in the state of California?
So that's a place where we're starting to get a little bit more in. We work through our lobbyist, who's very connected into that area, and he's bringing us more forward. The California Medical Association is also reaching out a little bit more to include us in the process. There's a coalition that we've been asked to participate in. I just need a little bit more information about it. So there's partnerships that we're doing throughout other specialties as well. So I think we're getting it. We've got a little work to do, obviously, but I do believe that we are getting to those places and that we'll start seeing a little bit more information.
That's great.
Yeah.
Appreciate that. Thank you so much.
Any other questions or comments from board members? Any questions or comments from members of the public who are present? Moderator, any members of the public on the WebEx?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of the screen, or simply raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Shall I close the Q&A panel?
Yes, please. Thank you.
You're welcome.
And thank you, Holly, for that presentation. We
Thank you,
definitely look forward to this working relationship in the future.
Thank you.
Thank you.
All right, we're going to take a lunch break at this point, and we will return at, let's see, I got 11:45. 1 hour, so 12:45 we'll be back for lunch to continue. Bye-bye. Our next agenda item. Oh, let's do roll call, Machiko. Okay. Thank you. You're right.
All right. Gore Damian.
Present.
Dr. Buhari.
Present.
Claudia Mercado.
Present.
Andrew Marino.
Present.
Dr. Patel.
Present.
Denise Pines.
Present.
You have quorum.
Thank you. We'll move on to agenda item number 10, which is our licensing program update. Ms. Chong, as our licensing program manager.
Good afternoon.
Good
Let
afternoon.
me get my bearings. Sorry. So let me pull up the slides for this presentation. Just the stats for licensing statistics. The board currently has 13,858 licensed osteopathic physicians and surgeons in the state. Of that total, 1,193 postgraduate train. 1,193 of those is postgraduate training licensees, and another 1,214 fictitious name permits. Although the Q1 and Q3 stats referenced in the attachments as attachment 10A and 10B, one of which I'm showing, reflect a 31% increase overall year to date. Applications received by the board compared to the fiscal year 21-22 stats, there was a 1% decrease in those applications. Most of those came from the PTLs. They're starting to bottom out with a lot of those transitioning into full and restricted license types. The licensing staff have been working diligently to decrease the remaining backlog incurred as a result of the prior vacancy within the unit. However, we're hoping that the following changes will assist in these processing efforts. So there's been a lot going on with regards to the application process and a secure data repository for all primary source documents received by the board. So in the recent months, we've been working closely with Breeze Information Services, Portfolio Management, and the Organizational Improvement Office teams to advance the board's web applications presence for those physicians looking to obtain licensure in the state. In preparing for this transition, we began by converting the full and restricted osteopathic physician and surgeons application from a two-step system to a one-step approval process, which went into effect March 16, 2023. Previously, the applicants were required to submit their hard copy application packet to the board, remitting payment of $200 to begin the review process. Additionally, applicants were tasked with ensuring that all supporting primary source documents had been submitted to the board before the applications could move into the next phase. Once the documentation was received and reviewed, staff approved the applicants' files and subsequently notified them of the final payment, which was needed, of $425, which would issue a full 2-year license. With the new combined process, applicants are now required to remit $625 upfront, which includes the application processing fee and the initial biannual licensing fee to initiate the licensure process. In doing so, the applications can now be approved in a shorter time frame, pending all documentation in the office is received and vetted. So with the applications received prior to March 15th, which was the cutoff for the two-step process, those all remain valid. However, they are still subject to paying the remaining $425 for the 2-year biannual fee. However, everyone moving forward will be subject to the new fee type, which in office we associate with a 1030 application transaction type. And this should reduce the process by at least 2 to 4 weeks, because now there's no lag time waiting for accounting to process the payments that are received in office as they handle all of our cash sharing duties for us. Also, the project go live date for the online application is set for early July 2023, pending any user transaction testing and board approval. In addition to converting licensure applications from hard copy to electronic submittal, we are also working to create a secured online repository for submission of primary source documents needed to process applications. This portal will require educational institutions to register prior to their being able to upload documents and create for creation of the secured database. This will streamline the application process by decreasing the wait time for those documents needed to successfully process applications, safeguard applicant information in the event of a security breach, and ensure that all required documents are coming directly from the source and not the applicant or a third-party database. Currently, we have documents that are coming in via mail and also being transmitted via multiple email accounts to various staff. And so now, instead of running around the office, time can be saved with this one repository database being created for staff moving forward. So we're hoping to have this secure database up and running prior to implementation of the online application. And our first meeting is on Tuesday, so staff will be meeting with OIO and portfolio management to finalize some of the information that was transmitted prior to with regards to what we need the database to accomplish for us, and then we'll move on from there.
Okay, do we have any questions from the board members regarding the licensing update?
Yeah, I had a question. You know the repository you mentioned, would it be possible for licensees to upload their CME to that repository, or are you more talking about a logistical repository for the back office?
As of right now, it's just for the initial licensing process. However, it can be expanded later on to include CME. I know that's one of the big things. A lot of the physicians are trying to figure out where they're supposed to send documents. Additionally, that comes into play with the verification of the completion of the 36 months postgraduate training. Our forms are the same for both the initial licensing process and the renewal process for that confirmation. And so rather than it being transmitted to the initial licensing staff inadvertently, it will all be found in this one database. So if there are any employees that are teleworking for the day or whatever the case may be, they're able to find that document in that one location rather than having to wait and prolong any processes.
Hey, Machiko. In terms of the documents being uploaded, so does the system allow the staff to kind of take a quick visual look and say, okay, there were 6 documents uploaded, it's completed, but then they go in and validate them and then they actually verify the completion of those documents?
I believe so. We're in early talks, but I'm not sure what the database will look like on the end, but that is the outcome desired.
Right.
Is that so right now, anybody can kind of transmit a document electronically. With this database, it will require that the entities themselves actually subscribe to the database, so we know firsthand this is coming directly from the primary source.
So you want to make sure that that's actually physician licensed by us with the relationship before we open the portal?
Right.
Yeah,
right.
and then we validate
The
that.
schooling entities,
Right, okay.
postgraduate training entities, they all have to subscribe prior to us accepting the documents that are being received.
And that's great. So about 4 weeks saves time, you think?
Yeah.
Oh, that's amazing. Thank you.
You're welcome.
You know, it sounds like a lot of positive changes towards efficiency, and let us know what we can do to help. That's it. Any comments from members of the public that are present? Oh, we have one.
Holly McChrist, OPSC. One of the other things that we're talking about working with the OMBC, I said OMBC, didn't I? OPSC, apologize. One of the other things we're going to start working with is sending the CME spreadsheet that we have from the people who attend our conferences to OMBC so that they have a bigger space to at least look and see who is submitting. And I'm trying to work with the AOA to see if there's another way to get you into the larger database. Sorry.
Thank you.
Dr. Bahari, Erica here. I did want to just point out and mention that we do have that regulatory packet for our CME self-certification in play, and that's going to save a lot of time when it comes to license renewals where they're doing the self-certification, and we will then merge into a audit situation. So just to kind of touch a little bit on that and remind you that we do have that big regulatory packet that we're hoping that gets approved.
Is that live right now? Because my renewal is coming up soon.
Not quite yet.
Maybe November or?
Okay.
Okay, moderator, any WebEx public members or members of the public?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to make a comment, please type comment using the field in the lower right-hand corner of your screen and submit it to all panelists, or simply raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Shall I close the Q&A panel?
Yes, please, thank you.
You're welcome.
All right, we'll go ahead and move on to agenda item number 11, the Administrative Services Program Update. Terry Thorfinson, our Administrative Services Program Manager. Terry?
Board members, members of the public, Erica gave you kind of an overview of how the units were reorganized. I have a memo and some stats to go over briefly, but I wanted you to see the subjects that are in the administrative unit. In the memo, you can see we have the receptionist, the fictitious name, permit applications, and renewals. We have renewals, compliance, SB 806 compliance, which is the 36 demonstration and completion of the 36 months of residency training as a condition for renewal for people licensed after January 1, 2022. We have cashiering, legislation, and regulatory. Overall, as Erica pointed out, the consolidating the staffing, both for me in terms of not supervising the entire office, has been a great change. It's much more efficient. It's kind of common sense that if you have fewer people to work with, you can work better as a team, and it'll be easier to manage all of the activities that are going on that the staff performs. And so I think I had just wanted to see if I could point out in the audience who the staff is that you don't usually see. Looks like Jaime. You want to raise your hand? Jaime is one of our renewal staff, the invisible staff. David, is David here? No? Okay. That's who everybody that has a license deals with, either one of those two staff. So he is our behind-the-scenes, very important role. Both are very knowledgeable, and I rely on them for their advice. And Mia, you mentioned, is Mia here? Quinn? No? Okay. She was our newest member. She's coming in. I'm working with her on SB 806 and eventually cashiering. Right now, cashiering is done by DCA. We have an out-of-house, but there's some desire to bring it in-house. in the future. So I would be also supervising that. Let's go to the statistics. Okay, so you don't usually see these statistics. These are renewals for both physician and surgeon license and fictitious names by quarter. As you can see, quarter one for physician and surgeon, 1,232, and these are not initial, these are renewals. Processing time, 27. Fictitious name, total of 4. Now, fictitious name permits for renewals are only done once a year. They're on the calendar year. December is when they have to be renewed, so it kind of clusters in terms, as you'll see in the quarter 3, it clusters when the biggest number, but you can see 16 days for processing. Physician, surgeon, quarter 2, 1,539, 29 days to process. Fictitious names, 428, a little bit of a jump for numbers. 3 days to process in quarter 3. Physician and surgeon is 1,539, 25 days to process, and 233. Now you might be wondering, why is renewals time frame that long? And what shows up in the statistics is the fact that as physician renewals come in, they're done kind of on a rolling basis, with eventually the priority at the end of the month being all those that expire in that month. We have a lot of physicians both that apply late and apply early. And so the ones that apply early, if they don't get, if the staff is dealing with this month is the expiration date month, they're ending up processing ones in fewer time, but at the cost of the ones that are the early birds that are giving us renewals much earlier. But we go towards trying to prevent the calamity of physicians' licenses expiring and having to cease practice. So that really something I looked at in the statistics. The staff is more efficient than the statistics show. So that's why I'm saying kind of what goes into statistics is based on, computers are, just using a number, just based on the number of days average for each of the applications, and some of that is skewed by applications that are early that are not getting processed because they're prioritizing people, preventing them from ceasing practice on a given month. Let's see. For the fictitious name, quarter 3, we have the total number, 233, and 10 days processing. That's really an amazing amount of time, given how backlogged we were. So we have a new staff that we had hired even before our last board meeting, who has just done a really wonderful job at trying to get us caught up, gotten rid of the backlog, and it's reflected in these numbers in terms of processing times of 10 days. So that's my report. Any questions?
Hi, yes. So I'm really impressed by your processing time. Thank you so much to you and your team. I think that's great. I think what you're trying to say is that there's a judgment call that you guys make on a personal level when you're going through these that the systems are not doing. So thank you for that. Anything that we can do to let the physicians know when to start applying? Can we automate maybe some messaging to let them know, hey, you're 6 weeks away, we need your application in the next 5 days? Or
well, we did, if you recall, we did make some changes. One, we elongated the period of time when both their application on Breeze opens up and they receive, we don't send out the application anymore, but we went from 60 to 120 days. So in theory, everybody gets contacted at 120 days out. So plenty of time to, do any last minute catch up paperwork, whatever. So that's one thing. When, as Erica mentioned, we go to the audit system, that'll be also easier because right now everything is converging on the end of the month when licenses expire. Mm-hmm. And it was the kind of the stress, the deadline, the high stakes consequences of not getting licenses processed in terms of renewal before they expire is what led to the change and the CME packet, which is we just got to get rid of this deadline, for everybody's sake, and go to self-certification. So that has been, the regs are setting that up, as you guys went through on the January meeting in great detail. And when that gets into place, then it'll be smoother. You know, that deadline issue and processing will go away because essentially certifying, yes, I've made completed the CMEs, and I'm going to be able to press the button to issue myself a license. So, like, that processing time is not counted.
Okay, thank you.
That won't be an issue. And so, so everything's waiting on that reg package that I'm working on. But I think we've made a lot of the changes. We also got rid of the sending out a 13, 14-page renewal application, which didn't necessarily mean people kept it, because we always kept getting asked. They said they didn't get it or lost it or whatever. So now it's a postcard. So we're trying to streamline and remind people. SB 806 people, those licensed after January 1, 2022, they get several emails about the fact that they have to demonstrate completion of the 36 months. They get one when they get a license. They get one when the 120-day window opens. They get another one at 60 days before expiration, and then they get one at cease practice expiration, so at the minimum. So some people, at least in the newer group, you get lots of notification that the renewal's up.
Yeah, thank you for that. Appreciate it.
Good question.
Any other questions from the board members? No? Any members of the public who are present who wish to comment or ask questions? None. Moderator, anybody from the WebEx?
Thank you, Mr. Board President. I have opened up the Q&A panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of the screen, or simply raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Shall I close the Q&A panel?
Yes, please. Thank you.
You're welcome.
All right, we will move on to the next agenda item, which is item number 12, the enforcement program update. We have Erica Calderon, the executive director.
Thank you, Dr. Bahari. This report is on the board's enforcement program for the third quarter of fiscal year 2022-2023. If we can refer to attachment 12A, which encompasses the enforcement statistics for the fiscal year. At our last board meeting, it was reported that there were several projects on the horizon for the board's enforcement program. It was reported that the board updated its consumer complaint form to save intake processing times and gather more essential evidence up front. The board is happy to announce that in addition to updating its consumer complaint form, the board has also translated this consumer complaint form to Spanish, and both versions will soon be available on the board's website. The board is also exploring other different languages very soon. In the staffing update, I mentioned that Ms. Mia Quinn was going to assist both the licensing program as well as enforcement. In terms of enforcement, Ms. Quinn will be responsible for the initiation of all of our consumer complaints. She will be opening our complaints to ensure that the board continues to stay in line with the board's mandate, which is to initiate all enforcement complaints within the statute requirement of 10 days of receipt of these complaints, and also execute proper acknowledgement. In addition, she will be assisting enforcement staff in flagging high priority cases where subjects may already be under investigation, have pending disciplinary matters, or the allegations are egregious in nature to foster a faster review process. Complaint status letters were created this quarter with the help of our Breeze team. These letters will assist enforcement staff in updating our consumers at every phase of the enforcement process, from intake to a consultant review to a field referral, and lastly, to update our consumers when action has been filed against one of our licensees. In addition to these letters, several brochures were created to explain these processes in depth, and they will be mailed out along with the status letters when the complaint moves along to each different phase. These brochures will also be available soon on our web and they will be under our consumer tab. At our last board meeting, Chief Ms. Nichols provided an update on the Divisions of Investigations non-sworn unit that will be assisting OMBC with the investigation of our consumer complaints. After learning that our board was experiencing a slight backlog in our enforcement cases, Ms. Nichols sent 2 of her staff members to assist the board with the review of all of our age cases that were older than 180 days in our desk investigations. Board staff, along with DFI and myself, we sat in the board's enforcement conference room and reviewed each case closely, identifying the next course of action, potential closures, and we also identified 15 cases needing to be referred to the field on an expedited basis. To help with case aging, enforcement is continuing to meet with me monthly for pending reviews. In addition, they are also receiving individualized monthly analyst pending reports, which highlight the high priority cases, short statute of limitations, and any age case that is over the 180-day desk investigation performance measure. In terms of communication with our stakeholders, we continue to meet monthly with DFI, the Attorney General's office, and we consult with our legal counsel in matters that we need to. As far as board statistics, we can refer to those charts. In terms of our performance measures, for performance measure 1, which covers the amount of consumer complaints and convictions and arrests received in comparison to last year, the board has received a total of 471 total complaints. The board is seeing a slight decline in consumer complaints this year in comparison to last. However, we are seeing a slight increase in arrest and conviction cases. Overall, these numbers continue to remain steadily. Performance measure 2 is the average number of days it takes for our analysts to initiate our consumer complaints, as previously stated, and acknowledge receipt. The target for this performance measure is 10 days, and as you can see, our year-to-date is at 7 days, a huge improvement from last year. In addition, with Mia joining our enforcement unit, we do hope that we can see a further decrease in this very soon. In terms of performance measure 3, this is the average number of days it takes to complete an investigation on enforcement matters that are not referred to the Attorney General's office. Case aging here fluctuates greatly because it takes an average of all cases, and 1 or 2 very complicated cases can skew these numbers drastically. In addition, as you are aware, historically enforcement staff was being redirected to assist applications, which we plan to never have to do again. Applications is fully staffed, and they have now an amazing leader overseeing their operations. These numbers include the timelines for HQIU investigative staff. The target for performance measure is 360 days, and as you can see, we are at 280 days year to date, so we are meeting this performance measure. We are hoping that with the development of the non-sworn unit, that the board can start seeing even this number come down a bit more. Performance measure 4 is the average number of days it takes to complete investigations and enforcement actions that are transmitted to the Attorney General's office for formal action. Case aging in this category has increased in comparison to last year. This can be partly attributed to some of these cases experiencing COVID-related delays in the past. The board has filed 12 accusations so far this year, has issued 4 administrative citations, has placed 5 licensees on probation, had 2 surrenders and 2 revocations thus far. Be happy to answer any questions you may have. This concludes my report.
Thank you, Erica. Are there any questions from board members?
I want to, I think you mentioned who sent 2 of their staff members to assist us? I didn't catch that. Wanted to thank them.
This is our DFI unit, our Division of Investigations with DCA, specifically our Health and Quality Investigation Unit.
Thank you. So that really, can we use them in the future if we need them?
I'm not so sure if we can, but we can definitely, we collaborate with them on a daily basis. They have, 3 specific and non-sworn investigators that have specifically been assigned to serve in our capacity with all of our cases, and it's a collaborative effort on a daily basis. We run cases by them to see what's the best course of action. Should we do more of a desk investigation versus an expedited referral? I do meet with their supervisor, Ms. Melissa Doss, on a monthly basis, along with Kathleen Nichols and sometimes Ken Garcia, and we just love the communication that we're having with them because it's a great partnership to speed up our processes.
That's great. And just one more point. Thank you for translating, I believe, the complaint form. So to follow that first step, are you also going to be offering the ability for there to be a translator in case somebody calls and wants to do a follow-up in Spanish?
We do have to go through our Department of Consumer Affairs translation service for that. In order for us to translate what gets returned back to the board, it has to be by a certified translator. We do have, obviously, staff that know the language, but we do have to have them officially translated. That is a very easy process to accomplish for all of these cases.
That's great. Thank you.
Thank you. Any other comments from board members? Any comments from members of the public who are present? Seeing none. Moderator, any members of the public on WebEx wish to comment?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of your screen, or simply raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Shall I close the Q&A panel?
All right, we
Thanks.
will. Thank you. Let's move on to agenda item 13, which is our probation program update. Ms. Jeremia, did I screw that up? Ms. Jeremia, lead enforcement analyst and probation monitor.
Good afternoon, Is this working? Good afternoon, Dr. Bahari and members of the board. My name is Andrea Jeremia, and I am your new lead enforcement analyst, and will also serve as the board's probation monitor. As Erica mentioned, I began with DCA at the Medical Board of California in 2019, where I had the pleasure of having Erica as my previous manager when she oversaw the discipline. Sure. How's that? Okay. Let me start over. Good afternoon, Dr. Bahari and members of the board. My name is Andrea Jeremia, and I'm your new lead enforcement analyst, and will also serve as the board's probation monitor. As Erica mentioned, I began with DCA at the Medical Board of California in 2019, where I had the pleasure of having Erica as my previous manager when she saw the discipline coordination unit. And on March 20th of this year, I joined the OMBC family. I'm here today to provide you with an update on the board's probation program. I would first like to share with you that I'm in the process of auditing all of our probationer files to ensure compliance has been maintained during this transitional phase. I've reached out and introduced myself to each probationer by email and have site visits planned for the future. In Q3, the Osteopathic Medical Board had a total of 34 probationers who were placed on probation for various causes. Of these 34 probationers, 8 were tolling out of state and not receiving credit toward the completion of probation. 1 licensee was placed on probation in the quarter, and 0 licensees completed probation. Of the 34 licensees on probation and not tolling, 4 were participating in the board's diversion program, Maximus. Maximus reported 1 issue of noncompliance of 1 of their participants for the quarter. This participant failed to properly submit their biological fluid testing sample for the month of January. Maximus remediated the issue of noncompliance by requiring the participant to submit an essay detailing the actions and steps they will take to avoid the issue in the future. I am happy to announce that I've met with Maximus and have already participated in my first diversion evaluation committee meeting this past April. 2 Maximus participants successfully completed the program in January, but they will remain on probation with the board until their probationary terms expire. And at this time, this concludes my presentation, and I would be happy to answer any questions.
Thank you. Any questions from members of the board? Ms.
I
Mikado.
have something to say. Can you just explain to us what Maximus does, just for the public to understand in our relationship? You mentioned you attended, what committee meeting?
It's the diversion, give me 1 second.
Stands for Diversion Evaluation Committee.
Okay.
Erica has a lot of experience with Maximus. I think she would be best to answer.
So they meet on a quarterly basis, Ms. Mercado, and they go through all of their requirements. When an applicant enrolls in that program, whether it's a self-referral or board-appointed referral, they come up with their terms and conditions while they're in the program, and every quarter they meet with them to just monitor their probation terms to make sure that they're compliant with every aspect, and if there are any issues that are brought up, that they're addressed. And at every end of the evaluation, they do get a new contract agreement with modifications depending on what is found. They have the ability to request any changes to those terms. As an example would be if they're required to attend 7 meetings with their healthcare professionals, they can request to be brought down to 3 or 4, depending on how well they're doing. They obviously also take a look at how frequently they're being requested to submit random body fluid testing. So those kinds of things. They do a wonderful job.
And Maximus is doing this for other boards, right? Not just the OMBC, just what's their scope of coverage?
That is correct. It's mostly the healing arts boards. We see them being utilized with BRN, physician assistant board, physical therapy. It's mainly a lot of the healing boards.
Mm-hmm. Thank you for that.
Any other questions or comments from the board members? Any members of the public who are present wish to comment? Seeing none. Moderator, anybody on WebEx?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of your screen, or simply raise your hand. We'll give you a moment. All right, I see no request for comment. Shall I close the Q&A panel?
Yes, please.
Okay.
Thank you. And we'll move on to the meaty part of the agenda here. Item number 14, discussion and possible action on legislative proposals. We have Terry Thorfinson, our Administrative Services Program Manager.
Dr. Bahari, board members, public. These proposals in this agenda item 14 are divided into 2 subject areas: licensing and enforcement. The inspiration for these proposals came from research and proposals that the medical board did in preparation for their current sunset report. And the idea with these proposals is that they do potentially affect both boards, enforcement and licensing. And so I wanted to bring these proposals to the board to see what the board thought about whether you would be supportive or not about these proposals. Legal counsel has advised us that we can't take a formal vote because I don't have language before you. We'd have to do that at a subsequent meeting. The value of doing a formal vote on the actual language that's proposed is that we could weigh in the board's committee bill. that is proposing these. Some of these are appearing in the committee bill already, but not all of them, and the legislature will want to know what the board's position is on these. So I'm going to, since we're not voting on each one, I'm just going to do it as a whole. Licensing, I'm going to go through the three proposals, and then I'm going to move, we'll take questions and discussion on those, and then we'll move as a group to the enforcement. Michael, you want to add to that?
Yeah, Michael Knotes, legal counsel. I just wanted to interject. The board can do a couple things with regard to the legislative process. The board can draft a legislative proposal if the board has a thought on a change in the law that we think is appropriate. As part of that process, we would probably direct our staff to draft a legislative proposal with all of the language and everything appearing together that would then come back for the board's approval. That's when the board is proposing legislation. When there are bills in the legislature that the board is interested in taking a position on or that relate to the board's duties, the board can also take positions on the bill. The board can take a support position, a opposed position, and there's some other gradations there. What some of these proposals are legislative proposals of another board, and they're not yet in print. We don't have the ability to support legislation that another board is going to propose until that proposal is actually legislation and a bill. Just adding that along. Thank you.
Thank you.
Okay. Okay, so let's go through, before I start with proposal 1, I want to give some context and background. I did provide you context and discussion points in the memos, and that's what I'm going to be working from. But just to give the board an idea of kind of how far we've come over the last maybe 4 or 6 years licensing, is the licensure process that the legislature has changed has gone from residents could get licensed after completing 12 months of residency, and during that time they used to apply for license in the first year of residency and the second year of residency, and they had to have that license before the beginning of the third year of residency, otherwise they would not be allowed to participate. That was changed when the legislature introduced the postgraduate training license. And the postgraduate training license did a couple of things that the legislature wanted to change. One, the license itself gave the board enforcement authority from the beginning of the application through licensure for the whole training license period, which was at the time 36 months plus a grace period of 3 months, so a total of 39 months. And that also, the legislature ushered in the concept that they also wanted people that were licensed to have completed 36 months of postgraduate training and residency. And so both of those were changes as a result in the training license. That was around 2018. Okay, so then there was a change, I think in 2022, where they changed back to, if you will, allowing for completion of 12 months of postgraduate training in order to be eligible for a physician and surgeon license. Now, what was different is because now we have jurisdiction over all of the period of residency. For the board's purpose, we're kind of building a crescendo from public safety perspective to having the board that oversees the profession have the authority, enforcement authority, from the beginning when they're actually practicing medicine within the residency. That was not true before. And two, they still want the concept of having all physicians complete 36 months of postgraduate training. And that is also, I think, from the legislature's perspective, a guarantee, if you will, or a feeling that everybody would have the same kind of really deep residency training. Because what they were trying to avoid is that people that applied for the license after 12 months and didn't bother to finish the residencies, it created kind of a different population. You had the marketplace that was saying 36 months is what you have to have in order to be hired, plus now the law says 36 months, and so they tried to limit anybody that didn't do 36 months. Okay, so then in 2022, when they did the going back to the 12 months you have to complete in order to be eligible for licensure, they didn't want to get rid of the 36-month requirement, so they changed it. It's now a condition of renewal. So in renewing your license, when you're licensed after January 1 of 2022 only, anybody licensed before that, this doesn't apply to, the SB 806 then requires that they have to demonstrate completion of the 36 months of licensure. Okay, so in addition to that, it reduced the time of the postgraduate training license. It went from the 39 months to 15 months, which is 12 months plus the grace period of 3 months. And as a result, the board's seen some problems that led to these 3 proposals. So as I go through proposal 1, to extend the postgraduate training license to 36 months, what did we observe? We observed that the 15 months wasn't enough. And these people were in residency, and if they didn't obtain their physician and surgeon license, they had to cease practice in residency. And we saw a significant number of residents in that situation. And it didn't kind of make sense why they were put in that situation, other than the fact they did change the law and the time period. So we were considering this proposal that to extend the postgraduate training program back to 36 months, that would alleviate this problem where residents would be in the middle of their residency, and because they didn't get their postgraduate training, their physician surgeon license, they had to cease practice. It would give people that were wanting to get a license more time, because they can apply after they complete 12 months of residency, they can start to apply for the physician and surgeon license. For those that don't want to apply for a license, they can just continue with a postgraduate training license and then leave the state once the residency is done. Both serve the interest of, one, the board has jurisdiction over these people, and it gets rid of a maybe considered arbitrary deadline for licensure. So that's proposal 1. Do you want to discuss the proposals one by one, or you want me to go through and we'll discuss them as a whole?
I think you can cover the whole section, Terry, if that's okay, and then
Okay.
if there's any comments or concerns or any discussion, we can just take it as a whole.
Okay. Okay, so the second thing that we observed was that with the reduction of the postgraduate training license down to 15 months, some people that took the licensing exam multiple times did not pass the exam in time to be eligible to apply for the physician and surgeon license. The physician and surgeon license eligibility, one of the criteria is the exam. They have to have passed all levels of the exam. And if they're taking it multiple times, which they can take it up to 4 times, they may not have time. And so the way that the statute was written, it wasn't really clear the board had any discretion. And the consequence was very harsh, and I think unintended by all parties. And the harsh consequence is that residents suddenly had to stop their residency because their 15-month training license was up, and they could never, without that finishing the residency, apply for the physician and surgeon license until they passed that exam. So it really suddenly threw a physician's track to licensure really into disarray and just stopped it. Again, we looked at, so what could we do? And so one of the things narrowly that we're proposing in this is to allow the board to have discretion to extend for people only that are needing more time to take their exams, not anybody else, just this category of people, to be able to extend the time that they have on their postgraduate training license. So taken together, Proposal 1 and Proposal 2, Proposal 1 would extend the time to 36 months, but we did observe, and the reason we included this is we did observe that people even went beyond the postgraduate training time frame. So there was a need for the board to have some, statutory authority of discretion. But we're limiting it to only people in the situation that are not eligible at this point because they haven't done, completed the exam. And then Proposal 3 also came out of an observation as a result of SB 806 that shortened the postgraduate training time frame, is for out-of-state licensees. They are they've completed their postgraduate training at least 12 months, and they want to come to California to continue their residency. So they have the statute allows them 90 days. That wasn't enough. And so they were finding that as they came to the state, they start their residency July 1, 90 days later, they don't have their license. Okay, what do they have to do? Cease practice. Okay, so that was another kind of hiccup interruption in the idea that we wanted to have jurisdiction, we want to have them licensed, but we also want to have them continue in their residency. So the proposal was to allow the time period to expand from 90 days to 6 months. And the 6 months, so we're not just being arbitrary, is the same time frame that we allow applicants for the postgraduate training license to apply. They start the residency and they have, while they're in the residency, 6 months to apply and obtain their postgraduate training license. So this proposal suggests, why not extend that to the out-of-state people? And the rationale for the out-of-state people is that they have more complexity. They have out-of-state fingerprints rather than live scans, which are sometimes problematic, cause delays, and paperwork because they're communicating from another state also can cause delays, is to just kind of take away that stress, give them more time. The board still has jurisdiction, just like it has, because we begin having jurisdiction at the beginning of the application process. So it satisfies, and I keep emphasizing the board's jurisdiction. And the reason I keep emphasizing that is because our mission is to protect the public. The jurisdiction of the board for enforcement is our way and our mechanism to protect the public. So that's why I always have my eye on in legislation. So all three of these proposals protect the public and protect the board's public safety and relax the deadlines that are causing problems and interrupting otherwise training for physicians. So those are the three licensing proposals that we're proposing for consideration to the board, not for a vote, I guess, this time, but please for consideration if there's any interest in us pursuing them.
Ms. Mercado?
And I also, maybe if you can add to this proposal, I think, for the state of California, we've been dealing with a lot of natural disasters or weather disasters that could potentially impact a lot of this process. Did you find any findings there as to also using this as a tool to make sure that no matter what happens, people have the time to complete these requirements based on, I'm thinking weather, like we had the floods and... am I making sense? Like, I'm thinking more about, because you mentioned residents, like people living in California, they're affected by other things around them. Is this something also made to help them with these timelines, or was that not really considered?
You mean by extending it to both in-state or out-of-state?
Yeah.
Well, we could do that. That would be an easy change, recognizing, like you said, you're right. The California did get exempt in almost all the counties for filing IRS, so why not, build that in? We could do both in-state and out-of-state.
Just some thoughts there. So if we want to pursue them this week, we will have to have a vote? Is that the next step? Or
I don't think we can vote on
Not
these
today.
proposals. We could vote to propose legislation. Is that correct?
At this stage, Mr. President, the board could ask staff to draft a legislative proposal for the board's consideration at a future meeting. But that's up to the board if they want to make a motion like that.
So the language of that motion would be that we would direct the board to propose legislation matching MD Board's proposal?
Well, you direct staff to draft a legislative proposal for your consideration. I mean, part of the issue when we're looking at a legislative proposal is the board really does need the statutory language so we have a reference for exactly what the board is proposing or supporting, and if we're looking at a proposed a bill that's already been introduced in the legislature.
But it would be very similar to these proposals?
It would be, but it would give you the actual legislative language in it and be in that type of a format where you're ready to look at it and approve it as a proposal that can then go to the legislature. Normally part of that when you're proposing legislation, you propose the concept, the board reviews the language, the board adopts a motion to adopt the legislative proposal and usually gives authorization for the executive director to.
So is that redundant though to what MD Board is doing? Because MD Board is proposing changes to the legislation, correct? That's what this is. So if they produce legislation or someone sponsors legislation, that would come back to us at some point for an opposition or.
That would be the point at which the board could take a position on the legislation. So, but I think some of what you're looking at here are your staff's proposals for changes to your laws, and others are apparently proposals that were in the medical board's sunset report.
So if I could just clarify, Dr. Bahari, of the three, the first two are being proposed by the Med Board. The third one is our proposal at this point alone. The Med Board would have to make a decision on their own whether they like our proposal.
Okay, so then the motion on the table would be to direct the board to draft legislation incorporating these three proposals as were discussed by Ms. Dorfinson. Is there?
Dr. Bahari, the other option is just so that we wait, see these go through medical board, and then take the stand to make a decision at that time to support it or oppose it. I think we really were trying to just educate you on what the Medical Board of California is trying to propose, since we are very similar in nature, and just kind of introduce their proposals to you so that you have that content for future adoption of whether you want to take a position or not.
Okay.
I would also add that just timing-wise, I think I understand what you're saying, Dr. Bahari, in terms of duplicative, but legal counsel is saying you can't make a final decision without the language. So this initial discussion introduces the subject and content and expresses interest to the board and gives staff the signal, yes, we'd like to see the language at a meeting, and then timing-wise is what I would add, to be relevant in this ledge session where these specific proposals in the Med Board sunset, they're being decided now. Our August meeting is too late. If we wanted to consider language, we would need to have another meeting scheduled, potentially a teleconference meeting in June, to have a board position ready to go that we can then go to the legislature and say, this is what we support.
I mean, I don't have any objection to scheduling a teleconference to go over before the legislation is decided on. You want to do that sometime in June? I don't want to get side eye from my fellow board members for adding a teleconference to their lives. But I think it's probably a reasonable thing to do.
You know, just for additional information, my understanding is some of these proposals are already in a bill. The bill is not on your agenda, so we can't discuss it. However, many of them will probably not end up in bill format because they're being taken or accepted by the committees at the legislature. So we'll just have to see what appears in the bill and what the board wants to take on a position on or not.
So why don't we schedule a teleconference in June to get an update as to where this is at? And if it's in legislation, if it's in wording that we can review and take a position on, then we'll do so at that time.
Okay, sounds good. Okay, so let's take a look at, well, first, for any more questions on the licensing proposals? Okay. Last comment on the licensing, I think they're a win-win for everybody. So that's always feels good when you have a proposal that serves kind of a broader interest, everybody's interest. So, okay, so the enforcement, let me get it up. The memo I'm going to be looking at is 14B. Now, all of these are not only enforcement proposals, but these are also ones that are proposed in the Med Board's current sunset. And I do have to acknowledge this is a unique situation. Typically, you kind of have your own time frame for thinking about legislation, or but this time frame is kind of pushed by the fact that these are live issues that are being considered that will affect the board. And so it makes sense for us to consider them in a timely manner so that we can also weigh in. And I might add, I know there was a lot of interest in understanding the enforcement process. These proposals really give you a more bird's eye look at enforcement, because one of the big questions is, why does it take so long? These proposals are specifically geared to trying to eliminate delays and lose statute of limitations, which are huge. And if the board supported them and if they went into law, they would be a huge improvement in our enforcement. And I commend the Med Board for doing the very in-depth research. These are really great proposals. And but with no further ado, let's take a look at them. Okay, so first one is establishing a fee for a disciplined licensee seeking to modify or terminate probation or reinstate their license. Okay, as I say in the context here, all of the cost recovery that the board is potentially entitled to, determined by the ALJ in terms of the amount, covers discipline. What it doesn't cover is the petitions. And the petitions are coming after the fact, after the board has considered the case and made a decision about what the final discipline is, and it is so ordered. And in most cases, it is agreed through stipulation, so there's agreement by licensee and the board. That process is then subject to early termination, like petitions to terminate, to modify. And so they have a right to do that, but the kind of costs associated with it still involve the same thing that we expend for the original disciplinary hearing, which is you need the experts, you need the investigation, or not the investigation, you need the DAG, the Deputy Attorney Generals, to be representing the board, and you need an administrative law judge and a court reporter and all travel. So in the context of looking at the efficiencies and the cost drivers, in general, enforcement is kind of a black hole in terms of the cost. It's expensive. You know, you have very expensive people that are involved, whether it's from experts, investigators, deputy attorney generals, the administrative law judges. It is an expensive process, and the gap in terms of the expense is with petitions. This was identified as an area that the board spends a lot of money, but doesn't necessarily, can't necessarily recover it. Now, this proposal is limited to, we're not proposing, nor are we going to, be able to recover all of the costs associated, but at least some would help. So if you look at the discussion, we estimated, the board heard over the last 3 years, just to look at trends, 8 petitions, averaging $40,000 a year for a total of $117,000. That gives you a financial ballpark of what we're talking about. It's not totally breaking the bank, but you know, 40,000 here, 117,000 over 3 years, it's not small change, and it just adds up. And so if we're looking at trying to eliminate the expenses of expensive enforcement, being able to charge the petitioners a reasonable amount based on reasonable costs, it won't cover all the costs, would be a way to do that. So that's what this proposal is. The Med Board is, you know, this is their proposal. We agree it would do the same for us, even though we have a smaller caseload. And my understanding is there is some traction on this with the committee. Okay, so proposal 2, changing the evidentiary standard to preponderance of the evidence. Okay, so this one, yes, it's legal, but I've tried to lay out in the memo why it's important and how we got where we are. And if you want to look, there's a hyperlink in my memo that goes to the FSMB website that has a fact sheet on all 50 states and what they're, what they have in terms of evidentiary standards. So the evidentiary standards, there are 3. Criminal standard, you're used to beyond a reasonable doubt. Clear and convincing and preponderance of the evidence are civil standards. We're not going to deal with criminal standards in this discussion. We're worried about the civil standards. And unfortunately, the law is silent on what standard. It doesn't have to be. The legislature can put a standard for all of the, in the Medical Practice Act, for example, that says all of the actions by either of the boards would have to be using preponderance of the evidence. But in the absence of that, so that's the solution, in the absence of that, you have to rely on case law. And right now, we're stuck with case law, which I've cited in the discussion, or in the background, that says Edinger, which was Edinger v. Board of Medical Quality Assurance, a 1982 case, was put in the position of trying to evaluate a case in which somebody was suing in court to overturn the board's decision. And they found that there was a case that when the judge was wondering, well, what standard of proof should you use, the actual case turned on that. And one of the issues was the prior court had said, yes, the appropriate standard is preponderance of the evidence. But on appeal, the judge said, well, you know, there's this other case out there with another regulatory board that uses clear and convincing. We shouldn't be having more than, you know, differing standards by boards, okay? That part is true. Okay, so then are we stuck with that? No. If there was legislation proposed that the standard of proof is preponderance of the evidence, that is what we would use in our enforcement cases. Why does that matter? Well, it's a higher standard, and most of the cases that get appealed overturn the board's ruling and discipline. And so if, in that case, the standard was set to be higher, was clear and convincing, it's a harder standard to meet. So it's likely, if the judge looks at that, the board may lose cases if it gets appealed. So the board wants to minimize the amount of cases they're losing after they made their decision. Having a preponderance of the evidence would assist in that. Okay, so then I look further into why preponderance of the evidence legally versus clear and convincing. And the clear and convincing evidence is usually referred to protecting rights, individuals' rights. And what are those in this context? Well, rights are usually, like you heard in the Constitution, inalienable. You have it. You don't have to apply for it. Okay, why that's relevant here is licensees do not, when they get out of medical school, have a right to a license. They have to apply for it. They have to meet specific statutory requirements to be able to be issued a license. So the right to have that license is not an individual right. And so to have the standard for individual rights, the clear and convincing standard, is too high for our particular enforcement cases. And the right standard is the lower standard. Not that there's anything wrong with it, just the lower standard of preponderance of the evidence would match better what the law generally reserves for preponderance of the evidence cases versus a higher level of proof required to protect rights. And so legally, I think there's good justification for recommending it. It's not just self-serving for us to want a lower standard. There is some really legal justification to argue for this. And if you look at the summary of the SSMB surveys, 44 states exclusively use preponderance of evidence. What does that mean? They have it in their statutes, their Medical Practice Act, that says the standard of evidence for enforcement cases would be preponderance of the evidence. 10 boards exclusively use clear and convincing evidence standard. Obviously, it's not 100%, but only 10 boards as opposed to the 44 use that standard. And then there's varying 2 boards that use a different standard, 11 boards that vary in terms of what kind of standards they apply. So there is some evidence nationally that preponderance of the evidence is widely used and would be a reasonable request to the legislature to make. So that's the gist of that proposal. Proposal 3, enhance the medical record inspection authority. Medical records, as you may not know, because you're only dealing with the decisions and considering what the final outcome is, are the heart of evidence gathering and otherwise a case. And so there are many different factors which these proposals deal with that cause delays. When they cause delays in getting the record, it causes delays regarding statute of limitations, it causes delays in the overall kind of completion of a case. Okay, so right now, we have to ask a patient for medical consent to release their medical records, all the medical records needed for us to consider whatever the complaint is against the physician. And generally we get that, but in some cases we don't. And drug cases are one of the examples where the patient might be wanting to keep this doctor and protect this doctor because they're getting medications that they want. And so, but the board is worried because of the kind of prescribing pattern, maybe doctor shopping, that maybe this is over-prescribing, okay? So in that kind of a case, we would, if we don't get the patient's medical release, then we have to rely on a subpoena. Subpoenas take time, cost money. Some subpoenas are simpler than others. The most complex ones involve both our Division of Investigation and the AG working together to go into court and get a subpoena. But one of the proposals the Med Board came up with is if our investigators could go in and inspect the medical records ahead of time, they could at least evaluate kind of up front, is this worth a subpoena or not? And typically, when we can't get the medical records is the heart of the expert review, it's the heart of the case. If we have to fight and spend money to get that medical record only to find out there's not much there, we've now spent a lot of money on something that may not have had merit. So having an initial inspection by the investigators would help the board navigate and prioritize expenditures towards subpoenas. Because the result is, if we don't get consent, we don't have evidence. No evidence, no case. We have to close the case for insufficient evidence. So then you have to make the decision. Is it worth spending the money to get this evidence? Okay, so this inspection authority would help that. It's very well designed in the sense that it is limiting it to just inspections. The reality is that for court, we need a certified copy of the medical records. So just because an inspector gets to see the medical records, even if they get to make a copy for themselves, that copy can't be used in the investigation. We still need the official records. And those official records usually come from either a release or a subpoena. So this doesn't replace the subpoena, but it does help the board prioritize whether we want to spend the money in pursuing these medical records through a subpoena. And there is precedent that the Med Board found is that the Bureau of Medical Fraud and Elder Abuse, they have inspection authority like this. So we're just mimicking that particular inspection authority. And again, it's not giving us the right to seize records that we're not entitled to. It's just giving us a preview, a look to help us prioritize expenditures. Because one of the things that Erica has to do is decide every single case, how much should it go to formal investigation? How much money should the board expend to build a case, on any given thing? So the more information we can have to decide whether we do subpoenas or not would be helpful. This proposal would help and assist with that. And it has, the way that the medical board designed it, has built-in accountability. It requires that all of the investigators would have to be trained first. Training would be created by the Department of Justice. What they'd be needing to be trained about is how to protect the privacy, because the medical records are a privacy, document, and the process and who has access is a privacy issue. And so anybody that would be having access would need to know what the do's and don'ts are for that, so that they built in their proposal that they would have this training by DOJ created, and the investigators would have to train anybody that did it. Okay, so that is proposal 3. Proposal 4 is pausing the statute of limitations for subpoena enforcement. Any delays are a risk to losing a statute of limitations on any given case. And pausing the statute of limitations is one way to prevent that. Okay, so generally a case, the statute of limitations stops when the DOJ issues the accusation. So anytime before that, the clock is ticking in terms of statute of limitations. And even though there are requirements of compliance, those compliance is based on when a judge has ordered the person to give up the records or to comply with the subpoena. But before that order, the time is still ticking. So this proposal makes minor tweaks in that to add, if you look on page 7, to add the language upon the service of an order to show cause, which is different than an order for a subpoena. Order to show cause is, why aren't you responding? So they're trying to pick on a kind of a transaction that occurs before the final subpoena order to stop the clock for the purposes of the statute of limitations. And what it's trying to do is get away from the respondent trying to employ delay tactics that runs out the clock in their favor in terms of statute of limitations. Not a big change, but enough to sort of, any tolling that can be done for any reason. It engages at least in an attempt to get the records, but it allows for the statute to toll at an earlier point than it currently does now. Right now it's the judge's order for subpoena. This would be an order to show cause, so it would help. Okay, proposal 5, mandate additional reports to board regarding physician misconduct. Okay, so right now there's current legislation, or there's current statutes, 805, 805.01, that require different entities to report physician misconduct or conduct to the board. But the board always gets asked, is this enough? How do you know if you're getting all these reports? There's a hefty fine if people don't, but if you don't get the reports, how do you know it's not getting reported? So both the medical board and us have been asked this question at each of our sunsets. How do you know if you're getting all these reports? You know, how much conduct are you capturing by these mandatory reporting statutes? So the med board said, well, I don't know if we're, and the same thing with us. We don't know how much we're missing. Okay, so maybe we should add to the list of mandatory reporters. That might be cast a bigger net to people that would report to us about physician conduct, like locum tenens, different entities that would have potential access to physicians and know what's going on with them in terms of conduct. Because what we usually get is, if we get a report, we sometimes get a preliminary report that notifies us something's going on. The entity, hospital, or whatever is investigating. But then, if the physician leaves and the investigation ends and is not concluded, that's it. It's dead end. We don't know what happened. We don't know where the physician went. You know, we know something happened, but we don't know what. And so it just sort of ends. But somebody along the line may know, like a local TENMS or other entities that interact with physicians. So the idea is to increase the number of mandatory reporters to hopefully get more reports of physician conduct. Proposal 6, increase the wait times for disciplined licensees seeking to modify, terminate probation, or to reinstate their licenses. This is kind of a modification of what the fee was. The fee is a fee. This one is saying, you know, I think our current time frames that give licensees the right to petition early are too short. You know, if the board sets 5 years, the board expects 5 years, okay? But they can be seeing people before 5 years through the petition, through what I said, pretty expensive process. And so this proposal, also the med board, but it applies to us, is that these time frames that would allow petitioners in different categories, whether they're revoked, they have a time frame of probation of 5 years, or whatever, that those time frames in the statute should be changed. Okay, so if you jump down to the italics words in BP section 2307, you can see what the statute says. And basically, it gives the categories of a person that files a petition after a period not following the minimums, and then the minimums are listed in the subsection. At least 3 years of a license surrender or revoked, they could, except if they show good cause. 2, at least 2 years for early termination of 3 years or more, and at least 1 year they could petition for modification of a condition or reinstatement. So the non-italicized bullet points are what the suggested change should be, is lengthening the petition for reinstatement from the first one, revoked or suspended, to be from 3 years to 5 years, lengthening the petition for early termination to after they've served more than half of their probation, eliminate the option to petition after 1 year if the license was revoked or surrendered due to mental illness or physical illness, provide an automatic rejection of petitions for early termination if the board files a petition to revoke a probation while the early termination petition is pending. And for repetition petitions, the board may deny without hearing or argument any petition filed within the 3 years. So again, kind of a little minor change, but it would cut down on the number of petitions that we have during a time frame that, for the most part, the board finds is too early, you know, when the petitioners come before you. So it would save us money, save us consideration, kind of stick within the original time frames the board envisioned for discipline. Okay, so that's that proposal. Proposal 7, Addressing licensees who ask patients to rescind their medical release. Okay, this seems obvious, but believe it or not, it happens. The law doesn't address that type of situation as unprofessional conduct. It currently, if you look under my discussion, the bullet points, contacting or cooperating with the board, filing a comment with the board, or withdrawing a complaint previously filed by the board, those are the reasons that are unprofessional conduct. You don't see anything about rescinding medical consent, pressuring the patient to rescind their medical consent that they gave with the board. And so, fact pattern-wise, board receives a complaint. They initially, with that complaint, give us the medical consent to receive the records. We potentially contact the licensee, or the licensee comes to know that they have a complaint against them, one of the two, and then pressures the patient into rescinding it. So if they rescind it, then we're back to square one. We don't have any consent. We have to consider a subpoena, et cetera. So this would add specifically asking patients to rescind an otherwise already approved medical consent as an unprofessional conduct added to the list. Proposal 8, we have 11, just in case you didn't look to the end. Add a deadline to participate in investigatory interviews. Right now, the standard is like good cause. You can say, I can't schedule this interview with you, usually with the investigator, because of one reason or another. Okay, so because there's no time frame, it can go on and on and on and on. Another kind of source of delay. So what this is trying to suggest is actually coming up with a time frame. Like this interview has to happen within 30 calendar days, period. Okay, whatever the good cause, that is no longer, can't stretch beyond 30 days. I think it's striking a reasonable balance between accommodating people, it's not next day, and 30 days should be enough time to do that. And that's what this is trying to do. Again, trying to limit the delay that would cause a case and investigation to be delayed. Proposal number 9, require earlier exchange of expert testimony information. This one is suggesting to facilitate, I think, stipulations, which are what most of the disciplinary actions end up being. So they're agreed by both the board and the licensee and approved by the board. Those usually need to have some kind of review, at least for the respondent's attorney, of what the evidence and particularly what the expert review evidence is. And so this proposal is saying that the current 30 days may be not enough for all the councils to be able to review very critical evidence, expert review, because it may make them want to stipulate if they had it sooner rather than later. So this is extending. The time frame is that each council should have access to this important information 90 days, not 30 days. And saying for the interest of justice and effective litigation. And again, the gist of the benefit for the board would be to facilitate kind of an early assessment, whether there should be a stipulation or there should be a hearing. That's always the decision that has to be made by respondents and board. Do they take this to hearing, even at the cost, or is there overwhelming evidence in the case that's really not worth litigating, and it's better to just stipulate to agreed upon terms? So that would facilitate that. Proposal 10, timely access to pharmacy records. As it turns out, the time frame for us to get pharmacy records is reasonable time, which seems reasonable, but it's yet not a certain number of days nor a certain amount of time. And the observation is that it can be another source of delay, is that we ask for these pharmacy records, medical records as well as pharmacy records are very critical evidence, for both evaluating a case and evidence itself. And as it turns out, the pharmacy board has in their statute that pharmacies have to provide that information within 3 days. So why not us? So this proposal is saying, how about 3 days to replace the reasonable time frame that's vague and can cause more delays? Last but not least, require patient records to be retained for a minimum of 7 years. Seems like kind of a mundane proposal, but what it's really getting at is the fact that the statute of limitations for some cases can be as long as 7 years, but the retention records for records are 3 years. So that mismatch can undermine otherwise serious enforcement cases. And so making the statute of limitations match the record retention for physicians would facilitate gathering evidence for all cases that are within either a 3 or 7 year statute of limitations. And that's it for the enforcement proposals.
Terry, that was great. I really appreciate the detail on every item.
Thank you, Claudia.
I agree as well. It was very detailed, very clear, especially in talking about clear and convincing and preponderance. I think the way you described that was probably the best in the whole time I've been on boards that I heard, to really, narrow down the clarity as to the why of each. I think a lot of what has been discussed here are things that we're looking at in terms of efficiency of time, like what is really creating these timelines that have the public really disheartened with the process that they find their complaint in. The termination of probation, I mean, that's always just been like a pet peeve for me that, we spend all this time going through this case, we give you 5 years and you come back and to knock off that time. I mean, I don't even think that they should be able to do that, but definitely it shouldn't be in these short time frames for some things that have been really egregious. So I'm glad to see that that is on here as well. So thank you.
Great. Thanks, Denise.
Yeah, just another comment. I think having access to information, this is really eye-opening for me, because I wish we would have addressed this earlier. Just like, for example, the pharmacy records, if there's somebody's over-prescribing and there's a delay there, what more harm can they do to the public in those, 7 days or 10 days? What's our statute now? What do we give them? I know you said the pharmacy board gives them 3 days, but if we wanted access to medical records for drugs being...
They're saying the pharmacy board, when they ask pharmacies, and they're the regulatory board for the pharmacies, they can get records for within 3 days.
Right.
But because we're not the pharmacy board, our provision was just set as, a reasonable time frame, which you might, for a first time when you're trying to come up with laws and things, reasonable is always one of those good things. Good cause is also one of those good. But when you use them in your daily practice of enforcement, it's problematic. It ends up causing, ultimately, delays. So, one of the things I really was impressed, not only sort of like Denise, with the topics that the medical board did, but the idea that it takes research and time to come up with the fact that the pharmacy board only, they get their records in 3 days, Mm-hmm. They did that. That research is done for us, Mm-hmm. It's really eye-opening to me as well. And, Eric and I discussed these, we both thought, wow, these would be really good changes to our enforcement. If we could suddenly get pharmacy records in 3 days, wow, that takes away all the back and forth and why, the delay that happens with why we're not getting records, because the gathering of the evidence is very time-consuming, and it's subject to all these delays that you saw. And then the expert reviewer needs all of that, including the pharmacy records. And the expert reviewer is both before the formal investigation, where subpoenas would be, but it's also after. And so, this is early on in the investigation would make a big difference to be able to just have simple records that the other board gets. Does that answer your question?
Yes, thank you so much.
Ms. Mercado, our current statute of limitations for our cases is 7 years from the date of incident, or 3 minus 1 day, or 3 years from the date that the board was made aware of the issue. So this very last proposal, setting a standard of having the medical records being kept for a minimum, like Terry said, goes hand in hand with that requirement for the statute, and really helps enforcement staff know whether or not we will still have the evidence to be able to pull when a case is brought to our attention with a short, limited time to investigate it based on the statute. I think we can move on, Dr. Bahari, to the next agenda item. No actions required, no.
Well, do you want to do a similar, did that first motion cover both licensing and enforcement, or do we need a motion to, like we did for the last one, or what? What do we do? I can't.
We'll do the same. If there is actual language proposed, then when we review in our June teleconference, we can talk about that.
Fine. Okay.
We'll take any other comments from board members? Members of the public who are present, anybody wish to add comment or question? Seeing none. Moderator, any WebEx members of the public?
Thank you, Mr. Board President. I've opened up the Q&A. If anyone would like to make a comment, please type comment using the field in the lower right-hand corner of the screen, or you may simply raise your hand. And I do see that we have several people raising their hands. So I'll start with the first, Maria Ibarra Navarrete. You should be able to unmute yourself, and you'll have a 3-minute time limit. I'll give you a 15-second warning. So Maria, you should be able to unmute yourself. There you go, you're unmuted.
Hello, are you able to hear me?
Yes.
Okay, I am Maria Ibarra Navarrete. I'm from San Jose. I volunteer with Consumers Watchdog. My brother died tragically from medical negligence. His doctor committed medication error, which led to his death. The medical facility nor the doctor reported the never event to me, which means they never reported it to you. They are required to report a never event. I fully support your legislative proposal to change the evidentiary standard to preponderance of the evidence. I agree with the board staff that the current burden of proof is too high to protect public safety. I also agree that holding off professional license is not an individual right and that the current standard of proof is too high. 44 states use the preponderance of the evidence standard. It is time for the board to change the evidentiary standard to make the processes fair for families as well as licenses. I also fully support to add or amend the statute to require an organization that employs licenses to report to the board any employment-related discipline imposed due to a medical disciplinary cause or reason, and to require any organization that contracts with licenses for physicians and surgeons services to report to the board when a license is dismissed for service or the contract is terminated. The board must have this information available to protect us. Therefore, you need to take it into step further and post that an 805 report has been received on a license on their physician profile, so families have this information as well. Policies should be adopting we are requesting that you initiate a complaint interview before you dismiss a complaint. You need to make the enforcement process fair for both families and doctors. The processes will only be fair if the complaint or the family member is able to provide input before the complaint is dismissed. One of the problems with the enforcement process is that the lack of communication with family members. I understand that the medical board is working on a complaint notification system. You need to implement one as well. Thank you so much.
All right, the next request for comment is from Monique Hines. Monique, you should be able to unmute yourself. So there you go, Monique, you're unmuted.
Okay, sorry. I am Monique Himes. I'm from Arvin and a volunteer with Consumer Watchdog.
My grandson Malachi died tragically from medical negligence. His doctor ignored his mother's pleas for help. She didn't just seek his help once. She went to him multiple times, and he was the last doctor that could have saved her life after hospitalization. He didn't cause my grandson Malachi to die 18 hours following a postmortem C-section. I fully support some of your legislative proposals, but I have to state some facts here. Before you can think of adopting legislative priorities, you really need to talk about following your own rules and guidelines. 1, the exception to the statute of limitations for minor children. You're denying my grandson, Malachi, his complaint, the right to the exception to the statute. You have closed his complaint, actually 2 complaints. If you don't know your own rules, let me explain them to you. If an alleged act or omission involves a minor, the 7-year statute of limitations period or the 10-year statute of limitations does not begin until the minor reaches the age of majority. My grandson Malachi will never reach the age of majority. Excuse me. He died at 18 hours old. So follow your own guidelines and reopen my grandson's complaint and grant him the right to have his death investigated. Do not deny babies' rights. I also fully support to add or amend the statute to require that licensees that receive employment-related discipline due to a medical disciplinary cause, that the disciplinary action must be reported to the board, but must also be reported on the physician profile. Just like we are asking the MBC to post 805 reports of loss of hospital privileges on the physician's profile, we're asking you to do the same. Policies you should be adopting, we are requesting that you initiate a complaint interview before you dismiss a complaint. You need to make the enforcement process fair for both families and doctors. The process will only be fair if the complainant or family member is able to provide input before their complaint is dismissed. Thank you.
Next, we have a comment from Tracy Dominguez. Tracy, you should be able to unmute yourself. And Tracy Dominguez, if you see a prompt to unmute yourself, go ahead and select that. There you go, you're unmuted.
Hello?
Yes, we can hear you.
Okay. Hi, I am Tracy Dominguez, and I am from Bakersfield, and I am a volunteer with Consumer Watchdog also. My daughter and her infant son both died from medical negligence. You have no idea what it takes to file a complaint and fight every step of the way with your enforcement staff. To do it is just to do this job, to review these complaints and to move them in investigation. It's a nightmare. It is emotionally and physically exhausting. It is like experiencing their death all over again because it is a death of their rights. Although I fully support your legislation proposal relating the 805 reports, and I need to require and the need to require the hospitals and the institutions must report disciplinary actions against a doctor. You must also post disciplinary actions on the physician's profile when it comes to a loss of a hospital privileges. Although these issues are important to me for personal reasons, I completely agree with my fellow advocates that you are not following your own guidelines and proceeds that you must do this first. You know and I know that this board is required to prioritize your complaints so that all death complaints are referred to an investigation. You know and I know you are not doing this and it's not happening. I know this because your prior executive director told me personally that he would accept my grandson's complaint if I would write it to him stating that I wanted all new staff, a new DAG, a new set of eyes on his complaint and his case. He made this promise to me without telling me that my grandson's complaint did not move for 3 years. Had you followed your own complaint guidelines, my grandson's complaint would have gone to an investigation, but it didn't. How many babies have you denied an investigation? Thank you.
All right, the next comment is from Xavier De Leon. And Xavier, you should be able to unmute yourself. There you go. Xavier, you're unmuted.
So my name's Xavier. I'm from Bakersfield and a volunteer with Consumer Watchdog. I'd just like to emphasize again that you guys aren't following your own guidelines and procedures. You guys are denying babies' rights. Adults have the 7-year statute of limitations, but minor children have an exception where their statute of limitation does not go into effect until they reach the age of 18 years old. You guys have denied my son this, and he was only here for 18 hours, so he's not even going to be able to make it to the 18 years of age. You've also denied an 8-year-old little girl for the same reason. So can you please reopen my son's complaint and grant him the investigation that he deserves? Secondly, the DCA complaint prioritization guidelines that you're required to follow. You guys need to send, when the death complaints, we need to have an investigation, which you guys aren't doing. My son's case sat in your guys' lap for 3 years and didn't move. That's 3 years of just nothing, no justice for my son. And we're here on these meetings fighting for their voice. My son was a human being. He wasn't a fetus. Even though he only lived 18 hours, his life mattered, just like everybody else's family members' lives mattered on this phone call. So please reopen his complaint and move his complaint forward with the investigation as it is required by the board. Thank you.
All right, the next request for comment is from Michelle Montserrat Ramos. Michelle, you should be able to unmute yourself. And you're unmuted.
Good afternoon. I am Michelle Montserrat Ramos, and I am with Consumer Watchdog. Some of the proposals you have listed in your report are the same proposals that we advocated for and supported in NBC meetings. We fully support changing the burden of proof to preponderance of evidence, as 44 other states already have in place. In many of the NBC complaint closure letters, it states that the case was closed because the burden of proof was too high to meet. As you mentioned in your meeting materials, we have to place a focus on public safety. There is at least one physician that has multiple open complaints in your enforcement process right now that at one time had up to 6, possibly 7 open complaints against the license. If you have 6 to 7 open complaints against a license at one time, that should signal a problem to you. If changing the burden of proof will move these complaints along and save some lives in the process, then you need to make this legislative policy a priority. We also support additional reports to the board regarding physician misconduct. This is truly a concern if you do not know if physician misconduct is being reported to you. There have been licensees that have lost hospital privileges at multiple hospitals, and their patients had no right to know this. We support the addition of any organization that employs a doctor to report to the board any employment-related discipline imposed due to medical-related issues. We also call on the board to post when an 805 report has been received linked to patient care on the physician profile to provide this information to the public as well, such as loss of hospital privileges. If a hospital or medical institution has lost faith in a physician to a point where they do not trust them to care for their patients, then that is information that the public should have the right to know. Lastly, I completely agree with my team that this board is currently not following its own guidelines and procedures. Under the laws relating to the practice of osteopathic medicine, you are required to follow the DCA complaint prioritization system that would require you to forward all death complaints and serious bodily injury complaints to investigation, and you are not doing so. Also, we know that you are denying babies and minor children the exception to the statute of limitations for minor children. We are putting this on the record that this board is not following Business and Professions Code 2230.5D. If you as a board does not know this, you do now. Now we need you to take action and call for a review of why your board staff is not
15
following this complaint
seconds.
prioritization and why this board is also not adhering to Business of Professions Code 2230.5D. Thank you.
All right, this is the moderator, and I see no further requests for comment. Shall I close the question and answer panel?
Yes, please.
Okay.
We will go ahead and move on to agenda item 15, the legislation report. For discussion and possible action on proposed legislation, Terry Thorfinson, our Administrative Services Program Manager.
Thank you, Dr. Bahari, members of the board and the public. I'm going to be referring to the memo when I'm talking about these bills, which provides a summary, but it also has the light hyperlink to the actual piece of legislation in the title. So the first one is SB 544, Laird, Open Meetings Law. And so if you click on SB 544, you can see the language. The summary of it is the issue with the open meetings is the current framework that we're operating meetings under for this meeting ends as of June 30th. And so the legislature only created this kind of hybrid arrangement that, among other things, allows for only one site to be public, and attendance virtually can happen at other sites without necessarily listing them on the agenda like was required before COVID. So the thing that's really good about this is that it basically extends beyond 1 year with no sunset date the current system of the hybrid, which I think is serves the interest, kind of like the win-win concept, is that it both serves board members in terms of increasing the convenience of attending meetings. You have the option of either attending in person or virtually. You don't have to post when you're virtual, don't have to post your location, which I think in the past was a problem. And then members of the public, excuse me, let me get something to drink here. For members of the public, open meetings access that was required to be in person was really not facilitating public participation, because it's much cheaper and more convenient as well for the public to participate virtually than in person. So the fact that Senator Laird has stepped up and proposed this legislation, all of the boards in DCA and DCA was strongly shopping this bill and supporting it. We have a strong author, and he does, in the intent language, identify the benefits of this new system in that it'll save boards money, it'll increase access of public participation, which was the purpose of open meetings laws. And so it serves all of those purposes, and he does not have a sunset, so when this gets signed into law, this will be the new way of operating open meetings. And so for that reason, I think the board has, in the past, supported in-person as well as having the option for virtual. This bill basically facilitates what the board has in the past said they support. It supports the current rules that we have, but they end in June 30th of this year. So I would recommend, since there's such a value to this board and how they operate, that it's worth taking a position and supporting in favor of the author, signaling that our board is also in support of this bill.
I'd like to make a motion to support the bill as it is written. We have a second, so we'll take a roll call vote. Any member discussion first, and then public comment, of course. Thank you.
It's just a comment. I think it is really important for the public to be engaged, and I do appreciate every comment from the public, so I support this motion.
Okay. Any members of the public present want to comment on this proposed legislation? No? Moderator, any members of the public on WebEx?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment on this agenda item, please type comment using the field in the lower right-hand corner of your screen, or simply raise your hand. We're displaying instructions and we'll give you a moment. All right, I see no request for comment. Shall I close the Q&A panel?
Yes, please. Thank you.
Oh, you're welcome.
Okay, now I would like to make a motion to support the legislation as written. You already did. Now let's vote. Roll call vote. Oh. Roll call vote, Machiko.
Corey Damian.
Aye.
Dr. Buhari.
Aye.
Claudia Mercado.
Aye.
Andrew Marino.
Aye.
Dr. Patel.
Aye.
Denise Pines.
Aye.
Motion carried.
Okay, we'll continue.
Okay. Can we show the memo that I'm reading off of on the screen?
I could, Terry, but the problem is the memo doesn't move along with me.
Oh, okay.
They would have to move it themselves, so
Okay, I'll just keep referring to it then. Okay, so the next bill is AB 1707, Pacheco, reproductive health adverse actions out of state. This is a result of the current climate with in response to the Supreme Court overturning Roe v. Wade in the Dobbs case, and the increased number of states that are creating bans and for different actions, reproductive in nature and also gender related in nature, and they're basically kind of prosecuting patients in some states and prosecuting doctors in some states. And in the pre-discussions, I think, there was a work group created with the governor's office and the legislature trying to brainstorm bills. And one of the areas that there was a concern about is that if other states have these laws that would outlaw, for example, providing abortion services, maybe even birth control, and gender change, gender affirming, gender change types of treatment, that they would be prosecuted in those states, but they could also be licensed in California. And generally, in our enforcement, if another state takes an enforcement or disciplinary action, it gets reported, and then we, if they're licensed in our state, we get that report and then open an investigation and stuff. The other thing with applications, if somebody applies to be a physician and then we look at their prior disciplinary, experience, again, a discipline for something that would otherwise be legal in California would be problematic. So this law was trying to head off this new reality and stop the California in specific having to be caught up in trying to either open investigations, deny licenses based on actions that are otherwise legal in this state. And so that's what this bill is trying to do, is shield physicians and the boards from having to make decisions, enforcement and otherwise, based on adverse actions in other states. Now, this is limited to, narrowly construed to, prosecutions and adverse actions related to laws in that state that are legal in this state. Okay, not all, it doesn't just change all adverse actions. So anything that's illegal in this state and in another state, yes, we would still continue to do open investigations and proceed accordingly. This is only to deal with the fact that we now have very hostile conditions in some states that will then put our licensees that are licensed in California and other states in this predicament that in California, when they come to California, all the stuff they've been doing, regardless of whether it's lawsuits or prosecutions, wouldn't have been an issue for California because they're doing stuff that's legal in California. So there was discussion and that there would need to be some legislation to deal with it. This is what this bill does. We're recommending a support on this. I think it would help in protecting California's reproductive rights positions, and it would protect physicians from getting ensnarled and forcing California to take actions they wouldn't otherwise take action. And because the law says it, there's no discretion. So anybody deciding not to take an action is not going to be dinged because they decide not to. The law would be clear in this.
Any questions or comments from board members?
Just to clarify, where is this bill currently at? So this is getting support, and it's going to be heard in August?
This bill has probably been heard in the first house, so it'll be going to the second house in July to be ending the session in August.
Michael Knotes, legal counsel. I just, as you were speaking, I looked it up. This bill made it out of the Appropriations Committee in the first house on May 10th.
So it still has to pass the House.
The floor of
The floor, yeah.
Okay, I would like to make a motion to support this bill as written.
Second.
It's been moved and seconded, so can we take comment from the public? Any members of the public present who wish to speak? Seeing none. Moderator, any members of the public on WebEx?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to talk on this agenda item, please type comment using the field in the lower right-hand corner of the screen, or simply raise your hand. We are displaying instructions, and we'll give you a moment. All right, I see no requests for comment. Shall I close the question and answer panel?
Yes, please.
Okay.
And then we'll take a roll call vote.
Cora Damian.
Aye.
Dr. Buhari.
Aye.
Claudia Mercado.
Aye.
Andrew Marino.
Aye.
Dr. Patel.
Aye.
Denise Pines.
Aye.
Motion carried.
Okay, next bill, SB 345, Skinner, Reproductive Services Legal Protection for Boards and Physicians. This bill is kind of a companion bill, only deals with boards in terms of, and the governor, in terms of cooperating or being forced to cooperate with out-of-state subpoenas and prosecutions and expedite people to an out-of-state lawsuit. This bill tries to provide a shield for, again, another issue that was raised in this work group is that executive directors could be brought into out-of-state lawsuits through subpoenas that are subpoenaing some kind of record, could be discipline, I don't know what other information they would be asking for. And the executive director would then have to be in the position of deciding, which would be discretionary, whether they would comply with it or not. And they may not feel comfortable with not complying. So the idea that the law would be clear to say that they wouldn't have to comply if it's for an action that would be otherwise legal in California, kind of the same theme as the last bill, is that the governor could refuse these actions, and executive directors could refuse to cooperate in only situations where the lawsuit and the subject of the lawsuit would otherwise be legal in California. So a different turn. First one that we supported was kind of focused on physicians. This one is focused on boards and a little bit of physicians, but it's all related to actions that are illegal in another state, and they're trying to compel California or its executive officers or others to participate and provide information to an outside state lawsuit for a subject that would be legal in California and is illegal in that state. And I'm recommending a support on this for the same reason. It does fix kind of an outstanding problem.
Terry, for the record, can you just please verify which bill we're talking about? I think on the agenda we have it listed as AB 1369, but is it SB?
SB 345.
345. So there's a correction that we need to make to the agenda.
Okay. Can we make that?
All right, so
Michael Canotes, legal counsel. I'm looking at the agenda for the meeting, and I don't see this bill on the agenda. I see A through D.
It's listed under the watch bills, Michael, under section F.
I see. Thank you.
Yes. We just need to move it up to the section on the legislation portion.
Okay, so any questions or comments or from the board members?
It's SB 345?
SB 345. In the appendix, the agenda item is there, but on the agenda itself, it's listed in the informational bills watch list. Okay, any members? I make a motion at this point to support the bill.
I'll second.
Okay, so any members of the public that are present wish to comment? Seeing none. Moderator, any members of the public on the WebEx wish to comment?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of the screen, or simply raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Shall I close the Q&A panel?
Yes, please.
Okay.
Thank you. Let's take a roll call vote. Machiko?
Cora Damian.
Aye.
Dr. Buhari.
Aye.
Dr. Mercado.
Aye.
Andrew Marino.
Aye.
Dr. Patel.
Aye.
Denise Pines. Motion carried.
Okay, we'll move on to AB 1369.
Okay. AB 1369, Bayer Khan, telemedicine out-of-state licensure exemption. This bill amends a section of BMP code that defines the scope of practice for physicians, BMP code section 2052, by adding a section 2052.5. And basically what it is asking for, and if you click on the hyperlink, you can see what the actual language of the bill is. It's creating an exemption to the Scope of Practice Act that requires licensure for any physician out of state to be practicing medicine with a California patient. This bill is proposing that a telemedicine doctor that is licensed from another state be able to provide telemedicine to patients in state. And it gives a few specific examples for what those conditions are. The foundation for telemedicine has two prerequisites. Physicians providing care to California-based patients must be licensed in California. That's one. Conditions that were allowed to be provided through telemedicine were conditions that the standard of care would not require the physician to see the patient in person to diagnose or treat or recommend treatment. Those are basically the foundations behind telemedicine and creating it. This bill violates both of those. The two requirements were put in place to protect public safety and patients from being treated through telemedicine. Both requirements are at the heart of protecting public safety. Technically, the bill amends 2052 by adding the section, and that's the scope of practice. We also have a telemedicine section, but they did not choose to amend that section. By adding the proposed language that they're adding to 2252.5, the new section, it's essentially adding both a scope exemption and an exemption from the requirement that to practice medicine in California, one must be licensed to practice in California from their respective regulatory board. It exempts them from being criminally charged for unlicensed practice and fined up to $10,000 of imprisonment not to exceed a year. One of the scope changes that this bill proposes is to allow these out-of-state licensed telemedicine physicians to provide care for life-threatening conditions, which is currently prohibited and beyond the scope approved for telemedicine to provide. This dramatic scope expansion is not only a red flag, but it's also a significant threat to public safety. Life-threatening conditions require an in-person treatment, not a video chat level care. Life-threatening conditions are when a patient are most at risk and would open them up to being victims of negligence, precisely because the telemedicine physician is unable to provide the immediate level of care for a life-threatening condition. As mentioned above, this bill amends 2052, not the Telemedicine Act, which is BNP Code Section 2290.5. That telemedicine section sets standards for telemedicine, should be the logical place or choice to amend. Instead, the author is choosing to amend the bill that defines the overall scope of practice for physicians in California. The choice of amending this in the scope has a more sweeping impact on creating a blanket exemption to licensure and expanding scope of what would be allowed to be provided through telemedicine would be if they were currently amending just the Telemedicine Act. The sweeping scope change and facts alleged as justification for this bill are suspicious. The sponsors claim it is for California-based patients with life-threatening conditions, too sick to travel, not enrolled in a local clinical trial, that have patient physicians consent to care from an out-of-state, to allow an out-of-state physician care through telemedicine. If they are being cared for by a California licensed physician locally, why does the patient need to connect to a telemedicine physician out of state? Why does the patient need telemedicine if they have a local physician who's caring for their condition? Why does the bill make sweeping changes, scope changes, in requiring licensure telemedicine for a limited population of patients? There is no requirement that the telemedicine physician have expertise in the condition being treated, nor that the patient needs to be enrolled in a state or out-of-state trial. If the condition were enrolled in an out-of-state trial, the bill doesn't even require the telemedicine doctor to be providing actual care related to the clinical trial or even be in the same state as the clinical trial. The facts are neither compelling nor make sense for otherwise requiring telemedicine licensees to be licensed in California when caring for California patients. The fact that this bill allows telemedicine doctors care without being licensed would mean that they are not regulated by the board. The board would not have enforcement jurisdiction over them for purposes of pursuing disciplinary actions to protect public safety. This exemption would prevent OMBC and MBC from protecting patient safety. Patients harmed by these unlicensed out-of-state telemedicine physicians would have no recourse against them civilly or criminally or otherwise because the harm occurred in California and no entity in California has jurisdiction over these unlicensed state physicians. This would open a huge loophole in protecting patient safety and regulating physicians who provide care to patients in California. And it's worth noting and emphasizing that licensure is not simply an administrative hassle for physicians to practice medicine in California. Licensure requirements are set by the legislature to protect public safety and ensure competency and avoid fraudulent licensure, so every patient can feel confident that they are being cared for by a competent physician. Licensure is the mechanism that provides the board with enforcement jurisdiction to investigate and bring disciplinary actions against physicians who violate the law. Without licensure, there is no regulation of physicians who are allowed to practice in California without a license, and there is no recourse for the patient harm against an out-of-state unlicensed physician. Patients are left unprotected by this bill. The lack of requirements and restrictions in this area are out of step with the way California typically handles out-of-state business. All of the state businesses, in a business context, provide legal jurisdiction through registering for the Secretary of State. So in the event of a lawsuit, out-of-state businesses can be sued for business conduct in the state. To protect public safety in healthcare, the law must provide a legal connection to the state, and that is licensure. And this bill denies that. I'm recommending oppose.
I'd like to make a motion to oppose it.
Second.
Okay, there's been a motion and second. Any members of the public present want to comment? Seeing none. Any moderator, any members of the public on WebEx wish to comment?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment on this agenda item, please type comment using the field in the lower right-hand corner of the screen, or you may simply raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no request for comment. Shall I close the Q&A panel?
Yes, thank you.
You're welcome.
The motion on the floor is to oppose this change in the law. Let's take a roll call vote.
Corey Damian.
Aye.
Dr. Buhari.
Aye.
Claudia Mercado.
Aye.
Andrew Marino.
Aye.
Dr. Patel.
Aye.
Denise Pines.
Aye.
Motion carried to oppose.
Okay.
Okay, last bill, AB 765, Wood Physician and Surgeon's Title. This bill started out as kind of a benign bill. The author's intent was to clarify the fact that lots of titles and references to physicians, I think probably mostly like specialist names, you know, that are other than doctor, are out there and nobody knows, is that a real title or what their licensure is or whatever. So this bill was an attempt across more than just physicians professions to say these are the titles that are valid and are subject to needing to be licensed. Okay, so we had net gains in this bill because osteopaths and doctor of osteopathy wasn't in the bill or in the statute. So having additions of DO and doctors of osteopathy, osteopathic physicians were great. But the original version of the bill had the word osteopath in there. And then suddenly it got amended out. And the comments related to that were, let's have a discussion about whether this name should be protected, what they call title protected, osteopath. No question about the other one, but just the word osteopath. And particularly with referencing to non-licensed physicians, like the wannabe osteopaths. Who are those people? They're foreign-trained osteopaths. And the context, in delving into the, what the impact of this bill has, even though it's trying to clarify confusion for consumer or remove confusion, it creates confusion by removing osteopath, because in the evolution of the osteopathic profession, osteopath used to be the name that people used. And for the U.S., an osteopath is synonymous with doctor, period, just because of the training. But nowhere else in the world is that true. Every other country does not include allopathic training alongside and inclusive with osteopathic training. So nobody else is essentially can call themselves a doctor anywhere else, okay? So foreign board osteopaths maybe didn't do the research when they moved to this country. They're foreign trained. But when I looked into the foreign training, there's no standard regulation in any of these countries for what the training is. And so you have a foreign trained, potentially unregulated person coming in here wanting to use the word osteopath. And there's no infrastructure to regulate them because they're unlicensed, to oversee their competence. There's no CMEs, there's no exams, nothing, because we only support osteopathic physicians. So the amending this out and it allows potentially non-licensed osteopathic, foreign-trained osteopaths to use this name. And it would open the door to questioning, like, would the board be able to tell these unlicensed osteopaths, if they're left out of the bill, stop using the word osteopath? The answer would be no. We would not be able to do that. What would we be able to do is, as I list here in the italics, BMP code 2459.5, kind of esoteric, but basically it lists the scope of practice for an osteopath to include osteopathic manipulation that can only be done by a licensed osteopathic physician, period. Can't even nobody else can do the diagnosis, the treatment. It's got to have the direct and immediate supervision of the osteopath. So it makes clear that the osteopathic manipulation as a modality is reserved only for licensed osteopathic physicians. These these foreign-trained osteopaths are using osteopathic manipulation. So the board used to, before this bill, be able to say, you can't use the word osteopath and you can't do osteopathic manipulation. Now this bill calls into question, can we tell them not to use the word osteopath? I think not, unless this goes back in the bill to be title protected. So I did some more research. Do we have anything in the BMP code that would protect the title? No, we do not, other than the section that is the scope. The AOA has policies on the title, the use of the word osteopath, and the gist of their policy is that osteopath is a former term that has evolved into osteopathic physician, and that osteopath is reserved still for the family of osteopathic physicians to be used in informal conversation and in informal reference. But it's still reserved, according to the National Association, to be part of the osteopathic physician profession. And so this bill, in not protecting that, would violate that. What does it do beyond that? Well, it creates confusion, which is what the opposite of what the bill was trying to do. It allows unlicensed osteopaths, foreign trained, to use the word osteopath, and potentially it limits the board's ability to fix this, because now you'd have a legislative intent showing that osteopath maybe wasn't title protected, because they actually took action on that issue. Okay, so the only fix we would have, either now or in the future, would be statutorily. So this is kind of a central bill to both the profession and the board. The board's interest is not in protecting the profession, it's in protecting the public. So what is our interest? It's enforcement. This bill, in removing osteopaths, makes our enforcement harder for this. So for that reason, we would like to oppose, unless amend, this bill in terms of a position where we would be open to signaling to the author that there's a concern by the regulatory board that oversees this issue, but we're open to negotiating with the author. And we have been in conversation with the author and committee staff about this, And so the next step would be to take an official position that we can then have further conversations about. Without an official position, we can't go further than the conversations we've already had.
So are you suggesting we take a position of oppose with specific amendments to?
Not specific, just that we're, the position, you know, the range of positions that Michael said, there's a gradation. There's support or oppose, and then the kind of in between is you can support if amended or oppose unless amended. The choice in the between the if amended part is the support means that you really like the bill, but you need a few little tweaks to get there to totally support it. And oppose unless amended means that there is something in that bill of extreme concern that does need to be changed and that you're open to removing your opposition if it's amended. So it's a tone difference. But you know, for the board in deciding what position to take, you're trying to come up with what position reflects the board's feeling about this, you know? Are you alarmed that this is being done? That would be in the oppose. I'm recommending not just a straight oppose, but an oppose unless amended, as opposed to a support if amended. But the board could do any of those four positions: support if amended, oppose unless amended, straight oppose, or no position at all.
If I may jump in the conversation, Erica Calderon here. Enforcement-wise, it doesn't limit our enforcement. I want to clarify that we can pursue action against unlicensed activity of the practice of osteopathic medicine. I guess the main concern here that we're worried about is the advertisement and creating a sort of a deception to our consumers. You know, when they advertise themselves to be an osteopath, very similar to advertising themselves, closely related to osteopathic physician. So I want to clarify that we can pursue unlicensed activity. We would have to look at it on a case-by-case basis. But here, the main issue is deception when it comes to our consumers. When they see this advertisement, do they believe that they're going to get service from an actual physician? That's the main concern here that at least board staff and enforcement has.
This is Claudia. I'm looking at the bill here, but it starts by mentioning the Medical Board of California. So in this case, if we're another board, why wouldn't the Osteopathic Medical Board be included at the beginning of the text? Is that part of the big issue?
Yeah, that's one of the issues. I mean, there's a lot of places the Osteopathic Board should be included in,
right?
Including in the bill there. The bill talks about, as you're right, the medical board, but then later on in the bill it gives the list, a paragraph of all the different types of valid titles that require licensures and are still valid, and we're in there, but yes, we're not with the medical board, and that is kind of unfortunately a theme in the legislature, is that we're often left out of bills. But because of the construction of the Osteopathic Act and the Medical Practice Act, that mostly, and not in all cases, what becomes law in the Medical Practice Act also applies to us, unless we have a section specifically in our act that determines the outcome of a particular subject or action required.
Yeah, because my concern is this bill, or I guess the author, are they aware that we exist, right? You've been talking to them, they know we're a board, we're licensing DOs, and somehow I'm just perplexed by the fact that they left us out. Like, what is the intention of elevating the medical board and not elevating the Osteopathic Medical Board?
I think it's an unintended consequence or intention. They really don't know much about osteopaths. I face this every legislative session, that the bill doesn't, and actually I asked Michael, do we really have to follow this piece of legislation if we're left out and not specifically called out in the statute? And in most cases we do, even if we're left out. And it's just, you know, the legislature doesn't know about the osteopathic profession or physicians. So they leave us out of the bill.
So would it be good for us to make a motion to oppose it until we're recognized as a body of the state of California now for how many years?
That's what I suggest.
I mean, how many years has this board been operational, just for the record? Since what time?
Yeah, you know, I normally would.
22? Did I hear that correctly?
Yeah.
So it's taking 100 years for the state to recognize? I think there's a problem there with the author not even acknowledging that. I think the author needs to have a history lesson and acknowledge, you know, our efforts in making the state great.
Yeah.
Uh-huh.
I mean, I would certainly make a motion to oppose unless amended, as opposed to support if amended.
Okay, so the difference is, I understand and sympathize, Claudia, with the oppose and Denise with the opposed sentiment, because yes, after 100 years, we should be automatically put in statute. But we're not. That's the reality. The politics here are some powerful authors, some of which could have some control over the board when it goes through sunset. And so the little tone difference between oppose unless amended can make a big difference in conveying in the public discourse a position and a strong concern with facts without trying to insult or otherwise disrespect a powerful figure, if you will.
And Claudia, I don't think about this disrespect. It's just, I think it's about politicians being servants and understanding that this is a part of the state of California.
I want to clarify, the bill actually does recognize osteopathic physicians in it. It's just they're removing osteopath. There's a section in the bill where it's listing anesthesiologists, cardiologists. That's the portion that's been amended. So they are recognizing osteopathic physicians early on in the bill, but down below, that's where the term osteopath was removed. So just to clarify that, and I just to help out in ease in the decision making.
Yeah, I think that's the main concern, is that word was removed, and that creates confusion. And if they reinserted that in the language, I think we could support it. So I would make a motion to oppose unless amended in that fashion.
I'll second.
Okay, we have a motion and a second. Are there any comments from members of the public that are present? Seeing none. Moderator, any members of the public on WebEx wish to comment?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment on this agenda item, please type comment using the field in the lower right-hand corner of the screen, or simply raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Shall I close the Q&A panel?
Yes, please.
Okay.
We'll now have a roll call vote.
Cora Damian.
Aye.
Dr. Buhari.
Aye.
Claudia Mercado.
Aye.
Andrew Marino.
Aye.
Dr. Patel.
Aye.
Denise Pines.
Aye.
Motion carried to oppose unless amended.
I'd like to just make a follow-up comment for Claudia's purposes. If you look at the text, Claudia, that you're talking about, now that I'm looking at it, it's in the intent language, which doesn't become law. In the actual statute that does become law, that's where we are mentioned. So yes, your point is absolutely on point, but it's not part of what will become law. It could be something conveyed to both, committee staff and others, which I try to do every time I have contact with them to include them in the analysis. But thank goodness it's intent language, not actual statutory language. Okay, great. That ends the bills that are recommended for positions. The next item I was not planning on going over. It's just informational bills. The purpose of having an informational bill list is to give you an idea what's out there. They're not necessarily urgently needing our support or positions, but each year, especially from a physician's perspective, there's a lot of bills and subjects that may not be ones that you want to take positions on that will affect your practice and affect, what requirements you have to follow. So I try to have a bigger list so that you're aware of these bills and can follow them and look them up, and we'll be following them as well. So I'm not going to go over the watch list. So that would conclude, unless you have any questions, the bill legislator proposals.
Any questions or comments from board members?
Yeah, Michael Kenotes, legal counsel. Just for members of the public, when we go to public comment, there are a lot of bills on that information watch list that were on our agenda, so you can comment on any of those bills on the agenda.
So any members of the public that are present wish to comment? Seeing none, I'll ask the moderator, are there any members of the public on the WebEx who wish to comment?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of your screen, or you may simply raise your hand. We are displaying instructions and we'll give you a moment. All right, I see no requests for comment. Shall I close the Q&A panel?
Yes, please.
Okay.
Thank you. We'll move on to agenda item 16, the Intergovernmental Relations Reports and Administrative Services Update. And this is, do we have Judy Bucchiarelli here? Ah, wonderful. Our Staff Services Manager, Board and Bureau Relations with the Department of Consumer Affairs. Thank you.
I always like to try this nicely instead of blasting you out here. Can everyone hear me okay? Perfect. All right, good afternoon, and thank you for allowing me the opportunity to provide the Department of Consumer Affairs update today. In honor of Public Service Recognition Week, which we celebrate this year on May 7th through the 13th, I'd like to begin my update by thanking the board members and dedicated board staff for all of your hard work. DCA will kick off this important week with a department-wide appreciation email to staff and other messaging to highlight the essential work that DCA employees do every day. We are grateful for your service. Next, I'd like to inform you that DCA's printing provider is currently experiencing technical difficulties, and as a result, the printing of many of the board's renewal certificates, licenses, and letters is delayed. Printing interruptions began on April 13, 2023. DCA is working closely with the printer provider, and at this time, the estimated time of restoration has not yet been determined. DCA shared messaging with the impacted boards, and until the issue is resolved, licensees should be encouraged to take advantage of online services. DCA will continue to provide updates as more information becomes available. Moving on, I'd like to provide a diversity, equity, and inclusion update. Established last fall, the department's DEI steering committee is comprised of 12 executive leaders from the boards, bureaus, and the department, and has been working on many items, including updating the strategic planning process, training, and the development of an informational DEI fact sheet, which was distributed to board leadership. The strategic planning process has been updated to embed DEI into the process, which includes a survey, DEI section in the environmental scan, video messages, and a brief training video. DCA's solid team will be reaching out to the executive officer no later than the end of June to discuss a plan to update or develop the board's strategic plan. In addition, all DCA solid trainers will be completing a 50-hour diversity, equity, and inclusion training certification program through the University of Massachusetts. On April 28th, Director Kirchmeier issued a memorandum on DCA's commitment to employees to increase the availability of DEI courses through DCA's Solid Training Unit. A DEI section has been added to the homepage of the Learning Management System, which I'll refer to as LMS, and employees can access and register now for 3 courses available in June of 2023. Over the coming months, additional courses and educational information will be available. DCA's first Diversity, Equity, and Inclusion fact sheet has been released. It was developed as an informational tool and includes the department's 3 DEI initiatives, memorializes DCA services that support DEI efforts, and includes DEI terminology as it applies to DCA. Tomorrow, the DEI Steering Committee will hold its quarterly meeting in person and will elect a chairperson and vice chairperson. The committee will also discuss training, strategic planning, and DEI activities through the end of the calendar year, as well as a membership composition and processes to expand membership. As the DEI Steering Committee's work continues, I look forward to updating you in the months ahead on their progress. Equally important, I'd like to remind you that there are 2 DCA-wide mandatory trainings for 2023. This includes sexual harassment prevention training and information security awareness. All DCA employees and appointees, including board and advisory council members, will need to complete the sexual harassment prevention training this year. Board members must take the 2-hour supervisory training. This training is required every odd year and is online, self-paced, and takes approximately 2 hours. Board members with an assigned DCA email are also required to complete the Information Security Awareness Fundamentals training. This training addresses everyone's role in protecting DCA data and information. The training is online and required each year. Both the sexual harassment training and information security awareness training are available in the department's LMS. For more information, a mandatory trainings page has been created to help members identify, access, and track specified trainings. The page includes direct links to mandatory trainings, as well as pertinent information and policies specific to these training courses. Go to dca.ca.gov and click on the DCA Board Member Resource Center page under Require Board Member Training. You may also reach out to Board and Bureau Relations Chief Deputy Melissa Gear or Assistant Chief Deputy Yvonne Durantes for assistance. As a reminder, the next board member orientation training, also referred to as BMOT, will be held on June 20th. Board members must complete BMOT within 1 year of their appointment or reappointment. On June 20th, BMOT will be offered in person in Sacramento and again on October 10th at a location to be determined. Members can register for this training via LMS. As the fiscal year comes to an end, I'd like to remind you to please submit your travel expense claims as soon as possible, but no later than 5 p.m. on Wednesday, June 8th. Claims submitted after this date will still be processed. However, they will not be paid until July of 2023. If you have any questions regarding travel claims, please contact Melissa Gear. As you are all aware, legislation passed last year amending provisions of the Bagley-Keene Open Meeting Act to extend the ability of state bodies such as DCA's boards and bureaus to conduct public meetings virtually through July 1, 2023. Absent the passing of new legislation to extend these provisions, DCA boards and bureaus will not be allowed to conduct meetings virtually after July 1, 2023. DCA is aware of the legislation recently introduced, which removes certain teleconference requirements from the Open Meeting Act. The bill was recently amended to do the following: require members of a state body participating remotely to disclose whether any individuals 18 years of age or older are present in the room at the remote location and the general nature of the member's relationship with those individuals. Require state bodies to end or adjourn a meeting upon discovering that a means of remote participation required by the bill has failed and cannot be restored. This bill does not include an urgency clause and would not take effect until January 1, 2024. Boards and bureaus should be prepared to conduct public meetings in person in the interim beginning July 1, 2023. Next, I will share some information about the federal portability law. On January 5th, 2023, a new federal law took effect that enables service members and their spouses who hold professional licenses in a different state to practice in California within the same professional discipline and at a similar scope of practice if they are required to locate to California due to their military orders. Since becoming aware of the new law, DCA has been collaborating with agency on best how to implement the law. DCA will share information as it becomes available. In the meantime, should your board receive an inquiry from a service member or spouse regarding this new law, please contact DCA Legal Affairs. Finally, DCA submitted its 2021-22 annual report to the legislature, and the report is now available on the DCA website. This annual report includes a new design and additional reporting metrics such as military licensing data now required for all DCA boards and bureaus. We hope you will take the time to review this impressive compilation of the valuable work of the boards and bureaus. And this concludes the DCA update, and I welcome any questions from the board.
Any questions from board members?
Can you specify a little more about the federal law? You mean for the active military members, if there's an emergency and they have to practice medicine here in California, they would be allowed to do that without contacting the board first, or is there a process?
No, they will have to contact the board first, and direction right now, if that does happen, I would expect that the executive director will reach out to legal affairs.
We, Erica Calderon here, we met briefly about this, and right now DCA is looking at how we can keep track of those individuals. We will be required as a board entity to keep track of them as they're coming in. They're also, we're also required to take enforcement action if needed. And one of the requirements is that they have to have a license out of state in order to come, and we will have to be reporting that information if we do pursue any action to their licensing boards out of state. So it's really preliminary in the stages, but we are in discussion with DCA on how we're going to work together because it is affecting all the healing boards and non-healing boards that are, under the Department of Consumer Affairs umbrella. And so as a collaborative effort, we're kind of looking to see how we're going to implement some kind of data tracking, portal that we can all access.
Thank you.
Okay. Any members of the public have questions that are present or comments? Seeing none, any moderator, any members of the public on WebEx?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of your screen, or simply raise your hand. We'll give you a moment. All right, I see no requests for comment. Shall I close the Q&A panel?
Yes, please.
Okay.
And thank you. We're going to go ahead and take a quick, like a 10-minute break, okay, and then we'll have a presentation coming after that with the last agenda item. Okay, gaveling us back in. After the break, let's do a quick roll call.
Gloria Damian.
Here.
Dr. Buhari.
Here.
Andrew Marino.
Present.
Dr. Patel.
Here.
Claudia Mercado.
Present.
Denise Pines. Here. You have a quorum.
Okay, we'll continue with item number 17 on the agenda, which is a presentation discussion on Black maternal health in California.
Wait.
Oh, did I miss something?
I mean, Renee, I love it.
Sorry, this B. Sorry, I apologize. I jumped the gun. It happens. And it's so well laid out in my script. Item number 16B, the budget update. I have Renee Milano from DCA's fiscal office. Apologize.
Has to be green?
Yep. Is that? Perfect. Hi, everybody. I'm Renee Milano. I'm the budget manager that oversees the Osteopathic Medical Board. And today I want to thank everyone for allowing me to present the budget unit section on item 16B. First and foremost, I know there were some initial materials that didn't have all of the information due to an ADA compliance transition issue. I hope that everyone does have an updated copy, and they've also been able to update on the website the materials. So I'm hoping everybody has those updated documents. I did also provide printed copies as well. So I'm hoping everybody has that, and I'll be presenting on those materials today. Page 1 is going to be our expenditure projections. They're based off fiscal month 9 actuals, and based off of those, we're now currently tracking about $1.5 million projected in personnel services, $2 million projected in office operating expenses and equipment, and about $3.5 million in total expenditures for this fiscal year. On page 2, you'll find the revenue projections, and this again is based off of fiscal month 9 actuals. And in that, you'll see we're projecting about $3.3 million in revenue this year, and about $99,000 currently in reimbursements. Page 3 is going to be your fund condition statement. It's kind of the meat of the fund. And on this, you're going to be able to track the overall projections of the health of the fund in our out years. To start, we read left to right, top to bottom. So you'll see our actuals in 21-22 begin at about $5.2 million, which includes a $93,000 adjustment, which is a beginning balance adjustment. So that gives you a starting balance in 21-22 of $5.2 million. With that, you also collected a revenue of about $2.93 million. And based off of that revenue and your actual expenditures of about $3.2 million, that provides you a end balance of $4.5 million. With that, you kind of progress into your current year, into the next fiscal year, and begin your balance at $4.5 million. Currently, based off of fiscal 9 FM fiscal month projections, we're projecting $3.3 million in revenue, and you'll just see that displayed there, and about $3.4 million in expenditures. That gives you a projected current year balance, ending balance of about $4.2 million. And then again, that will carry over into our budget year of 23-24. Now, those will be based off of our governor's budget projections, and you'll see that beginning balance of $4.2 million. Revenue was projected at about $3 million, and then we had an expenditure projection of about $3.4 million. With that, we project a beginning balance of budget year, or an end balance of budget year, about $3.6 million. And all of our out years are projected with a 3% growth. That's just based on standard increases, salary and wages, all of those kind of things. So we build in a 3% overall growth, and we do project revenue as stagnant. This gives us a very conservative approach of a fund condition, and even with all of that, you'll see in 25-26 we are projecting a end-of-year balance, or a revenue months in reserve, of 6.4. So that gives you 6.5 months essentially where if the board isn't accruing any additional revenue and continues expenditures as projected, they can still sustain their activities. Now, that's just an overall overview of the documents that we've provided, but I'm also available for any questions, and I just want to thank the board for the opportunity.
Thank you. Any questions or comments from the board members?
I have a question. This is Claudia. How does the state budget affect our board in terms of like there being a deficit or a surplus in budget at the state level?
Absolutely, and we are having discussions about that in regard to the general fund. This is considered a special fund, and so while it is its own self-sufficient funding, we do appreciate when our boards and bureaus take a conservative approach and consider the fact that our general fund is having those concerns. However, there's no direct necessary impact. We just want to be very conservative in that approach because the general fund as a whole is also taking a conservative approach.
I guess there's no real concern with our board based on what you just presented, right? If we stay conservative, bring no money, we can still survive for 6.4 months. That's what you're saying?
In 25, 26.
Yeah, projecting into the near future, okay.
A couple years out, that is the current projection. And I will say there are no immediate concerns. I apologize. I usually end with that to appease some of the questions, but we have no immediate concerns at all with the funding.
And I guess one follow-up, when it comes about, supporting our staff, and let's say we wanted to add more staff because we see an increase in licenses based on our efforts, how are we going to get support for that? Do we just go find our own money to support our staff members, or if we're having a good year, do we come to you and say, hey, we need more money?
That would be something we would start initial conversations with and work with the board on developing. We do have some budget change proposal discussions that are early in the works, likely regarding that additional employee or support that the board is looking towards. And that's something we work with our boards and bureaus on, especially in regards to future years, if there's a potential fee increase necessary, anything like that. And we do keep a very open dialogue with all of our programs to make sure that we keep that consideration as we go forward.
Thank you, I appreciate that.
I think one of the things for us to maybe look at in the future is doing an analysis of other state osteopathic boards and what salaries look like, what amount of staff looks like. Last week was the Federation of State Medical Boards annual meeting, and I met with several other states who have like a fraction of our licensees, but they have maybe 15, 16 employees. So we should look at whether or not we have not really been operating at the level that we should be operating at, considering what's happening across the country. I could be wrong, but I think it's something for us to look at, and maybe that might be something as a future agenda item that I say at the end.
Any members of the public who are present wish to comment? Nope. Moderator, any members of the public on the WebEx who wish to comment?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment, please type comment using the field on the lower right-hand corner of your screen, or simply raise your hand. We're displaying instructions and we'll give you a moment. All right, I see no requests for comment at this time. Shall I close the Q&A panel?
Yes, please. Thank you. And thank you for your presentation. All right, now we'll move on to item number 17, which is a presentation discussion on Black maternal health in California. We have Ms. Pines, one of our board members, and David Rainin from the Department of Public Health, California.
Great.
I think we're going to start our presentation with a video clip. Is that correct, Ms. Pines? Would you like us to go ahead and do that? Thank you.
I mean, the biggest misconception is there something that we are doing? There is something inherently wrong with our body, our makeup, our genes. There's something that we're eating. There's some ways that we are behaving, that somehow these bad habits have put us in a situation for poor maternal health outcomes. And there's nothing that we are doing that is so different than anyone else in this country. The perfect storm is Black women who are dying during pregnancy because of underdiagnosed conditions Black women who are dying during childbirth because they are ignored when their concerns are heard. Black women dying in the postpartum period because they do not have ready access to physicians when they experience postpartum complications.
Baby actually moves with you. They're moving in there with you, okay?
It's not something that we're doing that's any different from anyone else. I really prefer to just say, hey, call it what it is. It's racism. Racism is killing us, right? Your heart can't take it. So we literally die from broken hearts.
They're just doing like a rotation and they're just like trying to find a lock and key, trying to get out of this way, like, you know.
White people say that all the time, that they don't see race. I've never, ever heard a person of color say that in all the years that I've been alive. And so it's obvious. It's something that is 100% weighing on the minds of the families and the community that I serve. And so not acknowledging it does harm, because it's almost like gaslighting an issue that is not okay.
Unfortunately, there was a state senator in a southern state who said, you know, maternal mortality isn't so bad if we don't count Black women.
Louisiana, about a third of our population is African American. African Americans have a higher incidence of maternal mortality. So if you correct our population for race, we're not as much of an outlier as would otherwise appear.
If that was not an illustration of implicit bias, I don't know what ever could be.
Ms. Pines?
So that was just a short clip of a 90-minute film that I produced that aired on PBS on April 10th across the country in response to the CDC's report that revealed some years ago that Black women were dying at a rate of 3 to 5 times or 4 times white women. And that's just the general number. If you go into particular communities, even in New York, that number can be 20 times as much. And so when I heard that statistic as a filmmaker, I just felt like I really couldn't believe that. I personally did not know any Black woman who had died from complications or had experienced any adverse events as they were going through the process of maternity. But I knew that lots of women did exist. And as I started doing this work and traveling the country, because we went to about 4 cities to tell the story, I realized that this is an epidemic that happens to Black women, that they're almost lucky if they survive through the healthcare system. And so dying during pregnancy, dying during delivery, dying 18 months postpartum is just unacceptable in a country where we spend the amount of money that we spend on healthcare. And when you think about birth, a lot of us just simply think like, oh, women just can have babies, that's really easy. We really sort of think that. And so we don't think that this is possible. But it is, it's possible. And it's not just happening to Black women. I always say that, you know, whatever happens to like the general population, that Black people is always exponential for them. So if you solve for them, you actually solve for everyone else. And so I wanted to be able to tell the story to the way I see filmmaking. I always do social justice films. So the way I see them is so that they're usable tools, so that whoever is the watcher of it either is creating awareness, looking to create an awareness, oh, I didn't know that this existed, or those inside of the problem creation sort of can identify themselves and see what it is they can do to change. So a couple great things is happening with this film outside of, it broadcasting nationally around the country. We showed it at the UN in Geneva. I'm in talks with the White House right now for it to be seen by the First Lady. But we are working with AACOM, so they're the accrediting arm of the osteopathic schools, to make this film a mandatory of one of their 10 modules that they have around health equity. So that's one thing. So this now will get medical students. Last week when I was at the Federation of State Medical Boards, the Federation creates CME programs, and one of the officers overheard me talking about the film and came to me and said, we want to turn this into a CME. So this is filmmaking, honestly, at its best, right? This is not just, oh, that was sort of nice, but now we can actually create impact. I'm also partnering with the AMA. We just created shorter clips, so we pulled some footage out where we had a lot of physicians and CEOs of hospitals talk a little bit more frankly. And so we have a 12-minute clip for clinicians and a 12-minute clip for healthcare administrators. So as the Dobbs decision puts more women, across the countries, especially in particular states, into an already broken system, we're going to see these numbers become exponential in a very short period of time. The unfortunate part that I see about regulations that get passed that doesn't have money attached to support what is going to come into the system is just bad legislation, right? That's just bad legislation when you make decisions like that. So this film, shines a light on this complex issue, right? There's no one answer to it. Yes, it's racism. Yes, it's how the medical system is designed and how things are reimbursed. It's, hospitals that don't have enough resources to even keep their OBGYN departments open. I sit on a hospital board that their maternal ward almost was closed. And the people in that community would not have had a place to go if they didn't get bailed out, honestly, from philanthropic dollars. A lot of times we see, when I look at the easy answers, some of the easy answers is, doulas as advocates for these women, or more midwives. And those are answers, but those aren't the only answers. I think one of the biggest challenges is that physicians do not listen to these women at the most critical point of which they need to be heard. During these really critical moments, they don't have wait and see days. They have maybe wait and see moments, maybe wait and see a few hours. That becomes that critical when there is a complication. So that's what this film does. It's called Birthing Justice. People can still see it. It's streaming on PBS right now. It did really well, so a lot of them are rebroadcasting it in this month and in June. So I wanted to bring this issue. I'm also talking at the Medical Board of California in August, and I'm talking with a couple other boards in the same exact manner for us to recognize that this is a problem, that this problem exists within the healthcare system, and it does exist within, directly aligned with physicians. So thank you for the opportunity to be able to talk about it and show a small clip from the film. And now we're going to have a representative from the Department of Family Health, David, come and speak and present on what's happening specifically in our state. Thank you, David.
We good?
Either one works.
Okay. Everybody can see and hear?
Yes.
All right. Great. Thank you for your patience there. Thank you for this opportunity. Good afternoon to the board. I'll be sharing information about maternal mortality and morbidity in California, looking at some of our data and some actions we're taking with respect to those data. After seeing that amazing video, and I've seen the full 90-minute version, it's incredible. You all should watch it. I do want to remind you all that while I'm talking about numbers, these numbers represent real people. And so when I talk about cases or deaths, we're talking about really tragic events, and we cannot continue to be okay with that. So, let's see, how do I'm having trouble advancing.
You should see it. This is the moderator. You should see an arrow at the top of your screen that you can, if you're looking in WebEx.
Oh, thank you. Thank you. Thanks for your help. Yeah, so sorry about that. Just quickly, our roadmap for this afternoon, I'll be talking about maternal mortality and morbidity, defining some terms, talking about our surveillance and quality improvement efforts. Also, going over what actions we're taking programmatically. I'll provide some contact information, and time permitting, we can have some questions and discussion. I want to start with maternal mortality, and there's a QR code there. If you want to scan that with your phone, it'll take you to a landing page where there's a whole lot of additional information from our division on maternal mortality. And I want to start by acquainting you with some terms. There are two terms that I'll be referring to quite regularly, maternal mortality and pregnancy-related mortality, and I want to differentiate between the two. So if you look at this figure, the circle, the dark blue circle that corresponds with the dark blue rectangle, that's what we generally refer to as maternal mortality. And this is a measure that's in wide use. It comes from the World Health Organization. It's also used by the National Center for Health Statistics. And what it is, it's a statistic that describes deaths during pregnancy and up to 42 days after the pregnancy ends. And these are deaths related to the pregnancy itself. So that's a very commonly used metric. States report it. It's reported nationally. It's reported internationally. You hear it on the news. But I have to tell you, it's a little bit of an unreliable measure. There's some underreporting in places. There's overreporting in places. And so what we in California are trying to do, and this is following the federal government at the CDC, is we're trying to have a better accounting of maternal deaths. And so that takes us to the pregnancy-related mortality. And that is that medium blue circle that's just above the maternal mortality circle. And what this represents is deaths during pregnancy and up to 1 year after pregnancy that are related to pregnancy. But how we get there requires us to look at pregnancy-associated mortality, which is that grayish circle, the largest one. And that is deaths due to any cause up to 1 year after pregnancy. So what we do is we assemble the pregnancy-associated cases, and we go through a process to determine which are pregnancy-related. Again, that's a better metric, pregnancy-related mortality, than conventional maternal mortality. And so I'll be referring to those two and drawing a contrast to try to just let you know that there's some issues related to reporting, and we have to all be aware that sometimes the problem is even worse than what gets reported. Just to show this a little bit different way, this is a tabular form where it talks about maternal mortality on the left, pregnancy-related mortality on the right. Again, the time frame for the MMR is up to 42 days postpartum, whereas for the PRMR, it's up to 1 year postpartum. The data source for maternal mortality is death certificates only, and again, there's some reliability issues there with data quality. And then we define it using those data with ICD codes. In contrast, the better measure, the pregnancy-related mortality ratio, utilizes many different sources of data, vital statistics files, including birth, death, and fetal death data, hospitalization data, medical records, coroner and autopsy records, and all this information is gathered together and fed to an expert committee, which then does the determination of pregnancy relatedness. And so, again, these are the two measures that are in use. The maternal mortality ratio is widely used, but there are some reliability issues. So you'll be seeing from the data I present the pregnancy-related mortality ratio, which is a better accounting of maternal deaths. So I'm going to tell you how we arrive at that pregnancy-related mortality ratio. We do that through surveillance, where we're looking at the burden of the disease. We're trying to describe, how it impacts our population. And our surveillance, which is done through rapid cycle reviews, is referred to as the California Pregnancy Mortality Surveillance System, or PMSS. And it was initiated in 2018, again, to provide a timely and accurate pregnancy-related mortality data. The first deaths that were reviewed were from 2008, and to date, since 2018, we have done rapid reviews of over 1,000 deaths. Again, because the ratio is, the maternal mortality ratio, rather, it's based on death certificate data, and it's not reliable. We in California had some underreporting, and I'll show you some data on that shortly. Perhaps some of you are familiar that Texas, in contrast, had some overreporting. So you can see, in terms of the direction and the magnitude of the deviation from the true number, it varies from place to place. So PMSS aims to identify the cause and timing to death, to determine if the death was related to pregnancy, and so therefore it serves as an efficient method for maternal mortality review with sort of enhanced methodology. The other thing it does is it informs our in-depth reviews, and our in-depth reviews I'll talk about momentarily, where we really get into some of the causes and prevention opportunities for these deaths. Schematically, this is what PMSS looks like. You can, if you start at the upper left corner with the death records, what we do in California is we do linkage with birth records and fetal death records. But of course, not all pregnancies result in a live birth or a fetal demise that has a fetal death certificate issued. So we also look at patient discharge data, emergency department data, ambulatory surgical center data, as well as some information that is on the death certificates. And with all that linkage and those sources of information, we develop what we call a pregnancy-associated death cohort. Within that cohort, we look at pregnancy status, and we look at timing relative to the end of the pregnancy. And then we validate that information by using coroner reports and medical records, which we procure. That's in the center there in that green rectangle. Below that, in that light blue rectangle, you can see some of the exclusions. Those are exclusions based on the standard methodology, again, following the federal government's lead through the CDC. Once we have that pregnancy-associated death cohort, we share that with our expert review committee, and that review committee then determines pregnancy-relatedness to say, in fact, yes, these pregnancy-associated deaths were related to pregnancy. Others turn out to be not pregnancy-related or unable to determine. But once we know those pregnancy-related deaths using this methodology, that forms the data for our surveillance. The other thing that does, in addition to describing the burden, is it informs our quality improvement efforts. And so what we do, instead of rapid cycle reviews, where we're only looking at cause and timing and pregnancy relatedness, we do in-depth reviews where we look at much more information to determine causes and quality improvement opportunities. And that in-depth review process is a program we call the California Pregnancy Associated Mortality Review, or PAMR. PAMR is set up to prevent pregnancy-related deaths and to eliminate racial, ethnic, and other health inequities. It aims to identify pregnancy-related deaths, their causes, and preventability. So that's the enhanced part of this, their causes and preventability. We also look at contributing factors and prevention opportunities at many levels, including the patient, provider, facility, and system levels, but also more broadly in the community level. Again, we're looking at deaths out to a year postpartum. So at some point, the postpartum visits typically go 6 weeks. Women are dying much longer than that, and from causes related to pregnancy. And so we need to engage the community and see what services and what assets and resources are available to serve these women, so that as we create real change, when these same kinds of circumstances arise in the future, lives are saved rather than lost. So again, we're working to improve maternal health outcomes. PAMR was established in 2006 after observing a rapid increase in maternal mortality. So we said we can't we can't be okay with that, so we have to figure out what's going on. So the first deaths that were reviewed were from 2002. Since that time, we've done multiple phases of PAMR. 3 completed phases have resulted in over 600 deaths being reviewed by different expert review committees. The first phase was obstetric and medical causes. Then we shifted over to pregnancy-associated suicide, and we switched gears once again most recently and completed an obstetric hemorrhage review. All of these were statewide, and again, over 600 deaths were reviewed. From some of those early reviews, we took the information that emerged from the review process and worked collaboratively with Stanford University to develop some maternal quality improvement toolkits. Perhaps some of you practitioners are aware of them. There are toolkits related to CVD and hemorrhage and hypertension and sepsis and a few others. And so, again, this is kind of a data to action approach here. Currently, with PAMR, we have 2 committees that are ongoing. One in Southern California, which is a population-based review of obstetric and medical causes of death. And secondly, we began a review committee focused on COVID-19. So these are pregnancy-related deaths from COVID-19. To date, with these ongoing 2 committees, we've reviewed 120 deaths so far and counting. So for the in-depth reviews, we're up over 700 reviews. And again, as I mentioned earlier, with the rapid cycle for surveillance purposes, we're over 1,000 reviews. So because we employ these, we impanel these committees, they're voluntary. We have these different review committees, both the rapid cycle and the in-depth. We have expertise from clinicians and from community members. And as you can see here, it's a broad range of expertise because we recognize that there are many opportunities, many leverage points for change, many services and many resources that are required to really create real change here. And so we're drawing on the expertise of all these individuals. When we go through the committee process, there are several guiding questions. For both the rapid cycle and the in-depth, we ask, was this death pregnancy related? And what was the underlying cause of death? For the more in-depth review, where we want to know sort of the drivers of these deaths and what can be done about it, we ask, was the death preventable? What were the contributing factors to the death? And we ask these questions at the patient, family, provider, facility, system, and community levels. We have begun utilizing a health equity framework and using a lens where we ask, did discrimination contribute to this? And that's been very interesting, enhancement to our work. And then because of COVID-19, since 2020, we've been asking, did COVID contribute to the death? And then finally, a guiding question for the committee is what specific and feasible actions might have changed the course of events? In other words, what's a leverage point for change here? Ultimately, we take this information, we look for emergent themes based on the deaths in the aggregate, and we work with the committee to develop specific and actionable recommendations. Again, the idea is data to action. And our recommendations take the form of who should do what and when. And again, we're concerned about all levels, from patient and provider through the community. And we're also concerned not just within the childbirth experience or the early postpartum period, but all the way out for a year postpartum. So, having now described the committee work that we do, both rapid cycle and in-depth, I'm going to get into some data here, just so you can see some of the numbers. And again, as I mentioned, remember, we're talking about real people here. So this first slide with data, this does show the MMR. Now remember, I described this as being an unreliable measure, even though it's widely reported. And a couple things I want you to take away from this first graph is when you look at the purple line toward the top of the graph, you see that the United States maternal mortality ratio, the trend line over time, has been on an upward trend, has an upward slope. It moves around a lot because maternal mortality is a relatively rare event. And so a few deaths 1 year more or less will cause the trend line, the slope of that line to shift a little bit. So the first point then is that at the United States level, the MMR has been having this upward trajectory, especially in this most recent 3 years, where you can see the slope of that line going up quite rapidly. If you look at California's MMR, that's the lighter blue line with the triangle markers. Number one, it lies below the U.S. line. In about 2008, that's when we started our work. But I have to just caution you that I told you earlier that that these data were a little unreliable. There was some underreporting there. So when you see that lower valley there, around 2013 to 2017 or so, we know for a fact that there was some underreporting going on. But as you can see, in recent years, there's this upward trend. So again, these are not that reliable, but you see these in the news, you hear about these, and so what I want to do is just put out that cautionary note and instead share what we refer to as the gold standard data, the PRMR. These are better data. Again, you can see the California line, which is the blue, below the U.S. line, which is the purple. I do want to make a note that these are not perfectly comparable because the methodology used at the national level is slightly different than the methodology used in the state of California. What we do here is we use a few more reporting sources so we can capture more deaths. We also employ these committees, as I've mentioned, whereas at the federal level, they use a couple of medical epidemiologists, not a full committee. Again, slight methodological differences, mostly comparable, but not exactly. As you can see, it's mostly a slight increase until what is the pandemic. We have seen maternal mortality go way up in part because of the pandemic. If you look at the 2020 data point, the 18.6 deaths per 100,000 live births is what our true data point is. If we wanted to, or because we were curious about COVID, what impact that had, we removed those just for a comparison data point. You can see that it goes down to 15. So that's, sort of a harbinger, perhaps, of what we're going to see in future data because of the pandemic. So it's even more reason to double down on what we're doing. If we look at pregnancy-related deaths by cause, you can see the number one cause is cardiovascular disease. About half of those are cardiomyopathies. Hemorrhage is number 2, infection is number 3, and as you can see in that horizontal bar, 3% of those were COVID. But keep in mind that this is these horizontal bar charts are for 2012 to 2020, so those COVID deaths were only 2020. That's how much that's impacting infection as a cause of pregnancy-related deaths. When we look at these same causes by timing, this is important when you think about what are our intervention points, where can we make a difference. So the darkest blue is during pregnancy, the medium blue is during delivery and early postpartum, and then we get into the grayish color is the up to the 6 weeks, and then beyond that, the light gray all the way to the far right, that is that represents up to a year's time. So if you look at CVD, for example, you can see that a third of the cases happen, after the usual postpartum checkups are over at 6 weeks. So that's a key piece of information. In contrast, if you look at hemorrhage, you see that 3/4 of them are happening at the day of delivery or shortly thereafter. And so that's a different point of intervention. That's more in the clinical setting because that means that this highly at-risk situation is still under the direct care of medical professionals. Because we are concerned about social determinants of health, we utilize the California Healthy Places Index. Perhaps you're familiar with that. It's a way to sort of gauge the health of communities, taking into account a number of things, including neighborhood characteristics, educational employment data, other social determinants, transportation, a whole series of data. And what that does is it will classify a given geographic area as being advantaged or not, And so we represent these data along 4 quartiles. And what you can see over these three time frames, the pregnancy-related mortality ratio was lowest in the most advantaged. And that's kind of common sense, but it's really good to see this quantified. And you can see that this has not changed over this, the span of time here. And in fact, when you look at the most recent data, the most advantaged, the data point is 9.2. In the least advantaged, it's 18.9. So just where you live, nothing else, there is a twofold increased risk of death from maternal mortality. And so that's something we have to think about. It's not just what's happening in the clinical care of these individuals, it's what's happening in the community. And that's where we can also work to create change. This gets at some of what was discussed in the birthing justice video. These are the disparity ratios between Black birthing individuals and other racial ethnic groups. Across these 3 time periods, you can see that the red vertical bar here, which represents Black birthing individuals, is just by far and away much higher than any of the other groups. I mean, it's startlingly higher. Earlier on, it was about a 4 to 5-fold difference. In 2015 through 17, it actually went up. The disparity was 5 to 6 times. And it has narrowed slightly. The most recent data suggests 3 to 4 times. This is not unique to California. We see this across the nation. And again, watch that video. There's so much good information in that about this very information. And we just can't tolerate this. I want to shift gears a little bit to maternal morbidity. Severe maternal morbidity is the measure we use. It's a composite measure. It comprises a wide range of pregnancy complications that result in significant short or long-term consequences to a woman's health. So she survives, but she has severe consequences. The CDC developed the definition, which includes 21 hospital discharge procedures and diagnostic codes that indicate a potentially life-threatening condition or complication. So some of the diagnostic codes include sepsis or kidney failure. An example of a diagnostic code would be, a procedural code would be a hysterectomy. So we track this using discharge data that we get from the state of California, or for the state of California. And what you can see in this trend line over time is that since 2008, there's been a steady increase up through 2020. In fact, while it looks like a really sort of gradual increase, if you look at the magnitude, the 2020 data point is 104.4 cases per 10,000 delivery hospitalizations, which is more than twice what it was in 2008. The leading indicators, as you can see here in these horizontal bars, the first one is DIC, which is abnormal blood clotting. Secondly is sepsis. Third is acute kidney failure. Acute respiratory distress syndrome is next, and then hysterectomy, which is a procedure code, narrows out the top, finishes out the top 5. Again, with the disparities, we see that the non-Hispanic Black rate is above and consistently above the rates of the other racial ethnic groups. In fact, as of 2020, the SMM rate for Black women was nearly twice that of white women. This is an alarming gap, and it continues to persist. At the same time, severe maternal morbidity is going up for all groups. It also varies geographically. We can see here a map of California's counties where the darker orange color represents a greater burden of severe maternal morbidity. And as you can see, several Northern California counties had rates above the California average. Those include Humboldt, Sonoma, Napa, Yolo, Sacramento, Alameda, and Santa Cruz. So that's kind of the committee work we do, the data we track. And so as I come to a conclusion here, I want to just give you a glimpse into some of the programs and services we do within MCIH. We have kind of two buckets of programming. One is related to infrastructure and capacity building. And you can kind of glance over those for yourselves. I'm not going to go through any detail in those. But the other kind of bucket of programming, and these are a little more germane to this conversation, are the programs and services for vulnerable populations. And specifically am going to highlight the bottom two there, the Black Infant Health Program and the Perinatal Equity Initiative. First, the Black Infant Health Program. This is a program that has two kind of complementary models that run concurrently. There's a group model where Black birthing individuals get together, and they go through various curricula and and they work on different strategies together. And then the other part of it, the other complement, is that there's individual sort of coaching type of life planning where a given individual will be working with a case manager to complement the group model activities. So it's kind of a two-pronged approach, and it's very effective. And those who are eligible are 16 years and older, they're pregnant, or up to 6 months postpartum at the time of enrollment, and it's regardless of income, so anyone can participate. What we see from this program, which by the way has been around more than 3 decades, is that participants report having a better understanding of effective strategies to manage and address stress. They have stronger positive connections to their heritage and to the Black women in their community, and they have increased empowerment to make behavioral changes that lead to healthier lives. So Black Infant Health, I believe it's operating in 14 counties that represent 90% of the Black births in California. A few years ago, to augment a lot of the work that was happening in BIH, the Perinatal Equity Initiative was launched. This program serves BIH communities in need of additional supports, including doula services, group prenatal care. There's a fatherhood or partner related services. There's pre and interconception care services, midwifery, and provider training related to respectful care. And so through PEI, which is relatively new, we're tracking Black women with full-term pregnancies. We're tracking fatherhood participation in both prenatal and postpartum. We're tracking access to mental health services. And finally, we're tracking doula involvement and relationship with the medical personnel. So some good work going on in response to the data. Always we want to have science driving the programming that we do so that it's evidence informed. Beyond MCAH, Maternal Child and Adolescent Health, where I work, there are other CDPH programs that promote maternal health. This is not a complete list, but I wanted to just lay out some of these programs. These are collaborators of ours in our division. And then finally, just note that other departments, for example, Department of Social Services, Department of Healthcare Services, they also, of course, work to improve maternal health. Contact information is here. I also want to encourage you to use the QR code to get even more information. I want to highlight that Karen Ramstrom, probably some of you know her. She is a DO. She is our Chief of Maternal and Infant Health, and so she is heavily involved on the program side. And thank you. One more QR code. This is for data dashboards. If you're a data person and you want to get more information on a lot of health status indicators related to MCAH, that's the place to go. So thank you for your attention, and if there's time for questions or discussion, I'm open to that.
Hi, this is Claudia. Just wanted to point out that the QR code, I think you have to give us permission.
I have to give.
It says the QR code campaign has been disabled for.
It may be our Wi-Fi. I don't know.
Oh, the Wi-Fi.
Okay. So those of you who have the slides, when you're on your own, away from the networks here, maybe.
We can try that.
But thank you for a great presentation.
Yeah, that was a very nice presentation, and thank you, Denise, for bringing this forward. I think these are very important topics, and hopefully the goal is to improve these outcomes, but you have to bring them to light first. Quick question about the data. What's the lag time on the data collection for some of these things?
So that's a great question. It varies based on how rigorously we are, we call it sleuthing, you know, how rigorously we're going after the data. A number of our sources of information come from hospitalization data, which are reported through its Healthcare Access and Information, formerly OSHPED. And those data take a little bit longer than some of our vital records data. So there's some lag time built in there. Additionally, when we have to procure medical records and coroner reports, that varies by the person providing. You know, the coroner system in California is, you know, different. Some are sheriff coroner, some are, you know, pathologists. It's just, it varies. So the personnel varies, the process varies. But that's not really a answer to your question yet. I'm just saying why it takes.
That's why, yeah.
What our goal is to be able to fully review a case, going through all those processes I described within 2 years of the date of death.
Mm-hmm.
So provided that we can get access to all that information, which is out of our control, we can request it, but getting it, you know, so, but generally we hit that mark pretty well.
Okay.
So 2 years after the date of death. So.
I just had a question. So is it like a case of negligence from multiple people that are providing health services to African American women? So it sounds like it's the system that's failing us, not individuals? Or is it a combination of individuals and system that seem to not be doing the right thing?
I mean, I'm sure Denise has a better answer than I, but I can tell you that what we see in our data, it's at every level. It's, you know, it's a provider, it's a facility, it's a system, it's the community, it's, you know, it's even, you know, in some cases, it's even family, because, I mean, it may be, you know, we did a review on suicide, right? And so there's a lot going on within a family where the end result is a pregnant woman being, you know, brought to the point of where she wants to take her own life. I mean, there's a lot going on there. So there are all sorts of points at which, you know, there's room for improvement, or, you know, the other side of the coin, there are failures. So no, it's not right to just focus only on one level, one layer. There's so much going on here,
yeah.
Which feels a little overwhelming, but at the same time, I think it kind of broadens our perspective, so we realize there are many opportunities to intervene. So we have to recognize that, and we have to work accordingly. And I'll ask, you know, Denise if she has more on that than I do, I'm sure.
I think, I mean, to, you know, really say it simply, I think that these women, Black women, are just absolutely not valued.
Mm-hmm.
So if you're not valued, it doesn't matter what point of the spectrum you're being impacted, right? You're just not valued. And so I don't do anything extra. So we don't improve the facilities of where they're going. The doctors don't listen, or, you know, or become dismissive. The reimbursement is so low, you can't get quality doctors to serve in the areas where these women are, right? So it's, you know, so to David's point, it's not just one thing, it's just like so many different points. And as you heard, they've had programs in place for, what, a decade? And the numbers are still staggering, right? So that, you know, we have seen a little bit of improvement in this state when, you know, a large coalition had got together through partnerships with Stanford, and we were starting to see people like recognizing, the hospitals recognizing, the community seeing what it needed to do and to help, physicians looking at their role. But then, you know, something kind of came unglued along that process, and we started seeing the numbers go up. I think just before COVID, like we were looking, going, hey, what's happening here in 2018, 2019, and then COVID, and it sort of took the, sort of the light off of this for a little while.
Yeah, because I guess my first impression was, how does the media also play into this epidemic like you described it? And I think this idea of like the strong Black woman, right? If you're complaining because you have pain, somebody just says she'll be all right, right? This, I think at a national level, it's a matter of national security because you're putting people's risk because the media is portraying them to be strong and brave, but we all are human beings and we all need health care the same way. So I don't know if that plays into it when you talk to the White House, but I think at a national level, we got to change that image because it affects all of us. I mean, just my thoughts.
I think just the fact there's much more discussion in the media now. This has been going on for over 30 years. These numbers have been going up. They've been really, really high for a very long time. And I probably would say that we first started seeing articles come out about this maybe 4.5 or 5 years ago. And then there's just been more and more and more. And, doing films like this also helps to elevate that. There's another film out called Aftershock, where it looks at what happens when these women die. The baby survives, and now, what was a family unit is no longer a family unit, and what is, sort of the aftermath, so that you can understand what happens when you, like, we see this, David started off by saying that I'm going to refer to these numbers, but these are humans. What happens to that human and that human's family and that community that that person was a part of? So we just have a lot of loss that ends up happening.
Just final another comment. I was reading that in terms of the medical system, it's not a good investment to invest in, you're talking about infrastructure and medical facilities for children, like Children's Hospital, for example. I think even those facilities are really rare, and they're only based in certain communities that have philanthropic monies behind them. Is that something that you're seeing as part of the problem, where the medical insurance companies, or maybe let me see what I can try to say. I guess what I'm saying is, in terms of infrastructure, are the insurance companies and the medical profession creating this problem by not investing in women and children's health care because they don't see it as a way to make money? Maybe Terry, I think she's nodding. I think she understands what I'm trying to say.
Yeah, maternal health, deliveries don't make money. Bottom line. I mean, healthcare is a business, and if this is a loss leader in my sort of structure, I'm not putting investment into it. I'm not really hyper concerned about it. I'm making decisions that may not be the best for the patient as a result of that. So for example, you can't really predict that the woman's going to have the baby on, this day. But the way the hospital is set up, like, they need to be able to kind of get you in, get that baby delivered, get you out. I need that bed back, right? So lots of C-sections, we can even see the point of which C-sections increased, right? That were unneeded, and some of those C-sections have caused death.
They're very invasive.
Yeah. So when we say the healthcare system, I look at that from, a capitalist perspective, that it doesn't make money. Medicaid or Medi-Cal in our state doesn't cover it effectively. So those are really like the system problems, right?
Thank you for that.
David, great presentation. I do have a question in terms of underserved areas, like licensee population. Was there any studies made on that to correlate, to eventually get the stats? I mean, they're remarkable in our eyes, and does any of that correlate to underserved areas? We have an expedited process for our applicants in that area, and so I just wanted to see if there were some studies made with that in mind.
So on the mortality side, it's such a it seems weird to say that it's such a rare event, but it is. It's the worst outcome you can have. It's so tragic, but in terms of just sheer numbers, we don't have numbers that permit us to look sort of below maybe a regional level. And if you do follow some of those links I provided, you can get some of our reports. But yeah, there is you can see regional differences, and I'm sure if you were to overlay, provider shortage data on that, I'm sure that there would be an association there. Morbidity, on the other hand, there are about more than 4,000 cases of severe maternal morbidity each year, and I know that the same would be true if you looked at underserved areas. You would see this. Part of it is you also have to think about not just the number or distribution of providers or facilities, but also how they're equipped, right? So they have to have certain assets in order to provide the right care for high-risk individuals. You don't want a high-risk pregnancy going to the local community hospital just because it's close by, or maybe, she was born there, so she's going to have her kid there, right? If she's high risk, that's not where she ought to be giving birth. So that's another consideration. And so you get at provider education, you get at patient education about where people should be delivering if they're high risk, right? So that factors into it too. But yeah, certainly. And again, I encourage you to look at some of our reports online, where some of this information I shared is in greater detail, including some of the geographic disparities and other things like that.
Thank you very much. It's a very nice presentation. Any comments from members of the public that are present? I believe we have one. And just please state your name. There's a little gray button on the base of the microphone. There you go.
Thank you. Denise Tugade with SEIU United Healthcare Workers West. We represent 100,000 allied healthcare workers across the Western region, and want to thank the board for making space for this really important, nuanced topic. We disproportionately are made up of, direct patient care providers. Disproportionately, that is women of color, and so they are not only, care providers, but they are people who have lived these traumas, and so they want to be part of the solution. And so we have a very active African American caucus with a subcommittee on maternal health care that is particularly active in these issues. And so you come here wanting to be a partner on the care team on these issues. We've been working closely with HCI on data as well, because we think that that is first and foremost one of the really critical first steps of how do we understand the problem. And so, to that point, we have been working with them to get facility level data on sepsis management, C-section birth rates, VBAC, vaginal birth after C-sections, time in the ED without being seen, and other really critical quality measures, and have that stratified by race, ethnicity, gender, and other, vulnerable population markers. And so, again, thank you so much for raising up this important topic, and a particular thank you to Board Member Pines for your work.
Agreed. Any members on the WebEx? Moderator? Members of the public?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment, please type comment using the field in the lower right-hand corner of the screen, or you may simply raise your hand. I do see some raised hands, so we'll start with Monique Himes. And Monique, you should be able to unmute yourself.
Hi, I just want to say, David, thank you for that presentation. It was really great. I am Monique Himes. I'm a volunteer with Consumer Watchdog. Malachi, my grandson, died tragically from medical negligence. Malachi died because his mother's clear-cut complications from preeclampsia were ignored. Malachi was forced to face a postmortem C-section. Had his mother been given basic treatment for preeclampsia, Malachi would be here today, excuse me, and we would have celebrated his 4th birthday. I'm completely offended that our public board member, Denise Pines, will bring the issue of Black maternal health to this board while she sat here and listened to us discuss how our baby of color is denied his right to an investigation. It is one thing to be the executive director of a documentary on Black maternal health, but it is another thing to bring that issue to this board when you know our baby's rights are being denied. How do you possibly think that anything can be done without the maternal health crisis in this state by denying dead babies' rights? Every woman deserves a beautiful birth story. I mean, every woman and baby deserves to survive their pregnancy and delivery of their baby. If a baby dies from negligence, then this board must treat that baby like the human being he was and grant him the investigation that you are required to conduct in the case of a death of a patient. We demand babies' rights from this board. Thank you.
Next, we have Maria Ibarra. You should be able to unmute yourself, Maria. And Maria Ibarra, your last name's cut off. You should be able to unmute yourself if you see a prompt. There you go.
There was a little delay. Thank you again for that presentation. That was really informative, something that we all know about already. I am Maria Ibarra Navarrete. I am from San Jose, a volunteer with Consumers Watchdog. I am a member of the volunteer team of advocates who works on regulatory board reform, maternal health issues, advocacy, and education about our medical negligence. As a member of a team, I support my fellow team members. I join my maternal health advocate colleagues by voicing my concern about a public board member discussing Black maternal health issues. When this board continues to ignore and close consumer complaints filed on behalf of the babies of color that have died or suffered egregious harm, we will not begin to address the maternal mortality and infant mortality crisis in this state. This board continues to ignore and close complaints filed on behalf of the babies, completely ignoring the special statute for minor children, where the statute for minor children does not begin until the child reaches the age of 18. I leave this board with one question. What would you do if this was your mother, sister, daughter, wife, or child, a victim of medical negligence? Thank you.
Our next comment is from Tracy Dominguez. Tracy, you should be able to unmute yourself.
Can you hear me?
Yes.
Okay. Well, David, that was a good presentation, but let me tell you, it's not there for Latina mothers. We don't get the resources that you offer. So that needs to be a change. That's when I started the Save a Mom, Save a Family Foundation in my community so that Latina mothers could get the resources they need because they're not available. So that needs to be looked into. And it is Latina Maternal Health Awareness Month. I have fought for it, and we are dying, and we have a lot dying in our community. But anyways, I'm very emotional because it's my daughter, Demi Dominguez, and my grandson, Malachi De Leon. I'm one of the persons that you guys are talking about in all those numbers. So this really made me very emotional to see this and to be left out as if she didn't matter because she was a Latina, a strong Latina, educated Latina, graduating from college a month before she started having symptoms and got ignored and had medical negligence and lost her life. But anyways, board member Denise Hines, as a public board member, we expect more from you. As a public board member, minimum you should is discuss the maternal health concerns of all women of color. As a public board member of California, you did nothing to address this maternal mortality crisis in our state. As a public board member on this board, all we want is equitable enforcement process. You have listened to our pleas for our babies of color that are being denied basic rights of an investigation of their death from a maternal death. But you say nothing. Where is your outrage for the babies that have died due to maternal negligence? Denise, you truly are not concerned about this issue. When will you demand an investigation into why babies who are dying to maternal negligence and are being denied these investigations of their own deaths? And why is this board denying babies the exception of statute of limitations to minor children? If you care about this issue, you would demand that our baby of color would not be considered a fetus. He was 5 pounds.
15 seconds.
Okay, I'm sorry. I'm very emotional. I'm sorry. But would be referred to as a beautiful baby who graced this earth for just a brief moment, who earned every right upon their birth. I am the mother of a daughter who lost her life. I live it every day. My family lives it every day.
I'm sorry.
Thank you.
Yes.
Thank you. I thank you.
All right, our next comment is from Michelle Montserrat Ramos. Michelle, you should be able to unmute yourself.
Good afternoon. I am Michelle Montserrat Ramos. David, I would like to thank you for your presentation. Board Member Pines, although I am pleased that you did link this issue of maternal mortality to physicians as well, where is your leadership role on this board surrounding this issue? Where was your leadership role with the NBC when my friend Charles Johnson approached the medical board when his wife Kira died, and her accusation was not just for her, but included harm to 5 women? I am concerned that a public board member is bringing a presentation on maternal health to this board without taking leadership on this issue. When you know that this board is closing complaints for babies of color, denying them a right to an investigation, and also denying them the right to the exception to the statute of limitations for minor children. You are all aware of this because these parents and grandparents have been reporting this issue to this board for the past year and a half. These mothers and babies have not been valued. Their lives and deaths are of no value. It is no secret. We will never begin to curb the maternal mortality crisis in this state until you investigate all maternal deaths, which include infant deaths due to maternal negligence. All these maternal deaths and serious bodily injury complaints that the families have commented on to this board are all linked to maternal negligence. And all of the mothers and babies that have died or have suffered lifelong harm are people of color. I agree with the families that this board must call for an investigation into why board staff is closing these cases without investigation and not following Business and Professions 2230.5D, the exception of minor children guideline, and Public Board Member Pines should be the board member that takes leadership of this issue and calls for this investigation. Really, any of you should call for an investigation into this issue. This is a matter of public safety to the highest degree for all California families. Thank you.
And we have a comment from Xavier De Leon. Xavier, you should be able to unmute yourself. And you're unmuted.
Okay, perfect. My name is Xavier De Leon. I'm from Bakersfield and a volunteer with Consumer Watchdog. And just like everybody before me has said, I really can't believe that Denise Pines would choose to insult us parents by bringing the issue of Black maternal health to this board, when she is choosing to sit by and watch us fight for the rights of our babies who were lost to maternal negligence. She sat there and said nothing when we explained how our babies were denied the right to an investigation and also denied the right to the exception to the statute of limitations for minor children. Denise, you have not only sat on this board in silence, not once speaking up, asking for an investigation into why babies' deaths for maternal negligence are being denied an investigation. You also sat on the medical board when my friend Charles Johnson's wife, Kira's doctor complaint, which included the death and harm of 5 women, was given, and he was only given probation. We expect more from you on this board, especially from our public board members. Ms. Pines, we are calling on you to demand an investigation into the complaints of babies of color. We really are questioning why these complaints are not going into investigation and why these babies of color are being denied the exception of the statute of limitations for minor children. Thank you.
All right, this is moderator. I see no further requests for comment. Shall I close the Q&A panel?
Yes, please. Thank you.
You're welcome.
All right, we'll move on to item number 18 on the agenda, which is future agenda items and future meeting dates. Machiko, you want to go over the dates that we've talked about? Obviously, we have to add, we'll do a survey and see what date works for June, I think.
We do. Currently, we have 2 dates on the calendar. August 17th, down in Southern California at Western University, and December 7th here in Sacramento. And then we have nothing lined up for 2024 as of right now.
Okay.
So we can start off with January. If we want to stick with Thursdays, the 4th, 11th, 18th, and 25th are all Thursdays in January.
And I'd say 18th to 25th from my perspective, but whatever you guys. The second half of January.
Second half of January. 18th?
18th, okay.
Going once, going twice.
18 works for me as well.
18th?
18th or the
Is that
25th.
around, is that close to
Oh.
for Federation?
Yeah, I was just thinking, is that close to the Martin Luther King holiday timeframe?
Oh.
What is holiday? Let's see.
The
Tuesday on the Monday.
15th, right? No.
It'll be after that then.
So then the 25th?
Well, no, which day is Martin Luther King?
I think it's the
Junior
15th. I
holiday.
could be wrong.
It's the 15th.
It's the
15th?
15th. I'm like, I have it on my calendar as the 15th, but
Do you
I
want
could
to
be
do
wrong.
it the following week or that same week?
So it's the 15th, and the date,
Well, it's,
we're
yeah,
talking about
Thursday.
the holiday
okay,
is the
so
15th.
I think we're fine. I think the 18th
Okay, so
would be
18th.
fine.
Did you have something, Erica?
The 18th is a Friday. Just want to clarify that. So
It's a Thursday.
17th, are we looking at the
Thursday.
17th?
No.
It's a Thursday. It's a Thursday.
We're in 2024.
I'm sorry. Looking at the wrong year. Sorry, Dr. Bahar.
That's okay.
And this is in Sacramento?
Yes. So January 18th, Sacramento. And then if we want to put May on the calendar, unless we want to go April, do we want it April or May for legislative purposes?
Does April tend to be better for that, Terry?
May.
May?
Okay. So,
Okay. Okay.
so we have 4 Thursdays in May, May 2nd, 9th, 16th, 23rd, or the 30th.
16th is good for me, but I'm open.
You said it will or will not work for you, Gore.
It would work for me. The 16th
It
would
would.
work, but I'm open as well for other days.
16th is fine with me, too. May 16th, 2024?
May 16th.
Objections? No?
Would we like to, maybe we can reach out to Toro and
Yeah.
see if they can host.
Sure.
We'll reach out to the osteopathic universities that are local and see
Yeah.
what works best for their students for outreach purposes.
I think that's a good idea.
What city?
Either Mare Island or Toro or, what is it, Bakersfield? No.
There's one in Modesto.
Modesto, right?
Modesto or
Clovis.
yeah.
Clovis
Yeah.
community, yeah.
So I'll reach out to the 3 universities and see what their schedules look like. So we'll do a tentative location, but scheduled for the 16th. How's that work?
Sounds good.
Is May exam time for any of those schools?
That is why I'm placing a tentative location, but we're scheduling it for the 16th. Regardless of where it is, it's going to be the 16th.
Yeah.
It's just based off of what information I receive back. Do we want one more, or do we want to stick with the 2?
Why don't we keep it at that? So that's 4. We're staying 4 ahead right now.
Yeah. Okay.
Yep.
All right.
Any additional items for the agenda? New business that we want?
Yeah, I'd like to add something for the agenda. I'd like to have the staff look at the other osteopathic boards in terms of how many staff they have and salaries that they have for the positions that they have on staff. And then the other thing I'd like to add is looking at this board doing a Hill Day where board members go and meet with our legislators.
And this is Claudia. I won't be here, but I think I can still add things to the agenda. But, you know, some of the comments that the public brought up and that I'm also interested in learning more about, and I could probably attend the meetings as a public or a member of the public then. But there's a lot of talk about the statute of limitations for minor children, and I'm not really sure how that works or what was being implied in terms of how our board takes in cases in our review, if it is a death of children. So I just wanted to have the board address some of the concerns that the public brought to the table today, if possible, with their expertise.
Thank you, Claudia. I believe at our January board meeting, I mentioned that we were going to be reaching out to the Attorney General's office to provide a more in-depth presentation on their specific role. The last board meeting, we had a presentation on the enforcement process, but now we are catering the idea of talking to the Attorney General's office to just give us a more in-depth presentation on just the role of the Attorney General's office, which will then cover the statute of limitations and all of the exemptions that we have. So possibly at our August or upcoming, yeah.
Okay.
But what about June, setting a June teleconference meeting? You want to do that now?
Do you want to set that now, or do you guys want to do a Survey Monkey thing?
We can do it.
I think we can do a Survey Monkey on that and come back. Yeah.
Okay. Yeah. I know the first week of June will be out for me anyways. All right. Well, so you guys will be receiving a survey as to when a good date in June for a teleconference to go over pending legislation, so we can take a stance on some of those items. And with that, we'll move on to agenda. Oh, any comment from members of the public that are here? I see none. Moderator?
I would just like to invite you again next year if you can come and just keep the conversation going. I know you have a relationship, but if you can just keep us informed, we really appreciate it. That's all. Thank you.
Any moderator, any members of the public on WebEx wish to comment on future agenda items and meeting dates?
Thank you, Mr. Board President. I've opened up the Q&A panel. If any member of the public would like to comment on future agenda items or future meeting dates, please type comment using the field in the lower right-hand corner of your screen, or simply raise your hand. We'll give you a moment. All right, I see no requests for comment. Shall I close the Q&A panel?
Yes, please. Thank you.
You're welcome.
All right, item number 19, meeting is adjourned.